gets extra.
Correct.
Now, in the last statement, my name and Mr. Das's name is removed.
Achha, they increase here.
And for the other 800%, 2 rupees, 5
So
rupees.
after disbursement, they
Yes,
have correct.
after, and that last statement goes to audit.
Correct.
So he can't be found out. It's a,
So I remember one case I have dealt with. I was in the Portland Municipal Council. So there was a IT personnel. Initial days, initially the payment was after receipt the payment. So thereafter the audit section prepared the list amount this Excel sheet.
yes.
Suppose 25,000, 30,000, or 12,000, whatever the remuneration. What the IT person has done, he has prepared another Excel sheet giving the that 5 rupees, 50 rupees, 200 rupees extra
To each person.
to each person, and that amount has been taken out in his account.
Oh, when the final disbursement is done, they are getting the right figure and the extra is
They have
coming
taken
out.
in the fine is in his account. Subsequently, when the audit was found, it was where it has gone.
This person is even cleverer. That's why he remanipulated the last statement. So 3 years audit didn't find him. Now, my lord, we after this was two internal auditor did it, then discovered everything. That report is here. Then independent auditor was engaged. He also did it. Same report came. Then, my lord, we filed criminal proceedings. 3, 4 defendants in jail. Now they've got bail. Police investigated and discovered that this money was distributed by 2, 3, and 4. Part of it went to 5. And, my lord, they've bought 2 immovable properties. They bought
This
some
2, 3, 4, 5, they are not the employees.
not employees at all.
Or 6, 6 also.
Yes, 6 is the wife of 3.
Defendant number 2 and the daughter of defendant number 3.
Yes, this wife of defendant number 2, daughter of defendant number 3. No employee. After 1, my lord, nobody is an employee. So, my lord, criminal proceedings, police, my lord, discovered they've bought, my lord, 2 properties and they've bought a lot of gold. And there is also money, my lord, somewhere. So, my lord, the properties I want to, my lord,
So the
injunct.
amount which has been disbursed in the account of this 2, 3, 5, and 6,
Yes.
so whether the police has not freeze that account during the investigation,
Police has freeze that account.
freezed, whether the amount is available in that account.
No, no. They've transferred. That's not. We've given particulars. A lot of money has gone out, and 2 properties and gold. Gold, my lord, is untraceable. Those 2 properties, my lord, I want to injunct. Lord, may I just show your lordship the documents? The first statement, my lord, is at page 19. This is
19
what?
of application. See, give the G. Yes, it is parent is not admitted.
I'm sorry, my lord. I will. My lord,
Okay.
registered office within jurisdiction, fraud within. I'll show your lordship, my lord.
Page 19.
19. This is, my lord, what the branch head this is the this is one's physical statement submitted to the branch head. Kindly see, my lord. So one person, name C Bharati, address Madurai or something. So this is Madurai, such and such. This is then, my lord, kindly see number 6, Madurai to Sivakasi. And distance is 150, fare is 413 rupees, daily allowance is this. And this is how it's submitted by each medical representative to each branch head. And along with this, my lord, are the supporting documents. Your lordship will kindly come to the next page, 20. So along with this, so this is one physical statement submitted by one person along with all, my lord, physical documents, Xerox, etc., etc. Now, each medical representative twice a month submits a document like this. Then, my lord, is page 24. Now, the branch head, by an email to the defendant number 1, please, my lord, see page 24. This is EIPWL Varanasi branch to Niladri Bhattacharya, who's the defendant number 1. Please find the attachments travel expense bill for the month of July 2021 of medical representative, and TMR must be temporary medical representative. So each month this is sent by, this is the mail sent by Milord Madurai branch. Twice a month it's sent. Though these Milord at page 25 are the 8 medical representatives, the beneficiary account number, their address. This is medical representative's own bank details. So now when page 24 and 25 is received, 26 also, it's received, then defendant number 1 makes Milord page 63, where he includes the name. Relax. So Milord, he makes page 63. This is in the company's.
So after that.
Yes, this is in the company's system. It's in Excel form. Now, my lord, we've given one statement where your lordship will please, my lord, note 1, 10, 20, and 30 are, my lord, on the first page are, my lord, incorrect entry. Devashish Mistries. Different Devashish Mistries, different number 2. So, my lord, all 1, 10, 20, 30, then 40, 44, 51, 61, 71.
Yes.
Likewise, my lord, this is how he has done it. So this outsider's name comes into, my lord, our statement. In our, my lord, system. Now, my lord, please see 73. At page 74, my lord, this is the second step at the head office, the replication. This is what we call, my lord, the bank voucher statement. Your lordship would see it's ultimately signed by 2 authorized representatives at the bottom. So the same Excel sheet is replicated in the bank voucher statement, and prior to these, my lord, signatures, the earlier page is compared with this. So, my lord, he goes through. Then
74 is compared with 63 and
yes,
also.
yes. Then after that, my lord, kindly see, my lord, page 79. Now this is, my lord, 73 is sent to, in physical form, sent to the bank, disbursements are made. Then what we call the bank voucher is created. That's, my lord, 79. Here, my lord, he removes
The name.
the names and he increases the amount. My lord, let me show your lordship, my lord, one such entry. My lord, please see page 79, entry number 16. This is Partho Pratim Bhattacharya. It's, my lord, 15,709 at page 79. First entry, my lord.
Yes.
Partho Pratim Bhattacharya, 15,709.
Yes.
And, my lord, please now come to page 74. Second entry.
Yes.
Partho Pratim Bhattacharya, 11,709. So,
added 4,000.
yes. So, in these two, my lord, it's shown less, and again it's, my lord, increased in to cover that 4,000 which is taken off here. So this is whole, every one of them is inflated like this, 90% of these entries.
Yes.
Now when this happens, my lord, yes, yes, he's right, my lord, I must show this. My lord, please see 78 once, my lord. The total will, my lord, tally. That I should show. My lord, page 78, please see the final amount, 1811099. And please see page 85. Same amount, my lord. So, my lord, he's tallied the total. Nobody gets caught. Page 86, my lord, onward is a list of amounts received by the defendants during this entire period. 86, 87. This is the total amount received. Comes to, my lord, 3.59 crores. Now, my lord, this when we were suspicious, at page 606, my lord, in volume 5, is the auditor's report.
Six 606.
Yes, my lord, 606. This is the auditor's report starting. And my lord, I won't show your lordship the whole thing. My lord, please come to 634. Note 25. 634, my lord. Starts at 606. This is, my lord, APS Associates Chartered Accountants Independent Auditors Report
Yes.
to the shareholders. And, my lord, 634 is the conclusion. Note 25.
Yes.
My lord, this is a summary of almost everything. During the financial year 2023-24, a misappropriation of fund by one of the employees was detected by the management. On the basis of initial findings, an FIR was lodged with Shakespeare Sharoni Police Station. The accused named in the FIR have been arrested and are currently on conditional bail. The matter is sub judice before the learned Chief Metropolitan Magistrate, Bankshal Court, Kolkata. An independent firm of chartered accountants assigned to conduct investigation, including review of relevant records, documents, and control aspect relating thereto, have submitted their report on 14th August 24. From the initial findings and investigation report, it has been found that the alleged misappropriation of funds took place across 3 financial years, such and such 2021 to 24. Amounts misappropriated for the years were 22 lakhs, 1.23 crores, and 2.13 crores, aggregating to 3.59 crores. So, my lord, every year it kept increasing substantially. Next page, my lord. So, earlier entries have to be reversed. Now, my lord, please look at page 639, which is the interim fraud examination report by another chartered accountant, which is referred to in the statutory auditor's report.
Yes.
Here, we kindly see the background. On 19 December 23, we received an appointment letter as independent consultant of the company regarding examination of fraud of rupees 340.45 lakhs in respect of travelling expenses. We received an email on 26 June regarding enhancement of fraud amount. We came to know total fraud regarding this case was 359.57 lakhs. Then, my lord, the whole thing is mentioned from, my lord, page 640. And the procedure is mentioned in paragraph 6, and involvement of the perpetrator. I'm reading 7. Mr. Niladri Bhattacharjee, appointment as a peon cum packer of East India Pharmaceutical Works. Subsequently was promoted grade 9, etc. Being a senior clerk, he found out the weakness of the payment system of the travel expense bill, used the lacuna for personal financial gain, falsely entered the following person details for siphoned out the funds. In this matter, in our opinion, accounts finance department are not able to minimize the gap, and we got the 4 different numbers 2 to 5. And findings of the auditor, my lord, under 8. And this goes on, the whole thing is explained. And please, my lord, see the summary at 645, paragraph 10, 1. This is, my lord, an excellent summary of the whole thing. The branch office forwarded Excel PDF sheets of T bills to the head office every fortnight through official mail. Company has not authorized any person receive the mail. Perpetration of T sheet before payment, making vouchers, reconcile the same with vouchers. Person such and such, Shubroto Rai, ex-CFO, retired, he was appointed financial advisor, have signed payment sheet without proper checking. And now, my lord, please come to page 648, which is the FIR. And my lord, the complaint, my lord, is at 652, which says essentially the same thing. At 653, kindly see, my lord, 653. After receiving the physical bills at the head office,
Yes.
the bill entries were entered into the company's system by a clerk, that's affair number 1, working under our organization for 15 years. Then, my lord, how, my lord, he was connected. Then, I'm sorry, my lord, I'll just omit one sentence and read on. His father, late such and such, a erstwhile employee, as well as his wife, Priyanka Vishwas Bhattacharya, who also works in our head office. Thereafter, Mr. Bhattacharya used to prepare bank vouchers based on the data entered by him, which would then be reconciled by a supervisor. And after the check, the vouchers used to get signed by the officers having requisite authority, the Chief Finance Officer Somnath Rai, such and such, financial managers Shondeep Deb and Biplab Bhomik, such and such,
Yes.
have authority to sign vouchers for payment. The system of internal checks and controls was not followed efficiently for various reasons, which are now being investigated. Then, Niladri Bhattacharya, being a senior and experienced clerical staff, was fully aware of this lacuna and took advantage of this with an ulterior motive for personal financial gain. He falsely entered many fictitious TE bills and siphoned out money. Money siphoned out was deposited to 3 bank accounts by name of Devashish Mistry, Shambhu Kishore Chaudhary, and Shonjeev Das. These people are neither medical representatives nor employees of the company. Details have been inserted in the final list by Mr. Bhattacharya. It came to our knowledge in November 23 when the CFO had found that the bill for October 23 was abnormally high. Upon preliminary inquiry, it was found that there was siphoning of funds of rupees 3.26 crores, etc. And now, my lord, just the last thing I want to show your lordship, that is, using this, they have purchased properties. My lord, please come to page 655. This, I think, is the police. The police's application, the SI, my lord, Kaushik Shaha, signs it at page 660. Now, my lord, I just want to show your lordship. Please come to, my lord, page 656. At the top, my lord, second paragraph, after interrogating the accused in custody and in continuance of, it was revealed that the accused had purchased many gold ornaments from the proceeds of crime. And to unearth the truth, notices under 160 was served upon Lokhi Jewelers and Pinaki Construction, from whom the accused had purchased an immovable property. Then, Lord, please omit 2 paragraphs. After that, on 24th November, in due compliance, proprietor of Pinaki Construction, such and such Mistry, came to the PS, produced certified copy of sale deed for purchase of immovable property. Then, my lord, there is another My lord, page 657, paragraph 5. There is another property, my lord, which is mentioned. And this Pinaki construction is also mentioned, my lord, at page 658. Sum and substance, my lord, two properties, and my lord, some gold jewelry. Gold jewelry couldn't be, my lord, traced. And I have annexed all, my lord, records of criminal proceeding.
Yes. What is the prayer?
Prayer, my lord, is to restrain sale of all their assets and properties, which would include these two properties. Bank account anyway is frozen. Why do you have to? And kindly give me leave, my lord, to approach your lordship in the event the bank account is defrozen by the investigating agency. That's not likely to happen. So bank account is already frozen. So I don't need an injunction today.
Where is the frozen notice here?
I'm sorry, my lord.
Frozen notice there.
Frozen order is here. No, that's not annexed here. But I'm not pressing that because I know it's frozen.
Okay.
I'm just the two property, my lord, properties. Paragraph 21, my lord.
Landed property.
Yes, which has been purchased with the proceeds of crime. And this, my lord, I have come to learn from the police.
Yes. Who is appearing? Anybody appearing?
My lord, I beg to appear on behalf of the defendant number 125, 1, 2, 3, 4, 6. Now, my lord, I understand the cause of action allegedly arose in 2023. Criminal matter is pending. My lord, I beg before your lordship, my lord, only for 3 days time. I received the brief, my lord. I truly, candidly speaking, I could not read the brief. I could not sit with the client. Only 3 days time. They have been suffering for 1.5 years. Only 3 days. Kindly allow me to come back.
Let with regard to the property, let them.
My lord, it's a case of fraud.
Correct.
It's not that disbursement of loan and I have to repay it. My lord, kindly bear me with for 3 days only.
Lord, I am pressing for the first part of prayer C.
Kindly take up the matter only on Thursday. I'll come back.
Till Thursday, my lord, kindly protect me with the first part of
They
prayer
are not
C.
protected and they remained unprotected for 1.5 years.
No, that's correct. That's correct. Now
No,
it has come to the court. It is prima facie whatever the document subject to your submission with what is your defense. So, no problem with regard to this property. No, I am only giving the interim till Thursday, not to.
My lord, is aware that once an interim order is passed, my lord, then.
So because as per the report of the police, this property has been.
It's a third-party report. My lord is
No,
much more
report,
experienced.
whatever it may be, it
My lord,
is.
it's a third-party report. Case of fraud and cause of action 2023. My lord, I consciously do not make any submission today. My lord, it might turn wrong. My lord, that is why I beg before your lordship. My lord, kindly allow me to come back on Thursday. To Wednesday, I am not here. Kindly allow me to come back on Thursday.
Correct, no problem.
My lord, once an interim order is passed, your lordship is aware that then things get diluted. My lord, the order gets extended. They remained unprotected for 1.5 years.
But you keep it in mind. If on Thursday, if this court will get any report that you have transfer or any alienated this two properties,
if I cannot satisfy your lordship, certainly order will.
Then it will be difficult for you.
My lord, I have suffered.
Correct.
I have suffered personally after doing exactly what my learned friend had done. Lordship recalls where I came and made a statement. Please don't pass an order. I'll come back tomorrow.
Correct.
And my clients had, without telling me, already Millard signed and put it into the registry office. They were just trying to buy time so that the
But here, my advocate on record have done a smart work. She has taken a declaration internally from the client.
Very good. I congratulate you, but Millard, please, first part of Annexure C, these what the police say has been bought with proceeds of crime. Kindly restrain them till Millard.
Till Thursday, kindly do not pass any order.
No, this is very risky.
This two property, I am
very risky.
Till Thursday. Till Thursday, I am restrained.
My lord, your lordship is aware that once an interim order is passed, and today, my lord, candidly speaking, I am not in a position to make any submission that might turn wrong, and that is why I consciously do not.
Tomorrow, otherwise,
it will not be possible.
So,
My lord, wait, 700
This
pages
is very
petition,
risky. They are criminals.
700.
correct.
Very well, come back. I'll come back
Come
tomorrow.
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 There is no problem. Come tomorrow.
Very well.
No.
Milord,
Advocate?
Milord, order to rule to leave, and registered office is here, so fraud is here.
Leave
Or not.
cannot be granted. Senior counsel.
Which is why I thought I
You raise objection. And full list of counsel for the record. So appearing for the plaintiff. So appearing for the defendant number 1, 2, 1, 2.
1, 2, 3, 4, 6.
1, 2, 3, 4, 6.
Property group
And
and
so appearing for the defendant number 5. Full counsel for the plaintiff has concluded his argument with regard to the grant of ad interim injunction, but the counsel for the defendants prays for a day's time. Accordingly, for the interest of justice, the case is adjourned. Let the matter appear tomorrow at
I'm ready.
10:30. At 10:30.
Tomorrow 10:30.
grateful, Milord.
Mukherjee.
Grateful.
Appear for the respondent.
Commercial division, item 1, judgment. You for the respondent,
New metallic.
I'm for the respondent.
For the respondent.
Yes,
New metal.
yes, I'm Orissa Metallics. You are for whom?
Yes,
For the what date?
AP dismissed. AP dismissed.
Great, great.
Next.
Item 2 was fixed today, my lord, for filing of written notes. My lord, we've concluded our submissions. My lord, our notes are ready, my lord.
My lord, I pray, my lord, 7 days time for filing, my lord, the
Notes.
notes, my lord.
My lord, this is that, again, stands changing from suit to suit. Ordinary division, they take one stand. In the commercial division, they take another.
One.
That matter.
So appearing for the plaintiff. So appearing for the defendant. The matter is fixed today for filing written notes of argument by the learned counsel for the respective parties. Full stop. Counsel for the plaintiff has filed written notes of
Mal-
argument.
Copy.
Let the same be kept.
My
to
lord,
the
no
record.
copy, my lord.
give
It's
us.
for
Give
the
us copy.
honorable. My lord, they haven't filed their notes. On that day, I'll hand over.
Okay, when you file, then you
Yes, yes,
exchange.
my lord.
Counsel
Obliged.
for the defendant prays for a week time to file affidavit, file written notes of argument. Considering the submission made by the counsel for the defendant, time to file written notes of argument extended till today we are on 6th, no? Till 14th of January 2020. Let
Obliged.
the matter appear on 14th January under the same heading for filing written notes of argument by the defendant.
Obliged.
Please, your lordship.
Yes.
My lord, the goods sold and delivered, amount not paid. That's the main matter, my lord. I'm praying for leave under order to rule 2. Because, my lord, they have taken a stand in the matter that, my lord, the goods which were with them, my lord, has been returned to us. Now, my lord, we do not know how that goods has been dealt with, whether it's been sold to some other party, and what kind of complaints may come out, my lord, originating from this cause of action. So I've prayed for, my lord, leave under order to rule 2.
The commercial matter.
It's a commercial matter, my lord. The threshold is crossed, my lord. That's paragraph 21 at page 13. It's 81,96,000. And, my lord, it's within limitation. That's paragraph 24, October 5, 2023, my lord.
Okay. How it is a commercial
My lord,
work order?
it's, my lord, against purchase orders. My lord.
Purchase order?
Against purchase orders. In paragraph 19, we have explained that at page 12. Mediation failed, my lord. Mediation starter failure report is also annexed. That's 18th August 2023, my lord.
Yes. So appearing for the plaintiff. The plaintiff has filed the present suit for a decree of sum of rupees 81,96,313 along with interest at the rate of 18% per annum. Full stop. Counsel for the plaintiff prays for leave under order to rule 2 of the CPC on the ground that the plaintiff is not in a position to ascertain the exact loss which the plaintiff faced due to the act and action of the defendants. Consider the submission made by the counsel for the plaintiff, peruse the pleadings, leave under order 2 rule 2 of the CPC is granted. Full stop. Plaintiff is admitted subject to scrutiny.
Very deeply obliged.
I am for the plaintiff, my lord.
Yes.
So money claim, my lord. And on the earlier occasion, my lord, the money claim arises out of supply of goods. High-speed diesel was supplied, and thereafter, along with the price, they were supposed to pay the differential tax. Now, they did not submit the C form. No,
Did not submit the
C form.
C form. Yes.
So now the claim is in respect of the differential tax. We have paid in favor of the commercial tax authorities. The suit is for recovery of that amount, my lord. And on the earlier
The
occasion,
difference of the taxes
Yes,
which you have paid, which the defendant
yes,
is liable
yes,
to pay.
yes, yes, my lord.
And due to save the tax, you have paid that
Yes, my
on behalf of the defendant. Now you wanted to recover
My-
that.
On the earlier occasion, the suit was filed without complying with the section 12, my lord, 12A. So accordingly, that was returned. My lord, kindly see page 56,
Yes,
the earlier order. It was returned. Thereafter, we applied before the mediation. Now the failure report is at page 59.
Okay.
I'm seeking clause 12 leave because
Why clause 12?
some of the correspondences were exchanged from the office of the plaintiff at Shambhalpur, which is outside. I have explained at para 29, which are inside and which are outside. Para 29 at page 14.
So appearing for the plaintiff. The plaintiff has filed the present suit for a decree of sum of rupees 10,54,071.14 paisa, along with interest at the rate of 12% per annum. Full stop. Counsel for the plaintiff praised for leave under clause 12 of the latest patent 1865. Full stop. Counsel for the plaintiff submit that part cause of action arose within the jurisdiction of this court and part cause of action arose within the outside of jurisdiction of this court. Consider the submission made by the counsel for the plaintiff, peruse the pleading. Full stop. Leave under clause 12 of the latest patent is granted. Plaintiff is admitted subject to scrutiny by the judge.
Grateful.
Yes.
Your Lordship, here for the plaintiff, Your Lordship. This suit,
12A, why 12A?
Your Lordship, is a transferred suit. Your Lordship was filed in the commercial, non-commercial division in the initial, Your Lordship, but thereafter, by the order of Justice Showman's division bench, we have been granted the leave to transfer the suit to the commercial division, Your Lordship.
Where is that order?
Volume 2. Your Lordship, Annexure Q, page 247, volume 2.
Yes.
Your Lordship, the leave has been prayed for at paragraph 36, Your Lordship.
Paragraph?
36, Your Lordship.
on a clause 12 leave because this has happened outside this opinion. So
the clause 12 leave, your lordship, has been taken because part of the cause of action has arisen within the jurisdiction, lordship, and the part of the cause of action has arisen outside the jurisdiction of your lordship. And the same has been pleaded in paragraph 36 of the plaintiff, lordship.
Where is the urgency of it? 12A.
Lordship, paragraph 43 of the plaintiff, lordship. Leave under section 12A has been prayed.
Yes.
Your lordship, the leave under order 2 rule 2 has also been prayed for in paragraph 35, your lordship. Pleaded in paragraph 35, your lordship. Because there are few machineries and other the damages which cannot be quantified as of now, your lordship.
Yes.
My lordship, there's a leave for deficient court fee as well. This has been pleaded in
Leave for court fee.
paragraph 45.
Division bench already granted leave to utilize the court fee in this.
Yes, your
one
lordship.
leave, my lord. I believe, my lord, there is some problem with regard to getting back the court fee, my lord. We have taken out a fresh court fee, my lord. It's already with us. It's the old one. My lord will kindly give us leave to put in through the receiver, my lord. Mr. Banerjee will be the receiver, my lord.
Yes.
It's already here, my lord. So any leaves, my lord. All leaves as possible.
Order 1 rule 2.
Not as yet.
So and so appearing for the plaintiff. Police, the plaintiff has filed the present suit, praying for a decree for a sum of rupees 16, 51, 85, 702, along with interest and connected prayers. Police, counsel for the plaintiff prays for leave under order 2 rule 2 of the CPC, clause 12 of the latest patent 1865 and section 12A of the Commercial Code Act. Counsel for the plaintiff submit that due to the wrongful and illegal act of the defendants, plaintiff has suffered loss and injury, and as such, though the loss and injury, though the plaintiff has filed the suit for recovery of the said amount, but the plaintiff apprehend that the amount may further increase in future, and as such, leave under order 2 rule 2 of the CPC is required. The counsel for the plaintiff further submit that part cause of action arose within the jurisdiction of this court and part cause of action outside the jurisdiction of this court. Thus, he prayed for leave under clause 12 of the latest patent. As regards section 12 of 12 capital A of the Commercial Code Act, counsel for the plaintiff submit that the defendant submit that initially the plaintiff has filed the suit in the non-commercial division. Subsequently, non-commercial division. Now, in terms of the order passed by the Honorable Division Bench, the plaintiff has filed the present suit before this court, and the claim of the plaintiff is aware by the defendant, and there is every apprehension that the defendant will alienate the assets if the plaintiff will go for the mediation in the meantime. Counsel for the plaintiff submitted there is an urgency to move the present suit without initiation of pre-mediation process. Had the learned counsel for the plaintiff peruse the pleadings, leave under order 2 rule 2 of the CPC, clause 12 of the latest patent and section 12A of the Commercial Code Act is granted. The plaintiff is admitted, subject to scrutiny by the department. The counsel for the plaintiff submitted in terms of the order passed by the Honorable Appellate Court, the department has refunded the court fee, and he will deposit the court fee in the department within 1 week. Within 1 week from date. In view of the submission made by the counsel for the plaintiff, the plaintiff is granted leave to deposit the court fee in the department within a week from date.
Through Mr. Banerjee.
Through the learned receiver, Mr. Banerjee.
I'm very good.
Grateful, Your Lordship.
Thank you. Next.
Item 6, Your Lordship, I am for the plaintiff.
वहाँ से जाएगा डिपार्टमेंट से यहाँ तो लिया नहीं ना वहाँ फाइल करें. Yes,
Lordship, this is a suit for recovery of money.
Yes.
Lordship, the goods sold and delivered, Your Lordship, but money here, Your Lordship, has not been paid in entirety. Lordship, we have gone, Your Lordship, for the pre-instituted mediation, and the non-starter certificate has been issued. That is at page 190, volume 2. The defendant, Your Lordship, is within, but Your Lordship, the goods have been delivered, Your Lordship, to Jharkhand. So, Your Lordship, the part cause of action is outside. So that's why, Your Lordship, I have, Your Lordship, sought for, Your Lordship, the leave under clause 12 of the latest patent.
So and so appearing for the plaintiff. Plaintiff has filed the suit appearing for a decree for a sum of rupees 1,26,57,230 along with interest at the rate of 24% per annum. Counsel for the plaintiff submitted. The plaintiff has already initiated pre-mediation process and non-starter report has been filed, but has prayed for leave under clause 12 of the latest patent on the ground that part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. Consider the submission made by the counsel for the plaintiff for use the pleadings. Leave under clause 12 of the latest patent is granted. Plaintiff is admitted, subject to scrutiny by the department.
I'm great.
Next.
Number 7.
So my plaint, Willard, it's a transferred proceeding from Lanet City Civil Court before this honorable court. What
Perhaps
happened,
not
Willard?
a transferred proceeding.
My Lanet friend doesn't have a right of audience right now because plaint is not presented and I have not filed it for he cannot have our audience right.
Well, the
Anyway,
division bench has granted that direction, Willard.
that
Lordship will
kindly,
kindly see
may I place my case, Willard?
the order of
It was originally filed, Willard, before the honorable
December
Lanet City Civil
16th.
Court. The Lanet City Civil, the defendant had entered appearance, filed the written statement and
Well,
filed
the
an
third page
application
I
for
marked it.
transfer of that suit before this court. It was an application under order 711 on the ground of jurisdiction. That was allowed. Challenging that order, we preferred an appeal for this court, division bench. Now in division bench, we took the point that while
Order 7 Rule 11 was allowed.
On
on
jurisdiction, yes, on jurisdiction it was allowed and a suit was transferred before this court. We filed an appeal, being plaintiff filed an appeal for this court on the ground that at the time of transfer of proceedings or allowing that application, the procedures under order 7 rule 10 was not followed by the court below. On that ground, we preferred the appeal. Now, appeal court at that point of time heard both the parties and directed me, the plaintiff, to file an application under order 7 rule 10b before appeal court. And in terms of that, Millard, this yes, for taking the plaint and filing it here. And in terms thereof, the last order of the appeal court was passed.
Yes.
Lordship kindly comes to, I have annexed the last order in my plaint with the leave of the appeal court, page 40. Two orders passed by appeal court, page 36 and page 40 of my plaint. Kindly see, those are annexed with the plaint. Page 36 is the first order by which appeal court, Lordship kindly comes to.
Page 40.
Page 36 is the first order of appeal court.
That is leave granted to you.
Yes, leave granted to file the application.
Correct.
In terms of that, I filed the application and then the next order, page 40.
Correct.
By this order, the application was allowed. Kindly scan number 2. I am reading the fourth paragraph. I sought the leave to incorporate some formal pleadings in the plaint. Keeping in view of the above submissions, we grant the liberty to the appellant, the plaintiff, to incorporate the necessary consequent additional paragraphs in the plaint and to alter the court fees accordingly in the plaint which is now to be filed before the appropriate court. He further made clear that the learned court where the plaint shall now be presented shall not be swayed on merits by the observations of this court regarding section 14 of the Limitation Act, and the said findings are returned only for the purpose of enabling plaintiff to invoke the benefit. I am not reading this part. This is section 14. If my learned friend takes the point of limitation, only then this becomes relevant. Right now, he cannot, because he has no right of audience right today. Since the appeal has already been disposed of by the order dated 16 December, this said order is deemed to be made absolute. Can 2 is also disposed of accordingly in light of the above order. Needless to say, since no evidence, I am removing this part. So, my lord, in terms of this, I made 3 consequential additional paragraphs in the plaint. On 24th of December, my learned junior was before your lordship. When the plaint was presented, with your lordship's leave, a formal correction was made in the plaint and the plaint was filed. But it's a transfer proceeding under section 15, read with order 7 rule 10. The provisions will be applicable. It's a commercial suit according to the view of my learned friend. They filed the application and took this point. Appeal court also observed it's a commercial suit. City's jurisdiction is within the jurisdiction of the cause of action has arisen within the jurisdiction of this court. The parties are also within the jurisdiction. In fact, the defendant is within the jurisdiction.
What is the prayer now?
But money suit, the suit for recovery of money.
So what is the prayer?
But I am presenting the plaint because the division bench, my lord, in paragraph page 36, lordship would find that. Page 36, my lord, that order. Kindly come to paragraph 11, page 38.
Dispose of modifying the impugned order.
But page
Filing
38.
the formal application before this court, so that is over. Under them, before the appropriate. This
Paragraph 11. Accordingly.
That is the commerce.
Yes.
Accordingly, affirmative is disposed of by modifying the impugned order to the extent that subject to filing of a formal application before this court.
Yes. On December
by 18, under Order 7, Rule 10B of the Code of Civil Procedure, plaintiff is directed to file the plaint before the court, before the appropriate court, that is the commercial court, its original site, subject to Provisional Limitation Act by the December 2024.
Yes.
Thereafter, the party shall appear before the court where the plaint is presented on 6th of January. Yes.
It is this order is passed in terms of Order 7, Rule 10B. The court has to mention date, time when the plaint is presented. So according to this order, in terms of thereof, I present this plaint before your lordship today. If lordship admits this plaint, then the defendant will have a right of audience. They can take out application. They can, and I will also not be entitled to file other applications because I am contemplating an amendment application to file before I have to bring the plaint in the form of this court because now it is in the form of city civil court. I have to bring the form, make the plaint in the form of this court. So I have taken out that I could not take out, but I have affirmed the affidavit. I can't took the application for amendment of the plaint for bringing it in the form of high court. It is now in the form of city civil court because the lordship would also see the original plaint is also annexed. Page 43.
So what do you want?
I want lordship gives me the leave to present the plaint, and if the plaint is admitted before your lordship, then I will be permitted to I will be allowed to seek other steps in the proceeding. Other steps as in they had already filed the written statement in the court below. So that written statement also has to come here in terms of section 15 of the Commercial Courts Act. That stage is complete. But other steps, summons they have waived. So summons
I have not waived.
But recorded in the order.
It says that summons is waived unless your lordship feels otherwise.
Obvious.
So this statement that I have waived, it's incorrect.
It's recorded in the order. But I am not making that statement from the bar. It's recorded in the order.
What is your objection?
Yes, my lord. Twofold. Firstly, my lord, if to be present in the commercial division, they have to seek leave under 12A. They can't seek that leave because, my lord, this suit was being pursued since 2021, preceding which there was the NCLT proceeding. So today there is no urgency. They have to go before the mediator. 1. 2. With regards to the urgency, they had never filed an application before the learned city civil court. The suit was filed in 2021. It was kept pending till 2023 on account of deficit court fees. Thirdly, my lord, because yes, I have the case status. Thirdly, my lord, the other aspect is this, section 14, the Honorable Division Bench has been pleased to record in its order of 16th of December 2024 that the parties are directed to appear when the presentation of plaint occurs before this court. It is only because, my lord, the division bench takes into consideration the fact that they have to seek waiver under section 14, which only the receiving court can grant. Now, my lord, there I also have an objection with regards to admission of the plaint, because the suit, my lord, in 2021, it was when it was filed before the City Civil Court, I had a point of limitation already there. Today, my lord, coming back to 2025, 5 years have lapsed. So it is in any event barred by limitation.
So Mr. Ghosh.
My lord.
See, as per the order passed by the Honorable Division Bench, they have filed this suit.
Yes.
Correct. Rightly, wrongly, whatever it may be.
Yes, my lord.
And in the prayer portion, they have not asked for any leave from this court.
Yes.
So, correct.
I cannot, Lord, I cannot.
So only in terms of the order passed by the division bench, they have placed the suit before this court.
I've presented. Yes.
Can't present it.
That's the order of the division bench. I have to present.
Finally says 6.
Yes, my lord.
So, but unless and until there is a leave, so this court cannot pass any order.
Yes, my lord.
Correct.
It can be admitted subject to scrutiny by the department.
Scrutiny by the
Now, my lord.
So what I propose,
Yes,
subject to what I propose, I will send it to the master.
Yes, my lord.
For taking appropriate steps in account, because there is no leave, so the court cannot pass any
Lordship.
order. Then the master will take appropriate steps.
Yes, my lord.
And whatever your objection, you take your objection
My lord,
subsequently.
yes, my lord.
whatever it may be.
I'll take those objections. Only one thing, my lord. If they do not seek leave under 12A,
that subsequent.
Suit can't be filed.
That's subsequent. Your cause of action not arose.
No,
As of now.
unless
That's my
my rights have accrued.
Rights might be, but with regard to whether commercial, non-commercial, whether to 12A or not, mediation or not, that's
It can-
subsequent.
yes, then
and
this
this
will be
court
pressed.
cannot invoke any jurisdiction of the
Correct.
master at present
Correct.
because
Correct,
they have
my
not
lord.
asked for any.
Then, my lord, this has to be filed as a non-commercial suit.
Whatever
How
it
can
may
I?
be. No,
How
as-
can I file a non-commercial? The
If it
appeal
is-
court has
If it is
directed
a commercial
the
suit,
appeal
they
court has
have to take
directed
the
me to
leave.
file before the commercial division. How can I file a non-commercial suit now?
Consistence of
My
the
friends should not have
plaintiff,
then filed an application in the court.
consistence of
And my lord,
the defendant. Full stop. The plaintiff
We
has
have
filed the suit before this court
subject to scrutiny होगा ना.
in terms of the order passed by the Honorable Appellate Court in FMAT 392 of 2024 with Can 1 of 2024 within bracket Nibitita Das versus GBM P36 GBM Private Limited dated 16th December 2024 wherein the Honorable Appellate Court has passed the polling direction set out paragraph 11. Full stop. It is fine from the prayer portion of the present full stop. It is fine from the prayer portion of the present plaint filed by the plaintiff. The plaintiff has not prayed for any leave from this court, and thus the matter is sent to the master for taking appropriate steps.
But only one thing, sir. Only one thing. Lordship has to be that formally admit the plaint subject to scrutiny.
Can't.
But
I
then,
can't.
Lord, in that case, but my amendment application will also get stalled.
That's why you have not asked for any leave.
No, I don't.
Correct.
My
If you have not
submission
asked
leave is
for
not
any
required.
leave, the court cannot. And this is a duty of the master. Let the master. If the master find anything, then the matter will come.
It will come back to your Lordship. Because my
the master
submission is
find-
that the leave, the 12-way dispensation is not required.
Initially, this court cannot
Absolutely
take away the
I
right of the
take.
master.
Yes.
My submission would be that leave is not required at this stage, but whether as it may, it will come back to your Lordship. Yes, I'll
We have
take that.
presentation.
I'll make the
Grateful.
submission will come. Grateful.
Next. Number 10. फिक्स है नहीं चलेगा yes
My lord, recalls that Mr. Mitro was leading me in this matter, my lord. I am the plaintiff in this matter. The defendant number 1 had taken out an application, my lord, for deletion of its name. And my lord, my application for judgment upon
application.
My lord, that is pending. My lord, GA1.
You are for the plaintiff.
I am for the plaintiff.
Yes.
Now, my lord, during the course of the hearing of GA1 and GA3, my lord, is the application for deletion of the name of the defendant number 1. Now, my lord, the defendant number 1 has suffered CIRP. They have, in effect, succeeded. Mr. Kumarjit Banerjee was appearing for the defendant number 1. And my lord, Mr. Jishnu Shah also. So, my lord, the situation right now is it has gone into CIRP. So, my lord, we need to weigh our situation, what we need to do, because defendant numbers 2 to 6, my lord, are there. We would have to proceed, and that apart, my lord, we'll also have to lodge a claim, which we are in the process of as against the defendant
IRP.
before the IRP, my lord.
Now, my lord, so the situation right now, my lord, and so apropos, my lord, different numbers 2 to 6, that is something which we will have to consider at this given point of
What
time.
can be done now?
Perhaps, my lord, we will have to move as against the different numbers 2 to 6, because the suit as against the different numbers 2 to 6 cannot get stayed.
Whether different number 2 to 6 are appearing?
No, they have not been
Have you
appearing.
issued the notice? Where
My
is
lord,
the
several
affidavit?
notices issued, my lord, my affidavits of service, but if it so commences, my lord, because there are few entities which are outside, so I'll effect fresh service upon them. Yeah, perhaps, my lord, that will be the better way of proceeding.
So and so appearing for the plaintiff. None appears on behalf of the defendant. Defendant number 2.
1 has gone into CIRP. My lord.
The counsel for the plaintiff submitted. The defendant number 1 has gone into CIRP. Full stop. But the cause of action against the other defendants remains, and he wanted to proceed with the suit along with the application along against the other defendants. So the counsel for the plaintiff submitted. He will issue press notice upon the other defendants within a week from date. In view of the submission
My
made by
lord, it will take some time since they are outside India also.
within 3 weeks from date. In view of the submission made by the counsel for the plaintiff, the case is adjourned. Let the matter appear on 25th of February 2025.
Great.
Next.
My lord, I am for the defendant, my lord.
Who is for
Please,
the
Your Lordship, my lord, I am appearing for the plaintiff, my lord. Both of us, my lord, we are not aware why it has come. My lord, because there was a direction by Your Lordship and this was disposed of.
which one?
My lord, this is GA3, GA-Com 3, my lord, of 2024.
My lord, actually, it was our application that was for the appointment of the commissioner. That has already been appointed.
Whether this
Actually,
was
if it has been
disposed of?
filed, my lord, and so
Yes, yes.
By which order?
my lord,
By the, yes,
on
3rd
3rd of December, but it's not been recorded, my lord, in the order. So perhaps that is
That's
the
why it has
reason.
come.
That is the reason.
So and so appearing for the plaintiff. So and so appearing for the defendant. Counsel for the respective parties submitted by an order dated
3rd December, my lord,
3rd December
2024.
2024. This court has already appointed an advocate commissioner for recording the evidence of the defendant's witness on commission, and as such, he Form 3 of 2024 was disposed of. In view of the submission made by the counsel for the respective parties, and in view of the order dated 21st
3rd December.
3rd December 2024, GA-Com 3 of 2024 is disposed of.
Very deep.
Grateful.
Next.
Well, I am for the defendant petitioner in this matter, my lord.
Yes.
This is an application for setting aside of an ex parte decree, my lord, which has been passed, my lord. My lord, there are 2 applications. In fact, as an abundant caution, my lord, I have filed a Section 5 application also. But only one application is perhaps appearing before your lordship.
7th August.
My lord, the decree was passed on, my lord, 27th August. 27th August 2024. However, my lord, thereafter the order was modified by another order dated 6th of December 2024. So, my lord, since the order has merged with the later order, my lord, there may not be any requirement for filing the Section 5 application. But as an abundant caution, my lord, since I am recalling of that order also, I have filed this.
This is an application under section?
My lord, it is under Order 9, Rule 13, my
Rule
lord.
30.
Yes, my lord.
Yes. Then
So, my lord, I have to satisfy.
Plenty, my lord.
so you will file affidavit
Yes, my lord.
of the both
Yes, my lord.
GA2 and GA3.
Yes, my lord.
GA3 is there?
GA2 is, GA3 is
G2
perhaps,
section 5, my lord. And G3 is the recalling of the order.
but perhaps the GA3 is not appearing in the list. That is the difficulty. Your lordship can
nahi.
take it in the consider it as on
GA3?
today's list. Only one is appearing. I don't know why, my lord. Both have been filed, my lord, simultaneously.
Yes, not account.
ये कौन ठीक है GA3 कौन तो ये क्या है what is the GA3?
Lord, GA3 is the original application under Order 9, Rule 13, and GA2 is
calling of the order.
Yes, my lord.
Remain without certificate copy.
Lord, what happened in this matter, my lord? The address where the my lord writ of summons was attempted to be served, my lord, that was the possession of that property was taken up by the bank under the SARFAESI Act.
So, my lord, since the possession was taken up by the bank under the Surface Act, my lord, the defendant has shifted to another address at Bagurihati. So, my lord, all their attempts to serve the writ of summons could not succeed, my lord, as observed in your lordship's order also. Thereafter, my lord, a paper notification was made, my lord. That has, my lord, slipped by. I couldn't see that, my lord. Since it's not, my lord, somehow slipped. My lord.
Yes.
And thereafter, my lord, but they had the knowledge that I am residing at the
So
other.
you wanted to file affidavit?
Yes.
I went to
Both application.
both application.
What see, section 5 is order 9 rule 13 not applicable.
Because my lord, the order has been marched with, my lord, 6-4.
But my lord,
Since 2021, they have been intimated. At that time,
Okay, I will.
Lord, I am not saying a suit of 21, it is a 23 suit.
So
my lord, in this matter, no notice of motion is served and taken out, my lord.
So suffering for the plaintiff, suffering for the defendant. Full stop. The defendant has filed an application being GA3 of 2020, GA-Com 3 of 2024 under Order 9 Rule 13 of the Code of Civil Procedure for recalling of the judgment, ex parte judgment and decree dated
27th August 2024
August
as modified on 6th December.
as modified by an order dated 6th of December 2024. Full stop. The defendant has also filed an application being GA-Com 2 of 2024 for condoning the delay of filing an application under Order 9 Rule 13 of the CPC. Full stop. Though GA-Com 3 of 2024 is on record, but is not reflected in the cause title, in the cause list. Accordingly, GA-Com 3 of 2024 be taken as a day list. Counsel for the plaintiff press for time to file affidavit in opposition in connection with both the application. That affidavit in opposition be filed within
3 weeks.
3
Lord,
weeks.
till that time, Lord, the decree, execution of decree may be stayed, my lord.
They filed the execution.
They have not yet filed.
I have already filed.
They have filed. They are saying that they have filed. That is not kindly. But they had the knowledge that I am residing at other address and I have been arrested by the police.
Reply, if any, they are to be filed within a week thereafter. Within 2 weeks, 1 week.
1 week, Lord.
Within 1 week thereafter. Police. Release the matter on 28th of February 2025. If notice will come, then you come.
I'll mention them.
Notice if we receive, the come.
My lord, if a execution is filed, my lord, within 2 years, from the date of
That's why you will get the
they may not
notice.
file any notice to me, my lord.
It
That
will
is the
come.
difficulty.
That if it
But
is not,
somehow, my lord, protect me, my lord.
at this stage.
That is a money degree.
Come.
Money decree, my lord. But they knew that I was residing at another address and police had arrested me from that. They are proceeding.
Yes, next.
It was not intimated to us.
I am the plaintiff, your lordship, but I am opposing this application. This application for rejection of the plaint, lordship, and revocation of the clause 12 of the latest patent. Your lordship, I would like to file
No,
an
my
affidavit, your
lord,
lordship.
my lord, the application today which is on board is GA2. My lord, it is the application for condonation of delay in filing WS, my lord. We have received the writ of summons.
You have not been served with that application.
Yes, your lordship. My lord, the master summons have been served on 18th of December, my lord.
18th
Along
December?
along with the
24.
affidavit. Yes, 24, your lordship. That application has also been served.
Have you filed the return statement?
Yes, your lordship. On 20th of December 2024, we obtained leave of your lordships to file the WS with the department. We have filed the WS.
Yes.
Well, the time expires on 26th of December. We have filed it on 20th of December.
I come back tomorrow, your lordship. I don't think, your lordship, I have checked the application.
So suffering for the plaintiff, so suffering for the defendant. Full stop. The defendant has filed the present application being GA-Com 2 of 2024, praying for extension of time to file return statement. Full stop. Counsel for the plaintiff's defendant submit that the defendant has filed the return statement with the leave of this court on 20 December.
Yes, your lordship.
On 20 December 2025 and 2024, subject to acceptance of this court. Full stop. Full stop. In view of the above, the department is directed to place the written statement filed by the defendant in this record. List the matter appear tomorrow. List the matter tomorrow.
Your Lordship, let that application also come so that Your Lordship.
Counsel for the plaintiff further submit that the defendant has also filed an application being GA.
My lord, we have filed applications, my lord. It is not yet registered, but my lord, the master summons is returnable tomorrow. Probably
If
those
it's come,
applications will be listed tomorrow.
Let the matter appear tomorrow. ये मानतोष इसका देख लेना वहां से रिटर्न स्टेटमेंट मंगा लेना.
Well, this application will appear tomorrow.
Next.
Madam, this matter I'm appearing for the plaintiff petitioners, my lord. My lord, on 10th of December 2024, my lord was pleased to pass an order whereby my lord was pleased to direct the defendants, my lord, to furnish an amount of rupees 22 lakhs and odd with the registrar original side. My lord, the registrar was due to submit a report before my lord, 4 weeks from that particular date of 10th of December. My lord, that is tomorrow, my lord.
What is this application?
This is an application they have been praying for.
Lordship,
For the plaintiff.
My lord, the application is taken out by them.
to appear for the defendant number one. Defendant number one.
Who has filed this application?
Lordship, Mr. Ashok Nagar is appearing in this matter, who is now appearing.
I am asking who has filed. Defendant number one has
Lordship,
filed.
I am not briefed in this matter actually.
You are not appearing in the
Let
matter.
this matter then, my lord, let this matter be next.
Lordship,
in the
Lordship,
next monthly list, my lord.
Mr. Ashok Nagar, he is appearing from Supreme Court, and he has requested me to fix the matter after recess. Kindly, Lordship, fix the matter after recess.
Come next.
My lord, next week, my lord, next week,
No,
Monday.
Lordship, he is requested
After my matter is
My lord's board is heavy, na? How can my lord?
any time after recess.
so and so appearing for the plaintiff, so and so appearing for the defendant. Police, the proxy counsel appearing for the defendant number one submits that. The advocate appearing for the defendant number one is appearing in the before the Honorable Supreme Court and prays for fixing the matter after lunch. Police, considering the submission made by the counsel for the defendant number one, let the matter appear on 14th of January 2025. Next.
Deeply obliged, my lord. 14 January কবে দিতে পারলো?
Item number 15.
I appear for the plaintiff, my lord, petitioner. My lord, this matter, my lord, there was a application filed by us for judgment upon admission, which was allowed by my lord by an order, my lord, of my lord 6th of December 2024. Now, my lord, pursuant, and in that order, lordship had also rejected their application for extension of time, my lord, to file written statement, since it's a commercial suit and it was beyond 120 days. Now, my lord, they preferred an appeal against that order, whereby lordship had allowed the chapter 13A application. My lord, now, my lord, in the appeal court, my lord's order was upheld to the extent that my lord, judgment upon admission is maintainable. But my lord, they had filed an application for revocation, my lord, which was pending, which lordship had fixed on 24th of January. Lordship will find in my lord's last order of 6th December. My lord, that, my lord, the appeal court has directed, kindly see the order. Yes, my lord. GA4 has directed that they are not interfering with anything, only that they will have to deposit 20 lakhs. My lord, the amount has been reduced from 31 to 20 lakhs by 13th. 3 weeks, my lord, is 13th of January. So, my lord, as it is, my lord, I am agreeable, my lord. I have no issues. Lordship's order is upheld. But the only thing is that in the order of 6th December, with regard to his application, lordship had directed us to file the opposition within 2 weeks, I think, my lord. My lord, may that be extended by 10 days, my lord, I'll file it. May it be on 24th itself, I have no issues, my lord. May it be 10 dine kore dao. Within 10 days, I'll file it, my lord.
So and so appearing for the plaintiff, none appears on behalf of the defendant. Defendant has filed an application being GA Com 4. 4.
Yes, my lord, 4.
4 of 2024. 2024. Praying for revocation of leave under clause 12 of the latest patent. This court has already granted and directed the defendant and plaintiff to file affidavit in opposition. So the counsel for the plaintiff prays for extension of time to file affidavit in opposition. Let affidavit in opposition be filed within 10 days.
Yes.
Reply, if any, there to be filed within a week thereafter. The matter is fixed on
24th.
Let the matter appear on 24th of
The only thing, my lord, lordship will indicate it's a conditional order which the appeal court has filed.
They will not. On that day, will see.
No, because my lord, lordship records, otherwise my extension will, my lord, be as a waiver, my lord. Kindly sees the order, it's subject to deposit of 20 lakhs within 3 weeks. Otherwise, lordship will dismiss the application, my lord. Kindly seize the order. It's conditional.
Direct the appellant. Appellant is defendant.
Yes, my lord. So kindly record that. Otherwise, this extension would lead to a waiver on my part, my lord.
It is found that the defendant had preferred an appeal against the order passed by this court, and in the said appeal, the Honorable Division Bench, by an order dated 23rd of December 2023, directed the appellant to deposit rupees 20 lakhs with the registrar of this court within 3 weeks as condition precedent for hearing of the application for rejection of the plaint or revocation of leave under clause 12 of the latest patent. Full stop. Though none appears on behalf of the defendant and no report has been submitted whether the defendant has deposited rupees 20 lakhs in terms of the order passed by this court. It is made clear that the extension of time to file affidavit in opposition in connection with GF4 will not affect the condition imposed by the Honorable Division Bench by an order dated 23rd of December 2024.
My lordship can keep the appeal court's order, my lord. Grateful.
Let the order be kept with the record.
Grateful, my deeply. Deeply. Yeah.
Item number 16, line IPA for the plaintiff, my lord. This is an application by the defendants for extension of time to file the written statement.
Who is for the defendant? Writ of summons was served upon defendant number 3, 4, and 5.
Yes.
On 4th September, and defendant number 3, 4, and 5 received the writ of summons along with 23rd of September.
In paragraph 8, they say it is ready. It is to be ready.
September.
It is still in time. 16.
Whether they file the written statement or not.
No, my lord, paragraph 8, lordship will see. They say that it is more or less ready and could be filed, and they have sought for a period of 4 weeks.
You will file affidavit? No.
Within 120 days, my lord.
So when it's going to be?
23rd January, my lord, I think.
Fixing next week.
Very well.
So appearing for the plaintiff. None appears on behalf of the defendant. Defendant. Sorry. Defendant number
3, 4, and 5.
And 5 have filed the present application being GA Com 2 of 2024, praying for extension of time to file written statement. As none appears on behalf of the defendant, accordingly, for the interest of justice, the case is adjourned. Let the matter appear on 21st of January 2020.
Maybe before, if they file
17 January.
If they file the written statement, very well. Otherwise,
17 January 2020. Next.
My lord, I beg to appear on behalf of the defendant. My lord, the petitioner hearing, your lordship. My lord, this is my application praying for extension of time to file my written statement.
When you receive the writ of summons?
My lord, I have received the written summons on 24th August 2024. My lord, accordingly, subsequently, we have already filed the written statement with my lord's leave.
When?
My lord, written statement was filed on, affirmed on 9th December and it was filed on 11th December, your lordship. Now, my lord.
20 days?
Yes, my lord. It is within 120 days. Even, my lord, if the puja vacation period is excluded, my lord, within 90 days, your lordship.
How the puja vacation?
Yes. My lord.
Yes.
My lord, see the reasoning, my lord, in paragraph number 6 that due to various illness, there is no documentary evidence, nothing to show. My lord,
suffering from jaundice, taking the home medicine.
For 120 days. Whatever my lord feels.
Otherwise, your lordship, the rest of the defendants are octogenarian persons, your lordship. That is a fact, your lordship. Otherwise, if my lord.
This is filed by the defendant number 2 and 6.
I appear with all the defendants. My lord, defendant number 1 is the constituted attorney.
Who has filed the all?
Yes, my lord.
Single written statement?
Yes, my lord.
So appearing for the plaintiff, so appearing for the defendants. The defendants have filed the present application being GA-Com 1 of 2024, praying for extension of time to file return statement. Full stop. Counsel for the defendants submit that the writ of summons was served upon the defendants on 24th of August 2024. But due to the illness of the defendants number 2 and 6, the defendants could not file the written statement within the prescribed period of 30 days. Full stop. Counsel for the defendant submit that the defendants have affirmed the written statement on
9th December 2024.
On 9th of December 2024 and have filed the same in the department with the leave of this court on 11th of December 2024, subject to acceptance by this court. Full stop. Counsel for the plaintiff defendant submit that if the time is not extended to file the written statement, the defendant will suffer irreparable loss and injury. He further submits that though the defendants have not filed the written statement within prescribed period of 30 days, but have filed the written statement within the order time of 120 days. Learned counsel for the plaintiff raised objection and submitted that though the defendants have received the writ of summons on 24th of August 2024, but have not shown any cause why the defendants have not filed the written statement within the period of 30 days. The counsel for the defendant also pointed out that the defendants have taken the ground of illness but have not disclosed any documents to establish that the defendants were suffering from any illness. The counsel for the defendant plaintiff prays for rejection of the application. Heard the learned counsel for the respective parties peruse the application filed by the plaintiff, filed by the defendant. Full stop. This court find that though admittedly the defendants have not filed the written statement within the prescribed period of 30 days, but have affirmed the affidavit on 9th of December affidavit of written statement on 9th of December 2024 and have filed the same before in the department after obtaining leave from this court subject to acceptance of the same. Full stop. This court find that the defendants have filed the written statement within the outer time of 120 days, and as such, one opportunity should be given to the defendants to file written statement subject to payment of cost of rupees. How many defendants? 6. 10,000 to the plaintiff within a week from date. Full stop. The department is directed to accept the written statement subject to scrutiny by the department. GA number so this is clear.
Much obliged.
Deeply obliged. My lord. GA1 is my application, my lord, for application for extension of time
Below acceptance of the for extending the time. If my hands over,
I'm the plaintiff.
You are for the plaintiff, for the defendant.
My lord.
How many? Sole defendant.
Sole defendant.
Yes.
We have prepared the list of dates.
Huh?
We have prepared a list of dates, my lord.
Have you filed the written statement?
My lord, this is the within 120 days.
When you filed?
We have filed written statement on the 5th December 2024, my lord, after obtaining leave by this court, my lord.
5th of December, when you received the writ of summons?
My lord, the 29th
August,
my lord.
99th day you have filed?
My lord.
Yes. What is the objection?
Objection is what is the ground is given not to file the written statement within 30 days, my lord.
Okay.
My lord.
Come to paragraph 5 and 6, my lord.
Defendant.
My lord, kindly come to paragraph number 2, my lord. Actually, the same self of the issues, my lord, the matter is pending before GST authority, my lord. So that's why the status was not available, my lord. That took the time, my lord.
Yes.
I am opposing. There is no question of GST is in.
Okay. So-and-so appearing for the plaintiff, so-and-so appearing for the defendant. Full stop. The defendant has filed the present application being GA-1 of 2024, praying for extension of time to file return statement. Full stop. Counsel for the defendant submit that the writ of summons was served upon the defendant on 29th of August 2024, but the defendant could not file the return statement within the period of 30 days, that is on or before 28th of September 2024, on the ground that on the similar cause of action, a GST proceeding is going on before the GST authorities. And subsequently, the defendant has obtained all the information regarding the status of the complaint raised before the GST authorities, due to which the defendant could not file the return statement within the period of 30 days. So counsel for the defendant submit that the defendant has affirmed the return statement and filed the same in the department of this court with the leave of this court on 5th of December 2024, that is on 99th day from the date of receiving the summons. Counsel for the plaintiff submit the defendant submit that. Subsequently, the defendant has filed the present application, praying for extension of time to file return statement. Counsel for the plaintiff raised objection and submits that no cause is shown as to why the defendant have not filed the return statement within the period of 30 days. Counsel for the defendant submit that plaintiff submit that the pendency of the case before the GST authority is not the ground for extension of time to file return statement. Counsel for the plaintiff submit that the application filed by the defendant may be rejected. Heard the learned counsel for the respective parties peruse the application filed by the defendant. This court find that the date of summons was served on 29th of August 2024. But the defendant could not file the return statement within the period of 30 days. But it is fine from the record on 5th of December 2024, with the leave of this court, the defendant has affirmed the return statement and filed the same in the department. And this court has granted leave to file in the department subject to acceptance. Now, the plaintiff has prayed for acceptance of the return statement. Considering the above, this court find that though the defendant has not filed the return statement within 30 days, but 30 days and appropriate cause has been shown that the documents was not traceable, and after correcting the documents, the defendant has advised the learned advocate for preparing of the written statement, and accordingly, within the auto period of 120 days, the defendant has prepared the written statement and filed in the department. Considering the above, this court finds that one opportunity should be given to the defendant to file written statement subject to payment of cost of rupees 5,000. So the defendant is directed to pay the cost of rupees 5,000 to the plaintiff within a week from date. Full stop. The department is directed to accept the written statement filed by the defendant on 5th of December 2024, subject to scrutiny by the department. GA number so and so is disposed of.
My lord, one humble request, my lord. My learned counsel was appearing online. His name should be indicated.
You give the name. There is no counter claim.
There is no counter claim.
Give the name.
Much.
I must follow him.
Yes, next.
I appear for respondent number 5, 6, 7, and 8, Lordship.
Yes. Who is for the plaintiff?
I appear on behalf of the district collector of Tiruvallur.
Yes.
Only some leave I was praying for. We have got the affidavit. They sent it from there. But they have sent it according to the format over there. It is it is typed on both sides. and it is not in the bond paper. As a result, the stamp punching, they refuse to do it. So your lordship will kindly give me leave to have it stamp punched. That's why that and the Vakalatnama is also same defect. So if your lordship permits me to have that leave to have it stamp punched, otherwise I have it. Your lordship can consider it. I'll have it stamp punched in the course of the day.
This is the way of the South India. They save the papers. If you find the legal, if you find not on the court, if you send the notice, and if the South Indian advocates are giving the reply from either Chennai, Andhra, or Kerala, they will give the reply from the both sides.
Both sides.
I think in the both sides.
But in any case, the district collector Tiruvallur is present online. Is also there. In terms of your lordship's order. I would be praying, first of all, your lordship will dispense with his personal appearance.
What is the affidavit? Have you found what is the affidavit? What you have shown in the
Yes,
affidavit?
my lord. If your lordship permits, I shall have it stamp punched later on. The Vakalatnam and the both are there, my lord. Original reply আছে তো? Lord, I have given the details which I could collect.
Page 11.
Is there in page 15.
Hmm, 1.82.5. It is pending. নিজেই লিখেছে।
Okay. We have got that much, but and I would pray for some more time to give certain more because the search is not complete as yet.
Thank
you. Two other things, my lord. First is, may I file the affidavit of service on the, we have served also on the principal alleged contemnants, my lord, 1, 2, and 4. My lord, that apart, my lord, we have been made over, my lord, by way of email, my lord, certain details by the revenue department to my advocate.
You will get it. You will get the once this
I'll
affidavit is
accept,
out to you. You will get the details of some of the properties.
But
And
your lordship, but they are deliberately avoiding appearance in court 1, 2, and 4.
that I will, with regard to let the district collectors maybe dispense with their appearance, maybe dispense with.
No, I will give it to everybody. No problem.
And what about your client?
And your lordship give me the leave to have this stamp punched.
What about
And
the other contemnants you have any knowledge?
But I would be praying for a direction on the district collector with the local police, my lord, to bring them here.
That district collector can't.
But
That is the police authority.
we execute the warrant. Your lordship had issued the warrant of arrest.
But the district collector, unless they cannot. As per the provision, it is the police authority. So first we have
Direction of the police authority.
You have served it. If it is not, then I will pass an order for the district superintendent of police. Then if it is not, then we'll see to how it is to be executed.
Yes, because
step by step you go. Let us see.
Because warrants have already been issued by your lordship.
Then I will see to that. So appearing for the plaintiff. So appearing for the alleged content number 4, 5, 6, 7, and 8. And advocate appearing for the district collector of Tiruvallur and
Tiruvallur. I am appearing for only district collector.
Not the Tirupati.
Not Tirupati.
What about the Tirupati?
Sir.
Yes, you are the district collector.
Tirupati, sir.
Yes. Why you are not complying with the order?
Sir, we have furnished the information, sir, on December 28th, sir.
Whom? To my advocate on record, my lord. He had sent an email and an attachment with that. My lord, there's a
You also shared it to the Honorable Court.
Yes, yes. Got it. Tirupati Mandal. Okay. Okay, thank you. কি বলছি? 7 and 8 and so and so appearing for the district collector Tiruvallur district, Tamil Nadu. Full stop. The district collector Tirupati district from Andhra Pradesh is appearing in person through virtual mode. The district collector Tiruvallur district, Tamil Nadu is also appearing through the virtual mode in person. Full stop. Learned Counsel appearing for the district collector Tiruvallur district, Tamil Nadu submit that he has received the affidavit of compliance affirmed by the district collector, but it is It is not in the bond paper and it is typed in both sides of the papers. And praise for lieu, as well as the Wakalatnama is also typed in both sides. Counsel for the district collector Tiruvallur prays for leave to accept the same said Wakalatnama and the affidavit affirmed by the district collector Tiruvallur, Tamil Nadu. Accordingly, leave is granted to file the same in the department, and the department is directed to accept the same as it is.
And stamp and punch.
And also to stamp and punch. Full stop. The learned counsel appearing for the district collector Tiruvallur is directed to serve the copy of the affidavit to all the
I with them, but my junior would do that.
Full stop. The district collector Tirupati has Tirupati, in compliance with the order passed by this court, has forwarded the details of the property of the alleged contemners situated at Tirupati Urban Mandal, BN Kandriga Mandal. Let the same be kept with the record. Have you received this?
Yes, by way of email we have received this. Well, only one prayer.
The counsel for the plaintiff submit that the plaintiff has also received the said details through the email.
Well, I was humbly submitting. If your lordship kindly turns to page 2, my lord will see that in Tirupati Urban Mandal, there are 5 properties which have been mentioned, which includes the properties of the alleged contender number 4, my lord. 1, 2, and 4. Your lordship will kindly see residential and commercial mixed, then residential, and 1. 5 I really cannot see from here, but yes, but 1 to 4, your lordship will kindly direct the district collector Tirupati to attach these properties, because they are the principal contemners whose properties are there, which have been disclosed by the.
The counsel for the petitioner submit that though the district collector has submitted the report, and as such he may be directed to direct the concerned authorities of his jurisdiction not to register any kind of the deeds with respect of the property as mentioned in the with respect of the said report.
Order of this court.
Considering the submission made by the counsel for the plaintiff, the district collector Tirupati is directed to direct the concerned authority, that is the Tehsildar or the sub-register or any of the competent authority, not to register any kind of deeds with respect of the aforesaid landed property, with respect of the description which has been forwarded by the district collector Tirupati before this court, and to submit the report on the next date fix. Full stop. The counsel for the plaintiff further submit that though the warrant has been issued up against the defendant number 1 to 4, but till date the warrant has not been executed. Accordingly, the plaintiff is directed to take fresh steps for issuance of fresh warrant upon the alleged content number 1, 2, and 1 to 4, and the concerned district superintendent of the district are directed to execute the warrant and to submit the report before the court.
1, 2, and 4.
1, 2, and 4. Submit the warrant, execute the warrant, and to submit the report of warrant against the defendant number 1, 2, and 4.
One other thing, my lord, if your lordship kindly considers, on the last occasion, my lord's pleasure was to direct the respondent numbers 5 to 8 to file their affidavit of assets. They have they have not yet filed their affidavit of assets.
There was a direction against respondent number 5 and 8 to file.
5 and 8.
So.
Affidavit, no affidavit of assets. They have filed an affidavit.
Okay, let's see. Full stop. Concern. Let
that's
the
an
matter.
affidavit.
The
It's not an affidavit of
personal
asset as
appearance of the district collector Tiruvallur district and district collector Tirupati is dispensed with for the present.
For the timing, since we have done our bit, would your lordship discharge us from further appearance in the matter?
For the present, I am discharging.
No, their personal appearance. I mean, even for us to appear in the matter, because we've got nothing to do with the interstate fight. So further appearance for the time being is discharged.
Now, with regard to the report is to be filed by the district collector Tirupati with regard to directing the concerned authority.
So that is, no, I'm only saying I'm not appearing for Tirupati. I'm only appearing for Tiruvallur.
Okay.
That is why I say further appearance on behalf of the district.
For the present, The learned advocate appearing for the district collector, Tiruvallur, is also dispensed with.
Grateful to Lordship.
Dispensed with. You take this and affirm it?
Yes, sir. I affirm it. I shall file it before Lordship.
But your lordship has possibly not mentioned any returnable date. my lord.
Let the matter. So how much time you?
It will take some time, my lord.
Let the matter appear.
First week of February, my lord.
Let the matter appear on 11th of February 2023.
Warrant of arrest by speed post.
Warrant
because the
Thank you.
Lordship,
Thank you, sir.
one problem. Subject to leave, your lordship. The warrant of arrest, the requisites which we put in, your lordship, the bailiff wants himself to personally go there and come
That's
back.
why you file a fresh. Let the fresh report come, then I will pass a report.
Lordship would kindly direct the warrant of arrest, the requisites, to be circulated by way of a speed post. We can send it by speed. The bailiff.
That's when what speed post. What is happening if they're sending the speed post? It is returning.
Exactly, your lordship.
Secondly, I have passed an order for the personal service. That has also not been so. That's why I'm asking you take fresh step for personal service. If it is not done, then the court will say.
Your lordship. Obliged, your lordship.
Grateful to Lordship.
Next.
Item number 28. In this matter, I seek the accommodation for not today.
Item number
20 minutes.
20.
Not today.
Not today. Witness action.
Yes, ma'am. Because daily.
So why not today? Next week. Tomorrow you will bring the witness.
Yes, but she told me she will come.
Not today. Next.
I appear for the plaintiff.
Lordship, we are appearing for the respondent, sir.
Lord, it's for framing of issues, my lord. I have come with the issues, my lord.
वाला जो रिपोर्ट आया ना तिरुपति का उसमें ऊपर लिख दो रिपोर्ट फ्रॉम द तिरुपति डिस्ट्रिक्ट कलेक्टर तो हम लोग पता yes
It's for framing of issues, my lord. We had also written and given them a notice to produce 2 documents. They have not disclosed and they have not offered inspection either. So, my lord, I am providing the issues, my lord, subject to
yes why you are not produced.
Lordship, this order was passed on the 25th of November. Lordship, both of us have not done discovery and inspection. I was humbly praying if some
I
time
have
can
nothing
be,
to discover.
some
commercial case.
Some time be extended, your
I
lordship.
have
What
nothing to
time?
discover
Lordship,
except
they
to
have
those
given
2
a notice
documents.
to produce after discovery inspection. They were also supposed to file judge's brief of documents. They were supposed to
document will see to that.
affidavit of admission and denial. Your lordship, both of us are in default. We've
No,
not
he's
completed.
I am
ready
ready
for
to
that.
proceed.
He's ready for the
Admission and denial also, your lordship, not done. Discovery inspection also
not
not done.
disclose what the
There's nothing to do.
Lordship,
Everything is already admitted then.
Lordship, may I? They have not written any letters. There was 3 weeks time, your lordship, given. That finishes on the 16th of December. They have written a letter for notice to produce on the 19th of December. Because they have not done discovery and inspection within the 16th, then they've written a letter just before the vacations, your lordship. And they are asking for sanctioned building plan. We've written to our clients asking for instructions to produce the sanctioned building plan. Now it's taking some time, your lordship, to give them. But that is also
Where is your
beyond time.
client?
CSC, your lordship.
Calcutta.
Lordship, the sanctioned building
Victoria
plan and everything
House.
before the vacations.
At Chorangi.
That is after the time period of discovery and inspection.
CSC, there is no vacation.
No, Lordship, they have written a letter beyond their time of discovery and inspection.
It's a notice to produce.
By way of a notice to produce. So discovery and inspection has not been done by both the parties. I was humbly praying that may be done. Short time, Lordship, can be given.
Lord, notice.
How soon you complete?
Lordship, 2 weeks time, Lordship.
2 weeks? No, I will not.
There's just
no notice to produce is different. If
25th of November 2024, this court has passed an order. Now we are on January.
6 January.
Total December gone.
Lordship.
Half of January is going to be completed. So,
Lordship, they have also not produced anything. I don't know. They
Mr.
don't
Ghosh, have you
inspection,
disclosed your document?
Lord, it's in the plaint.
No,
for inspection
My lord, there is no document which is disputed because of the reason the only document is a 106 notice to which they have replied. So they can't deny existence of it.
Lordship, admission and denial has also not been filed. Suggested issues were supposed to be circulated. That has also not been done. Judges' brief of documents are supposed to be prepared. That has also not been done.
Admission and denial will be done unless and until the
time period was given.
Is inspected.
Lordship, Lordship, that was supposed to be done by the 16th of December. They write on the 19th of December, your lordship. So I'm saying both of us are
My
in
notice
default.
to produce has
I
nothing
think
to
2
do with
weeks
the
time.
discovery inspection.
So appearing for the plaintiff, so appearing for the defendant. Also by an order dated 25th of November 2025, this court passed an order directing the parties to complete the discovery and inspection of the document. Full stop. Today, when the matter is taken up for hearing, counsel for the defendant submitted the discovery and inspection could not be completed and prayed for extension of time. Full stop. Considering the submission made by the counsel for the defendant as a matter of last chance, the plaintiff is directed to disclose their original document, if any, relied upon to the defendant within a week from date. Full stop. Full stop. The defendant is also directed to disclose their original document which they are relied upon to the plaintiff within a week from date. Full stop. After disclosure of the document by the respective parties, the parties are directed to complete their inspection of document within a week thereafter. Full stop. On completion of the discovery of inspection of the document, the parties are directed to file their affidavit of admission and denial of the document within a week thereafter. In the meantime, the parties are also directed to exchange their suggested issues. Full stop. List the matter on 1 week, 3 weeks. Na? Let the matter appear on 31st of January 2024 for framing of issues. It is made clear that no further opportunity shall be given for discovery and inspection of the document.
Grateful, Lordship. Lordship, that will be 2025, Your Lordship.
31st January 20.
Grateful, Lordship.
Yes, next.
My Lord, I appear on behalf of the petition. My Lord, plaintiff.
Because I beg to appear for the plaintiff, my lord. And my lord, the application under section 8, my lord, of the Arbitration and Conciliation Act has been filed by the respondent, my lord, respondent number 1.
Yes.
My lord, the matter was fixed for arguments on that application.
You are appearing for a plaintiff?
Yes, my lord. Yes, my lord.
My lords, I am appearing for the respondent in this matter. And if my lords may allow, give us a certain date after 3 weeks, my arguing counsel will appear in the matter and argue the matter as we are appearing from the Delhi, my lords.
Correct. You have filed an application under section 8. Affidavit.
Yes, my lords.
Ready for why so late? This is a commercial suit. Affidavit completed.
Yes, my lord. GA2 affidavit.
So when your arguing counsel will be available, madam?
My lords, if my lords may keep it on any date after 3 weeks.
Not 3 weeks. So sorry. 3 weeks will not be granted. It's a commercial suit.
Okay, my lords, then any date as per my lords.
जनवरी में है कोई डेट? फरवरी में? फ्राइडे। ठीक है, हम रख देते हैं। So appearing for the plaintiff, so appearing for the defendant. Defendant has filed an application being GA1 of 2021.
Lord, GA2, my lord.
GA2?
Yes.
GA1.
GA1 is my application.
GA2. GA2 of 2021. Praying for referring the parties to the arbitration. Full stop. Counsel, it is submitted that readings in connection with the application is completed and is ready for hearing. Counsel for
My
that.
lords, if my lords may fix the matter on a specific time, it would be very grateful.
The defendant prays for time. Considering the submission made by the counsel for the defendant, for the interest of justice, the case is adjourned. Let the matter appear on 28th of January 2024. Under
My lords, can we get 5th of Feb or something?
When?
Maybe 8th or February, 8th of February. Will that?
8 को मिलेगा देखो. 26, not before that. 26th February. 26th February at 3 p.m.
Most grateful.
February at 3
Most grateful.
That's it.
Grateful, my lords.
Most grateful.
No, specifics. Yes, next.
Obliged, my lords.
Item number 23, Your Lordship, I am appearing for the plaintiff.
Your Lordship, the suit has been filed in the year of 2022 in relation to intellectual property rights, Your Lordship. We are requesting for transferring it to the rightful bench having the determination. Yes, Your Lordship, of 2022.
So appearing for the plaintiff, so appearing for the defendant. Counsel for the plaintiff submit that the matter is connected with the intellectual property right and is filed in the year 2022. Considering the above, this court find that this court is not having the determination to hear the said suit. Accordingly, CS number 260, CS number CS.Com 438 of 2024 within bracket old CS 269 2024 along with GA4 along with all connected application is released from the list of this court. Full stop. The department is directed to assign the new number of IP cases and to place before the appropriate bench having determination.
Grateful, Your Lordship.
Next. लिस्ट खत्म हो जाएगा आज कोई नहीं है none appears on behalf of either the parties. No accommodation is sought for. Let the matter be placed in the warning list. Next.
My Lord, I appear for the plaintiffs in this matter, my Lord. My Lord, the writ of summons have been served upon the defendants on 11th of June, my Lord. Thereafter, my Lord, 120 days has expired, my Lord, and I have obtained a report from the Deputy Registrar indicating that the defendants have not appeared or filed written statement, my Lord.
Sole defendant.
Sole defendant, my Lord.
Plaintiff in the suit thereby certified defendant not entered appearance either in person through the advocate.
My Lord, I'm praying that
Statement.
no, they have not filed it, my Lord. My Lord, I'm praying that the matter may be kept under the heading of undefended suits, and accordingly directions may be passed for.
Appearing for the plaintiff. None appears on behalf of the defendant. Plaintiff has handed over the service report dated 30 July 2024, wherein it reveals that the writ of summons through the bailiff was served upon the defendant. No, the writ of summons, the writ of summons was served upon the defendant through the postal services on 11th of June 2024. Let the report be kept with the record. The counsel for the plaintiff has also handed over the report issued by the Deputy Registrar within bracket legal dated 5th of December 2024, wherein it reveals that defendant has not entered appearance either in person or through the advocate till 5th of December 2024. Counsel for the plaintiff submit that neither the defendant has entered appearance or filed written statement and place the matter in the list of undefended suit. Had the learned counsel for the plaintiff peruse the reports, this court find that in spite of service of writ of summons, none appears on behalf of the defendant nor have filed written statement. Accordingly, CS.Com 660 of 2024 be placed in the list of undefended suit. Full stop. The plaintiff is directed to file judge's brief of document within 2 weeks. Full stop. The plaintiff is also directed to file the affidavit of evidence of the plaintiff witness within a week thereafter.
Very well, madam.
Full stop. Please the matter give the date for a witness action. On 27th of अभी तो था 26 लास्ट वाला 26 था 27 था 26 ठीक है 27 at 3 p.m. 27 at 3 p.m. Next.
Grateful, madam.
For witness action,
My lord, 26, my lord, I appear for the defendant.
My lord, it is my plaint, my lord. May I have my lord's kind leave to appear virtually, my lord? It is my plaint, my lord. On the last occasion, my lord, on October 4th, my lord was very kind to give us 30 days time to, my lord, file my additional written statement to the counter claim, my lord. It is admittedly, my lord, that has not yet been filed, my lord. I tender my apology, my lord. It is almost ready, my lord. We will be filing the additional written statement, my lord, along with an application for extension of time, my lord, to file it.
30 days over?
Yes.
30 days is over, my lord.
Then?
My lord, I am fortified by my lord's judgment, where a similar issue was raised, and my lord has held the 120-day period, my lord, for filing of a written statement. My lord would, mutatis mutandis, apply for additional written statements as well.
Okay. But have you gone through the report of the master? There is some defect in the written statement and the counterclaim. 16 December report.
No, my lord, I have not been given a copy, my lord, of the master's report, my lord.
You go through the, you're appearing. Yes. Go through.
Yes, my lord, we'll also go through the report, my lord.
That can rectify. We'll correct and give the copies to us.
Or we'll take steps to rectify the defects.
So-and-so appearing for the plaintiff. So-and-so appearing for the defendant. Counsel for the plaintiff prays for extension of time to file additional written statement to the counterclaim filed by the plaintiff. And filed by the defendant. Full stop. It is fine from the record the London master has submitted the report showing some defects in the written statement and the counterclaim. The counsel for the defendant, after going through the report, prays for time to take appropriate steps to cure the defects as pointed out by the department. Full stop. The time to file additional written statement. When you file the written statement?
Well, it was formally taken on record, my lord, by this court on October 4th, my lord. That is the order of my lord.
It's extended. How much? When you will file?
My lord kindly gives me 2 weeks, my lord. In any event, my lord, it cannot go beyond 120 days. My lord is well aware, my lord.
Within 2 weeks?
My lord, I apologize, my lord. 3 weeks, my lord. The plaintiff is situated outside of the country, my lord. I'm very sorry, my lord.
Plaintiff may take note that the set time for filing the additional written statement shall not go beyond the period of 120 days on receipt of the written statement.
I'm very grateful, my lord.
Full establish the matter on 31st of January 2025.
Grateful. Very grateful, my lord.
Appear for the defendant, my lord.
Yes.
48, my lord, I appear for the defendant, my lord.
Huh?
I appear for the defendant, my lord. There are 2 applications pending.
Who's for the plaintiff? Nobody. GA1?
GA1 is at the instance of the plaintiff, my lord, for amendment of the statement of accounts. And there is another GA3 at my instance for amendment of the support.
Affidavit in support of caveat.
My lord.
Paragraph 10 to 13.
My lord.
But nobody is there. So, have you no objection with regard to the application of the plaintiff?
The plaintiffs, we have an objection, my lord. Since, my lord, in the name of amendments, what they are doing, they are bringing the property of the wife in the purview of this
in the will.
Will.
The will is of the husband.
Yes.
And they wanted to bring the
property of the wife also.
Where from you got? Which property is the wife?
Yeah, may I just?
Have you filed affidavit? No.
Yes, we have filed affidavit, my lord. Affidavit in opposition, my lord. If my lord kindly take.
GA1?
GA1.
ये affidavit of opposition का J1 का
Paragraph 9, my lord. We have specifically stated.
नहीं है. When you filed?
We filed.
See in the file?
No, it's not here, my lord.
It's not in the file also.
We have already filed in the record, my lord. They have given reply to that effect also.
You are having the extra copy?
My lord.
Which paragraph? But the other side is not here. Adjourning it next week.
Well, kindly adjourn for 2 weeks, my lord.
So and so appearing for the. You keep it.
My lord.
You come with that. So and so appearing for the defendant. None appears on behalf of the plaintiff. It is found that the plaintiff has filed an application being GA1 of 2021, praying for amendment in the affidavit of asset. Full stop. The defendant has also filed an application being GA3 of 2020. GA3 of 2020. 2024, praying for amendment in the affidavit in support of caveat. Full stop. As none appears on behalf of the plaintiff, for the interest of justice, the case is adjourned. Let the matter appear on 28th of January 2020. Yes, who is appearing?
I am appearing for the petition. This is an application for grant of probation.
Yes.
4 heirs, 2 daughters and 2 sons. All has given consent.
4 daughters, 4.
2 daughters and 2 sons.
2 sons, 2 daughters. 1 son is the petitioner.
No. Petitioner is the younger brother of the deceased.
Younger brother of the deceased. So they have given no consent. And what about the attesting witness?
Attesting witness has a affirm affidavit.
Where is the will?
Will is at page Annexure B, page 13. Is 30.
Annexure B.
Annexure B.
Where is the name of the testator? Executor.
Second page, Mr. Ashok Kumar Gupta.
Younger brother Ashok Kumar Gupta. Yes. When he died?
He died in the year 2015.
15th October 2015.
Yes.
And date of will is?
13.
January 13. What about the wife?
Wife predeceased. It is written.
Where is that? Any death certificate is enclosed? No.
No. In the will also it is written. And in the affidavit also.
Which paragraph?
Will in paragraph 2. Space.
Will already recorded?
Yes. You will be affected by going. My mother and my wife left heaven for long back.
Where?
In will second paragraph.
I am 2 sons. Itna. Second paragraph of the will.
Will first page. I am 62 years old. Last line.
And sound mind, but have keeping indifferent health. I have my 2 sons, Abhishek, so and so.
2 daughters.
2 daughters, so and so will be entitled to succeed my property.
My mother
and my wife left for heaven long. Yes. Where is the affidavit? Abhishek Gupta. P. Agrawal. Abhishek Gupta. Vipin. Where is the attesting witness?
Bansi Nayak.
Bansi Nayak. So appearing for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 27th of January 2013, executed by the testator Jai Bhagwan Gupta. Counsel for the petitioner submit that the testator has executed his last will and testament by appointing the petitioner as his sole executor while possessing good health and fit state of mind. Full stop. The petitioner submits that the testator died on 15th of October 2015, leaving behind his 2 sons and 2 daughters. He submitted the wife of the testator was the predeceased, and the same is also recorded in the will of the testator. Full stop. Counsel for the petition submitted. All the 4 legal heirs have submitted their affidavit of consent, stating that they have no objection for grant of probate. Full stop. The counsel for the petition submitted. One of the attesting witness, namely Bansi Nayak, has also filed his affidavit stating that the testator has executed his last will and testament in his presence and in presence of another attesting witness by appointing the petitioner as his sole executor while possessing good health and fit state of mind. At the learned counsel for the petitioner peruse the original will, death certificate of the testator, affidavit of consent of all the legal heirs, and affidavit of the attesting witness. This court find that all the legal heirs have categorically stated in their affidavit that they have no objection for grant of probate to the petitioner of the last will and testament dated 27th of January 2013. The attesting witness in his affidavit has also stated that the testator has executed his last will and testament in his presence and in presence of the another attesting witness by appointing the petitioner as his sole executor while possessing good health and fit state of mind. In the will itself, it is recorded that the wife of the petitioner, wife of the testator, was predeceased to him. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate. Accordingly, the department is directed to issue probate of the last will and testament dated 27th of January 2013 on completion of all formalities. At the time of grant of probate, the copy of the will be made as a part of the probate. PLA number so is disposed of. Next.
I beg to appear on behalf of the petitioner.
Yes.
An application for grant of probate of the testatrix Chameli Bashu, my lord. Will in favor of her sister, and the deceased had no class 1 legal heirs. So accordingly, my lord, general citation and paper publication was also made. And one consent affidavit was also filed by one of the brothers, one brother who is the legal heir, class 2 legal heir. As there are no class 1 legal heir, it is reflected in the will itself.
Where is the will?
Yeah, it is after page 11, my lord. Annexure A.
Handwritten will.
Handwritten will.
What is the date? 13 February 2015.
13 February 2015.
Where is the name of the test executor?
Now, kindly the last page, my lord, see. Um, I do hereby appoint Mrs. Shunanda Mitra as the executor of this will.
I do. Which line?
Just in witness whereof, just above in witness whereof, after Calcutta 700664, I do hereby appoint Mrs. Shunanda Mitra as the executor of this will.
This will. Sunanda Mehta is the petitioner here?
Yes, he is the petitioner and the sister.
When he died?
The testatrix died on
Testatrix.
testatrix.
Died on 17 June.
17 June 2018.
And the date of will is 15.
Yes, my lord.
And husband?
Husband predeceased her.
2003.
2003.
No issue.
No issue. It can be seen in the will, my lord. Kindly see the top page of the will. The undersigned Chamili Basu, wife of and sole heir to late Dr. Dev Kumar Basu, having no issue.
Yes. How many attesting witness?
Only one attesting witness, Mohinshmoy Mitra.
Manishmoy Mitra. Sensation suffering for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 13th February 2015, executed by the testatrix Chameli Basu. Testatrix Chameli Basu, who died on 17th of June 2018. 2018. Counsel for the petitioner submit that the husband of the testatrix was the predeceased to the testatrix who died on 4th of August 2003. The petitioner submit that there was no issue in the wedlock between the testatrix and her husband. The petitioner has disclosed the name of the other legal heirs, though they are not the class 1 legal heirs, that is the brother and sister of the deceased, out of which one of the legal heirs, namely Utpal Krishna Ghosh, has filed his affidavit of consent stating that he has no objection for grant of probate of the last will and testament to the petitioner. Full stop. Counsel for the petitioner submit that citations were issued, but in spite of receipt of the citation, in spite of issuance of citation, none has come forward to file any caveat. Accordingly, the department has submitted no caveat certificate, certifying that no caveat has been entered against the grant of probate of the last will and testament. Full stop. Consider the submission made by the counsel for the petitioner, perused the original will, death certificate of the testator, death certificate of the husband of the testator, affidavit consent of one of the legal heir, that is the brother of the testatrix. Testator नहीं आएगा जहाँ भी है testatrix होगा. Testatrix, report caveat report, no caveat report filed by the department, and the affidavit of consent, affidavit of the attesting witness, and the affidavit of consent of the another legal heir. Full stop. This court find that full stop. Considering the above, full stop. Considering the above, this court find that in the will itself, it is mentioned that the testatrix has no issue, and the husband of the testatrix was the predeceased to the testatrix who died on 4th of August 2023. This court find that one of the attesting witness, namely Manishmoy Mitra, in his affidavit categorically stated that the testator has executed his last will and testament in his presence while possessing good health and fit state of mind, by appointing the petitioner as the executor of his last will and testament. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate. Accordingly, the department is directed to issue the probate after compliance of all formalities. At the time of grant of probate, the copy of the will be made as part of the probate. PLA number and disposed of. Next. None appears on behalf of the petitioner. No accommodation is sought for. Let the matter go out of the list. Next.
And for the petitioner.
Yes.
Not will dated 4th of September 2010.
Where is the will?
Annexure B, my lord.
What is the name of the testator?
Rajnikanta Patro.
Rajnikanta Patro, yes. Who is the executor?
Gautam Dev.
Yes,
Executor and beneficiary. Gautam Dev.
Executor, yes. When he died?
Rajnikanta Patro died, my lord, on 11th of January 2014.
Where is that? What is the date of the will?
Date of the will is 4th of September 2010.
Yes. When he died?
11th of January 2014.
Where is the death certificate?
Annexure A.
11 January 2014. Yes. How many legal years?
No, years are at paragraph 4 of my application.
1, 2, 3, 4. 6 legal years.
Yes, my lord, out of which, my lord, all were served. There was thereafter, as there is an order, my lord, dated 5th of September, 5th of August 2024, my lord. It will speak for itself. The cited parties 1 and 2 received, and the others did not receive. So there was general citation and paper publication was issued as according to the order, and accordingly it was done.
No caveat filed.
No caveat filed.
What about the attesting witness?
An attesting witness is Sopon Patro. He has already given, executed the will and has proved the attesting witness.
Where is that?
And my lord, if you see the will, the last attesting witness is Sopon Patro.
Sopon Patro. Attesting witness.
Yes, my lord.
How many attesting witnesses have filed the affidavit?
There were 3 attesting witnesses, my lord.
All are filed.
Only Sopon Patro has filed, to the best of my knowledge. Why?
सपन पात्र ये देखो सपन पात्र का एफिडेविट है ऐसा नहीं हो तो रिटर्न है
Maybe, my lord, there are 3 witnesses: Kamal Shoulder, Gobindo Ben. Gobindo Ben, maybe. Gobindo Ben, my lord. I apologize, my lord.
Okay, one last one.
It should be Gobindo Ben.
You don't know who has filed the affidavit?
Yes, my lord, Gobindo Ben. It was Sopon Patro came to file, but my lord, Gobindo Ben has affirmed this. There are 3 attesting witnesses. Gobindo Ben has affirmed.
No.
Malay
Biswas is there. Malay Biswas affidavit is there.
Can I inspect the record once, my lord?
So appearing for the plaintiff. So appearing for the petitioner, not the plaintiff. The petitioner has filed the present application by grant of probate of the last will and testament dated 4th of September 2010, executed by the testator, namely Rajnikanta Patra, wherein the testator has appointed the petitioner as his sole executor of his last will and testament. Full stop. The testator died on 10th of January 2014. What about the wife?
On 11th of January, my lord, died.
11th of January.
My lord, died predeceased, my lord.
Where is that? Where is it is mentioned?
It is given in the will, my lord.
Full stop. The wife of the testator, where it is?
The second paragraph, subject to correction. I don't have the copy of the will with me, that is why, my lord.
You are appearing and you are not having any brief.
No, my lord,
You are
it
not
is
having
there.
the
I
bill,
don't
you are
have
not
the-
having the affidavit, you are not having.
No, I don't have the
And
copy
you are
of the
taking the shelter of the clerk.
No, I don't have the copy of the will, my lord. I apologize for it, my lord. Only this file is missing. That is why, my lord.
Show me where it is mentioned that she is the predeceased. ये मनोतोष तुमने रिक्वेस्ट नहीं दी ना चेंज करने के लिए Give me.
There is no such averment.
Then, and in your application also there is no averment.
My lord, in my prayer, in my application, there I have made, my lord.
Huh?
I'll just show, my lord.
The mother of the testator has already expired. Where is the wife?
Can it be not today, my lord? I will explain it to you better.
Not today. As per the prayer made by the counsel for the petition, case adjourned. Let adjourn for the day. Next.
Lordship, I am for the petitioner, Lordship. My lord, the testator, my lord, died on 11th of August 2011. Lordship.
Where is the will?
Lordship, it's a Bengali will, my lord.
Not translated?
Yes, translated copy is also there.
What is the name of the testator?
Testator's name is Tarapada Bose. And my lord will see the translated copy at
Tarapada Bose.
Yes. My lord,
Then
translated
Basu
copy.
or Bose?
Bose, Basu, my lord, in Bengali.
Huh? No,
Bosu,
but
Bosu.
your application kindly see in application the first.
Now, I have already written Bose alias Tarapada Basu.
Okay. Then what is the name of the executor?
Executor, the wife was initially named as the executor.
Where
But
it
the
is?
wife
Where
predeceased.
it is?
I'll show, my lord. My lord, in page 17, kindly come
Appoint
to page
my
17.
wife.
Yes. Sneho Khana,
Basu as
Basu.
the sole executor. The executor after my death shall be given decision. Fails to become incapable of performing duty, the executor is necessary. My elder son Sriman Asim Kumar Basu.
Is
Shall be
the
considered.
present executor.
So
Lordship, I have
who has
made-
filed it? Asim
I-
Kumar filed.
Yes. Asim Kumar Basu has filed the petition.
When he died? 1st August 2011.
Yes.
And that what is the date of the will?
Will is, my lord, it's Bengali, 4th Shravan 1395. My lord, it's corresponding to 20th July 1988.
20th July
1988.
1988.
Yes, Lordship.
And when he died?
He died in 2011.
Yes. How many legal years?
My lord, I have stated
No,
this.
when he died? 2010.
Yes.
No,
He
wife
died
died
on
2010.
11th of August 2011. Lordship.
Correct. Wife died on?
Wife died on, my lord, I have
9/9/2010.
stated this in paragraph number.
Okay. Then?
I've stated this.
Yes, it is there. And How many legal heirs?
My lord, legal heirs are there at paragraph number 8, my lord.
Sons and daughter.
My lord, all have consented, my lord.
Where is the consent?
Consent affidavit to the judge. Consent affidavit.
Affidavit of attending witness. Attending witness.
Yes. My lord, in this case, my lord, both the attesting witness have passed away, my lord.
Then attending witness, you have to buy solemn form.
Yes. So if lordship desires, my lord, I can produce the attending witness.
will be
Who is
better.
the daughter? Who is the daughter? She has also consented to the grant.
See, Faguni.
Yes. Lordship will kindly see the will once. At paragraph 18, my lord, the signature of his father is there, and she says that I agree to the direction given by my father in the will. On that basis, my lord, she consented.
So and so appearing for the plaintiff, petitioner. So and so appearing for appearing. The petitioner has filed the present application for grant of probate of the last will and testament of the testator Tarapada Bose, alias Tarapada Basu, dated 20th July 1988.
My lord, Bengali date should be mentioned. Otherwise, my lord,
Bengali date लिख दो.
4th Shravan, 1395.
4th Shravan, 1395 within bracket BS.
Yes, lord.
The counsel for the petition submitted. The wife of the testator, the full counsel for the petition submitted. Though the testator has named his wife as the executor, as the executrix, but she died on 19/9/2010, and as per the said will, the petitioner has become the executor of the last will and testament. Counsel for the petition submitted. The testator died on 11th August 2011, leaving behind 3 legal heirs, that is 2 sons and 1 daughter, out of which the petitioner is one of the legal heirs. Counsel for the petition submitted that the testator has executed his last will and testament in presence of 2 attesting witnesses, but both the attesting witnesses have passed away, and the daughter, namely Faguni Datta, has filed her affidavit of consent as well as affidavit as an attending witness of the will, stating that her father has executed his last will and testament in her presence by appointing the mother, and after the death of the mother, the brother has become the executor, and the father has executed his last will and testament while possessing good health and fit state of mind. Counsel for the petition submitted. The other legal heirs have also filed their affidavit consent, stating that they have no objection for grant of probate of the last will and testament of the testator. Had the learned counsel for the petition produced the original will as well as the translated copy of the will, death certificate of the testator, death certificate of the wife of the testator, affidavit of consent of the legal heirs, and affidavit of the attending witness. This court find that the petitioner has proved the will and is entitled to get the probate. Accordingly, department is directed to issue probate of the last will and testament dated 20 July 1988 within Bangla mein likh dena, 4th Sarvana 1395 BS. At the time of grant of probate, the copy of the will be made as part of the probate. PLA number 7 disposal.
Grateful.
This has come at my instance. I mentioned the matter, that's why it's come. But the probate application was amended by an order dated 1st October 2024. Well, the only problem is, well, there were two of the executors. Only one of them is reaffirming. So I was praying for leave, my lord, to allow one of the executors to reaffirm.
Or
Well, the probate application, the amended probate application. Your lordship,
what is the order? What is the order?
the order is of 1st October 2024.
Amendment.
Amendment has been allowed. Amendment carried out also. Only thing, my lord, now that the amended probate application has to be brought on record, my lord, the reaffirmation, if your lordship takes the application, my lord, page 16 of the application, your lordship will find, my lord, the reaffirmation, the re-verification
Page 16
of the application. It's a
GA.
disposed of application, actually, my lord.
GA.
The GA1. It's a disposed of application.
Yes.
GA1, if your lordship takes page 16, well, page
Harishvardhan Lodha.
only Harshvardhan Lodha will. Well, this is the grandmother. R.S. Lodha's mother's will, my lord.
Yes.
R.S. Lodha's mother, there is no dispute here.
Uh-huh.
In fact, my lord, the two attesting witnesses, they've already done their deposition, my lord. Their examination is over. The executor, Harshvardhan Lodha, was in the box. At that point of time, my lord, the court found, if your lordship takes page 8 of the application, my lord, it's a lost will. The will is lost. So, my lord, the grandson had lost the will. So, the court wanted that averment to be there in the application itself. That is what we
So
have.
amendment is allowed.
Amendment has been allowed.
What is the
Only
law?
Harshvardhan Lodha, there were Harshvardhan and Aditya Lodha, the two
Both are-
brothers. Aditya is one, he does not live in Calcutta. So, therefore, only
Harshvardhan
one
Lodha wanted to be a
will be reaffirming. That's all. Re-verifying. Only instead of two of the executors, only one will re-verify. If that leave can be granted, my lord. That is all, my lord. It is not being contested. It is, if that leave can be allowed.
So and so appearing for the petitioner. Counsel for the petitioner submitted by an order dated 1st October 2024. This court has allowed the amendment in the probate application. Counsel for the petitioner submitted. There are two executors in the will, but one of the executors is out of India, and as such, it is not possible for one of the executor to reaffirm, re-verify the affidavit in the amended application, and seeking leave to allow one of the executor, namely Harshvardhan Lodha, to re-verify and reaffirm the affidavit of the amended application for grant of probate. Consider the submission made by the counsel for the petitioner. Full stop. Leave is granted to re-verify and reaffirm the affidavit of the probate application by Harshvardhan Lodha.
Well, only re-verification. There's no affirmation. It's
Only
re-verification.
affidavit kar dena. To re-verify the verification. Amended probate application by Mr. Only by Harshvardhan.
My lord, another prayer, my lord. If any date can be fixed, my lord, for Harshvardhan Lodha's deposition to be complete. He's already in the box.
You do one thing, you complete it, you mention, I will fix that.
My lord, amendment is carried out. It's only the re-verify. I'll do one thing, my lord. As soon as it's done, I'll come and mention, my lord. I'm obliged.
Great.
My lord, item number 55. I appear for the petitioner applicant, my lord. My lord,
What is the application?
Application is under 283.
Ah.
My lord, the petitioner, the testator had 3 first-class legal heirs. The wife and
Belapur.
Yes, my lord. If my lord strictly comes to the petition, my lord.
Raigad.
2 districts under the state of Maharashtra, Thane and Raigad. My lord, 8 properties are distributed over there, and for which my lord 283(3) needs to be complied, but my lord has expressed my lord's view in several other applications prior to this that when there is no person
Okay, I am allowing a prayer A and B.
My lord, no. My lord, I'm relying on Ravindra Shekhar Prasad's order, my lord. And we'll be praying for paper publication in those two districts, my lord, instead of
Paper publication is correct, but sometimes it's difficult. Let the district, if it is not completed, then I will allow the prayer.
my lord, that will even further lengthen the process, my lord. Why? Because there are no other living heirs or anybody in those two districts except the legal heirs in this will. My lord, all the legal heirs are the three granddaughters, two sons, and the wife. In fact, the entire estate has been distributed between them equally, and in fact, the daughter-in-laws are also beneficiaries to this will. So, my lord, the entire property has been.
So what you want?
My lord, I am praying for that there's a direction for paper publication in these two particular districts as per the the contents that to be issued by the departments, my lord. So that I can
But
come
where,
back
what,
with
what are the papers?
newspaper publication, my lord. The widely to circulated local and the
That is a different in the Maharashtra. This code has faced two, three cases in problem. What are the papers in Maharashtra in Marathi language and in English language and Hindi language?
My lord,
What are the papers?
kindly grants me a passport, my lord. In 2 seconds, 2 minutes, I'll come back and my lord appraise, my lord. My lord, kindly grants me a passport, my lord.
Yes, next.
My lord, I am appearing on behalf of the executor petitioner.
Yes.
Executor is the brother of the testator. Testator died. His your lordship will find the will.
Where is the will?
Your lordship will find the will at after page 9.
Mahavir Prasad Khandelia.
It is a registered will. It was registered at Additional District Register, Srirampur, Hooghly.
Where is the name of the executor?
Executor, your lordship will
Khandelia.
find at page 2 of the will, almost at the end of the first page, second page. I do hereby appoint my brother, namely Sri Ishwar Khandelia.
Ishwar Khandelia, son of so Indian resident.
He resides at Chhattisgarh.
A sole executor.
Yes.
In the event of death of my executor, the will prior to my death or prior to the take probate, my son Imanshu. So Ishwar has filed this.
Yes.
Ishwar has filed this.
Yes.
Then how many legal and what is the date of the will?
Date of the will, your lordship will find at the bottom of the will.
26th of August 2014.
Exactly.
When he died?
He died. He died, your lordship will find the death certificate. He died on.
Where is the death certificate?
22nd April 2019.
14 will, 19 died.
Died.
Yes, where is the legal heirs details?
Legal heirs, your lordship will find in the petition at page 5 of the petition.
First is the wife.
Wife has died in between the period when the will was made and when the application was made.
Where you mention?
I have mentioned.
Acha, died on 25th of January.
Yes.
Okay, then daughter of the testator.
Two daughters were there and the only son. All the properties have been given to the son, Himanshu Khandelwal.
So two daughter, one son.
All have given consent. All have given consent, and I have stated why the application was a little late. At para 3, the testator died on 22nd April 2019. The will was made on the will was dated 26th of August 2014. Was lying in an old almirah of the testator, which was remained closed for a long time and was opened and found out above will and handed over to your petition on 9th November 2022. And the probate application was filed in 2023.
So appearing for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 26th of August 2014. Full stop. The petitioner and the testator died on.
Testator died on.
The testator died on 22nd April 2019, leaving behind 4 legal heirs, wife, 2 daughters, and 1 son. Full stop. Counsel for the petition submitted that after the death of the testator and before filing of the present application, the wife of the testator died on 25th of January 2022. Counsel for the petition submitted. All the legal heirs have filed their affidavit of consent, stating that they have no objection for grant of probate to the petitioner.
No caveat is filed out.
Huh?
No one has.
As per the will executed by the testator. Counsel for the petition submitted. One of the attesting witness, namely Ramesh Kumar Agarwal, has also filed his affidavit, stating that the testator has executed his last will and testament in his presence and in presence of another attesting witness while possessing good health and fit state of mind, by appointing the petitioner as the sole executor. Had the learned counsel for the petitioner perused the original will, death certificate of the testator. You are not enclosed the death certificate of the wife.
Wife, I have not, my lord.
Testator. Full stop. Full stop. The certificate of testator, affidavit of consent of 2 daughters and the son, affidavit of the attesting witness. Full stop. It is fine from the record. The wife of the testator died after the death of the testator, but before filing of the present application. The legal heirs in their affidavit have categorically stated that they have no objection for grant of probate to the petitioner in terms of the last will and testament of the testator. The attesting witness in his affidavit has categorically stated that the testator has executed his will in his presence and in presence of the another attesting witness while possessing good health and fit state of mind, by appointing the petitioner as his sole executor. Had the learned counsel for the petitioner perused the will, death set. वो तो बोलती है ना. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate. Accordingly, the department is directed to issue probate to the petitioner of the last will and testament dated 26th of August 2014 on compliance of all formalities. At the time of grant of probate, the copy of the will be made part of the probate. PLA expenses and disposed of. Yes. Next.
Yes, my lord, I am for the grant of probate, my lord.
Yes.
Testator, my lord, Rabindranath Bose, will dated 28th of March 2006, and died on 9th of October 2018.
Will dated?
28th of March 2006.
28th March 2006 or 2005?
No, at after page 8.
Yes, kindly come the last page of the will. 28th March 2005.
Yes.
Then 6 you're telling.
2005.
How many witnesses?
No, only one attesting witness, Jayanti Kumar Shamul. There are no legal heirs. It can
Just
be
a
seen.
minute, just a minute. 2005, when he died?
Died, my lord, in the year 2018. 9th of October 2018.
18. When you filed the suit? When the file application? 23.
23, my lord.
After 5 years. Where is the justification?
Yes, my lord, in my application I have
Where is
stated.
the name of the executor?
At page 2 of the will. I appoint Vishwaranjan Senapati. Page 2 of the will, my lord, at the top of the top.
I appoint Vishwaranjan Senapati.
And he is the applicant here.
He is the applicant here. Yes. How many legal heirs?
There are no legal heirs, my lord. It can be seen from the will itself. Kindly come to the will, page 1. Second, the fourth paragraph, my lord, I have my house to live in and reside. My wife has already expired. I do not have any issue.
Then
My lord, there was general citation and paper publication was made, and all formalities been complied with, no caveat.
where is the no caveat certificate?
It is as per the department's report, it will be there.
There is the affidavit of attesting witness.
Yes, there is a attesting witness by Jayantu Kumar Shamal.
Jayanta Kumar Samal.
Yes, ma'am.
Consensus opening for the petitioner. The petitioner has filed the present application for grant of probate of the last will and testament dated 28th of March 2005. The testator died on 9th of October 2018. In the will, the testator has stated that his wife has already expired and he do not have any issues. Counsel for the petition submitted that the special as well as general citations were issued, but none has appeared or file any affidavit or file any caveat or affidavit in support of caveat. Counsel for the petition submitted, the department has submitted no caveat certificate certifying that no caveat has been entered against the grant of probate of the last will and testament. The one of the attesting witness, namely Jayanto Kumar Samal, has filed his affidavit stating that the testator has executed his last will and testament on 28th of March 2005 in his presence and in presence of the other attesting witness while possessing good health and fit state of mind by appointing the petitioner as his sole executor. Had the learned counsel for the petitioner produced the original will, death certificate of the testator, certificate of the department, no caveat certificate of the department, and the affidavit of the attesting witness. The attesting witness in his affidavit has categorically stated that the testator has executed his last will and testament in his presence while possessing good health and fit state of mind in presence of another attesting witness by appointing the petitioner as sole executor. The certificate issued by the department certified that no caveat has been lodged. Considering the above, this court finds that the petitioner has proved the will and is entitled to get the probate. The department is directed to issue probate of the last will and testament dated 28th of March 2005 on compliance of all formalities. At the time of grant of probate, the petitioner and the copy of the will be made as part of the probate. PLA number so and so disposal.
Grateful.
Yes.
My lord, so far the GF4 is concerned, my lord, I was supposed to file my affidavit in reply, my lord. Affidavit in reply, my lord, was prepared, my lord, beyond the period, my lord. And my lord, I am told by my learned friend, my lord, it was served today to him. My lord, anyway, my lord, I can press my application, my lord. My lord, the affidavit in reply, my lord, contains only email exchange between the parties, my lord.
But it
My
had
lord,
to be served. So,
yes,
my lord,
my lord,
today
I
morning, the
apologize,
day
my
when
lord,
the
to
matter
that.
is fixed, the affidavit is being served. But if your lordship does not consider the affidavit, I can make my
I
submission.
will not consider.
Very.
If they have not filed appropriate within time.
Within the time, this
My lord,
matter was
kindly,
fixed for
my
a
lord,
day back.
kindly look, my lord, I had some difficulty, my lord. My client was not here, my lord. This was the reason, my lord. And my lord, kindly look at the affidavit in reply once, my lord. I extend because, my lord, here what has happened, my learned friend has denied the existence of contract. He said that it was not signed by you, it was not given to you. In my application, I have stated the sequence of event. His only denial is that it was not signed by you and the document was digitally signed. It was not manually signed. And I relied upon the digitally signed document. It was signed through DocuSign application, my lord. My lord, so and in my affidavit reply, I only annex the trail mail, my lord, demonstrating that how this document was sent to me and how I have signed and how it was sent to them. This is the only thing. And the second document, my lord, I will place that the plaintiff is not a Indian company. It is controlled promoters are foreign entity. 80% of the shareholders are controlled by foreign entity. And I did not have any contract with the plaintiff directly. Whereas in the case they have made out that the goods were sold and delivered to them, to me, as per the contract. Where I have made out the case that I did not have any contract with them. The contract was a company, Flint, Netherlands company. He gave me distributorship and the goods were supplied as a selling affiliate. The plaintiff is herein is the selling affiliate. Goods was supplied through him. Whereas
May I only interject
whole,
once more? If learned friend wants to make his submissions, he can.
one line submission.
I have not understand what you want to make.
Yes, my lord, if my learned friend wants to make his submissions on GA4 and 5, he can.
Today is fixed for what?
Hearing of GA1, 4 and 5. 1, 3, 4 and 5.
I'm ready, my lord. My lord. Otherwise, my
K
lord,
1, 4 and 5.
1, 3, 4 and 5.
all applications, sir.
All application. What is the one?
1 is my application for injunction.
Yes. What is
and
3?
3 is for judgment on admission, my application.
Yes. 4.
GA4 is for under section 8 filed by the defendant. GA5 is for production of the arbitration agreement.
Filed by you.
Yes.
Filed by you.
Yes.
No, GA4 and 5 filed by the defendant.
5 filed by you.
No, 4 and 5
4 and
filed by
5
me.
by the
My lord,
defendant.
5,
That's
my lord,
why.
for only 8-3, my lord, production of original, because I did not have copy. I requested them to supply, they did not. So I filed an application because the provision provides.
So now what is the problem?
My lord, I am otherwise ready. Only my lord, this is a lacuna from our part entirely.
What?
My lord, the reply was filed by but anyway, my lord,
The day
my
the
learned
matter
friend
is
can
fixed,
deal with
my learned friend serves me in the morning the reply.
learned friend
My lord, I do not have any
deal-
difficulty.
What you filed?
affidavit in reply, my lord.
When you filed?
My lord,
It's not filed.
I will be
it's
filing
served.
In which application?
My lord, GA4 and 5. 4 is relevant, my lord. 4 is relevant. 4 is relevant. My lord, my learned friend can respond to the reply documents and appended to the reply on a
I
letter
have to
date.
take instruction on that. Today, my lord, the matter is fixed. I would have hoped, my lord, we all could conclude the matter.
My lord, in the reply, my lord, I have annexed the color printout of the email exchange so that your lordship can see what had happened.
Within a week from date.
Yes, my lord. My lord,
reply within a week.
It was not
November
done, my lord.
29.
It was not done.
So
It was not done.
So today, if you're submitting that, okay, I am adjourning the matter. Sign it, I.
My lord, I am not seeking adjournment, my lord. My lord,
He could get an opportunity to go through your application, sir.
Yes.
Then?
That is true, my lord. That is true. That is true.
Then
That is true.
once the court has fixed the matter,
My lord,
fixed the matter, it
I-
is your duty.
I understand, my lord.
Yes, what is the submission?
My lord, I can make my submission on my lord, without the reply. I can make my submission. My lord, on all the applications I
You
can.
want to rely upon a reply?
Yes, my lord, I have.
Oh, then I am accepting a reply. Serve the copy subject to payment of cost of 25,000 in the State Legal Service Authority. I will fix a date for hearing.
My lord, kindly consider the cost.
Because see, now I will adjourn this matter. Nobody is here. What I will do from 2 to 3.
Yes, my lord, I know that.
What
my
the
lord,
court will do from 2 to 3.
I understand, my lord.
The other advocates have been not given an opportunity. All the persons are asking the time, but due to the fixing of the time, I am not giving the other date to the other advocates.
Lord, may I?
My lord, maybe proceed today. My lord, I'll try and my lord, I'll consider the reply once.
No, if you are wanted to rely upon, no problem. And you wanted to, you can argue the matter. Then the court is not standing on the way.
But it is my lord, in the interest of the court and the bar, my lord, I can proceed, my lord. I'll try and my lord, go through the reply once. My lord, if it is possible for me to gather what has been stated in the reply, I can respond. But my lord, otherwise, my lord, I have to take instruction, my lord.
Then
That is the
when
difficulty.
you are
I'm facing.
disclosing the document, he has to take instruction from the client.
My lord, may I proceed with the facts, my lord, in the meantime, my lord?
So it will not be completed today.
My lord, I leave it to your lordship, my lord. It is entirely our fault, my lord. I cannot make any excuse.
So already an undefended suit.
No, it is, my lord, my demurrer application filed within the period of limitation.
What is the deferral application? GA3?
Yes, my lord. Reference of
No,
disputes.
GF4.
GF4.
GF4 is application for reference of disputes to arbitration.
Yes. Because the disputes are covered by arbitration. And in the opposition, my lord, they have not disputed the fact that they have a relation with the foreign company, Print Netherlands. They have accepted. I will show paragraph 5, my lord. It is most the whole facts were admitted, save and except that it was not signed, it was not sent to us. Only this is the thing. So that is why reply is important, because I have annexed all the documents.
So if the reply is important, why you have not filed within 1 month, 29th November? Now we are on January 5, 6.
My lord, here, my lord.
So
I'm totally at fault.
And the vacation starts on 25th. That is also 1 month was there before the vacation.
Some lacuna, my lord.
And after the vacation, also 1 week has been passed. And you are also not informed the other side.
My advocate on record was served it to him last week, my lord.
Last week?
On Friday, my lord, but
No,
I'm
served
told-
today morning at 11:45.
He was supposed to send you.
She was supposed to. That is a difference.
It was prepared last week.
Let's start. What is the GA4?
Yes, my lord. My lord, kindly take my application, my lord. Lord, may I just precisely say, my lord, what is the case about, my lord? Then I will refer the, my lord, the relevant documents. My lord, here, my lord, what has happened, my lord? I was engaged as a clearing and forwarding agent directly by the plaintiff in 2013, 2014, my lord. I have annexed the document. I will show it to your lordship, my lord. Being a clearing and forwarding agent, my job was to only supply against a remuneration fixed by them, not otherwise. I was not entitled to deal with the customers. I was acting as an agent under the plaintiff. This contract, my lord, was continued till 2018. Now, in 2018, they issued a letter. In fact, prior to 2018, there was a discussion. They wanted me to appoint as a distributor in the region of West Bengal to supply the products of not the products of the plaintiff. The products belongs to a American company that is called Flint Group. It has a group of companies all over the world, and the plaintiff is a selling affiliate of the Flint Group, my lord. That is a USA company. Now, distributorship offered to me for supply of their goods in the state of West Bengal. That was offered to me in 2019. I accepted the offer. Now in 2019, once I agreed of their proposal to become a distributor, they cancelled the clearing and forward agent agreement that was signed in 2014, and I entered into a contract in 2019
with plaintiff.
Not directly with the plaintiff. In the contract, they were addressed as a selling affiliate in the territory of India.
So, with whom you entered into an agreement?
Flint Group of Netherlands. Flint Group of Netherlands. I entered into an agreement with them. Now, immediately after the earlier agreement was cancelled, and I started doing distributorship assignment with the. Now, what has happened in 2019? Manual contract was sent to me. I signed it and sent it to the. I sent it to the plaintiff. Plaintiff obviously forwarded. He was supposed to forward it to the Netherlands company. Now in 2020, April 2020, and in the meantime, there are correspondence, my lord, I have referred in my reply. My lord, I repeatedly asking for supply of the contract copy. They did not. In the month of April 2020, plaintiff wrote to me saying, no, I'm not getting the copy, you have to sign it again. And they have forwarded the contract through an email, and in the email CC, the representative of the Netherlands company was also there. In fact, Netherlands company insisted the plaintiff to render the agreement, otherwise I cannot carry out the distributorship business with them. And they have in fact blocked my distributorship for the temporary period. When the document was sent to me, they insisted me to sign through DocuSign app. It's a digital way, my lord, where both the parties will sign digitally. I have annexed the digital copy of the. Now I have signed the document and forwarded to the through plaintiff on 30th May 2020. Now before signing the contract, my lord, I have raised certain issue. I said communication will show, my lord, I disputed as regards to the clause of arbitration. I said that you are asking me to do an arbitration in Amsterdam, whereas I'm carrying on business here. Your entity is also in India, so please modify the clause, because the governing law of India and arbitration should be held in India. They did not agree. In fact, I will show the response of the plaintiff representative saying, no, we are bound by the instruction of the Flint Group. That's a global company, and you have to obey whatever the terms set forth by them. We cannot do this, and you have to agree with that only without seeking any modification. These are the communications. I ultimately signed through the app on 30th May 2020 again. That copy I have annexed the digital copy. The app also shows that both the parties have signed it. It was sent. So this is the summary of, my lord, as regards to the formation of the contract also. My lord, the contract contains arbitration clause. I will refer, my lord. Now, my lord, in my petition, my lord, I have precisely stated in these fashions that how I came into the picture. And interestingly, my lord, I have annexed the clearing and forwarding agreement that was executed by the plaintiff. It also contains arbitration clause, but it was in India. Now, in the plaint case, what they have said, they did not disclose about the existence of any of the agreement. They simply said they have annexed in the plaint invoice, delivery note, and purchase order. These are the three documents relied by them. And I will also show it from the record, my lord. It is annexed in the plaint. They have issued a demand notice to me in 2022 by their advocate, where they recognized me that I am their distributor. Now I will show from the agreement, distributor agreement, I will also show that in case of termination of the contract, the plaintiff is not entitled to recover any money from me. They are empowered to only recover the goods. If I had paid the money, then in that event, they will take back the goods from me and refund the money. But the contract strictly says that without the distributorship agreement, I cannot carry on any business. This is the clause. They don't have any right to seek recovery of money, because it can only be done by the Flint Netherlands or not otherwise. Now, this is in this background, my lord, the plaint was filed. My lord, I filed my I filed GA4. Now, my lord, in the affidavit in opposition, my lord, there are 5 specific grounds of objections taken by the defendant, taken by the plaintiff. What is the first ground? The first ground, no concluded contract on the premise that it was not signed. They have, although they agreed their relationship with the foreign company, they also agreed that the contract was forwarded to me, because they did not dispute the communications, they did not dispute the document. There is no dispute as regards to that. What they dispute, that they said that you have not signed it, or rather the specific statement in the affidavit in opposition is that I have not received the copy. The plaintiff has not received any copy of the distributorship agreement. Now, second, they said that this is undated document, an unsigned document. Third objection is this cannot be construed an agreement under the definition of Arbitration Act. Fourth, plaintiff did not receive the contract. Fifth, it is not concluded. So this is the objections. Now, my lord, kindly take my application, my lord. And in my reply, my lord, I have since 2019, when the distributorship, when the distributorship was offered to me, I have annexed all the documents. Then when it was, how it was 2019, it was done. Then when I sought for supply of copy of the contract signed by me, in the month of April, how the foreign company representative seeking seeking deposit of the agreement signed by my distributorship agreement to the plaintiff. Then plaintiff approached me. Then they sent me the copy of the digital copy of the agreement. They also made an arrangement that very well, you require only internet connection, you sign it. You don't need to sign it manually, you sign it through digitally. These are all part of the communication, my lord. In my petition, my lord, I relied upon 2 communications, my lord. I did not anticipate that the plaintiff will straight away brush aside the existence of the contract. I did not anticipate it. But since they have taken these ground, my lord, I was compelled to sit with my client and sort all the correspondences, and my lord, I have placed these documents.
If there is no agreement, you have not disclosed the agreement.
I have disclosed it, my lord.
Where is the agreement?
My lord, kindly come to the distributor agreement, my lord, is annexed at
The
page
agreement
140.
on the basis of which you filed an application under
Yes,
section
page 140, my lord. It is appearing at page 140 of GA4.
Yes.
Yes, my lord, kindly see at the top, there is an envelope ID at the left. DocuSign envelope ID number is there. Then, my lord, kindly see the parties' descriptions are described. Now, my lord, kindly see, my lord, at page 142, subject matter, article 1, subject matter of the agreement. My lord, all the pages are, my lord, numbers are there at the top. These were sent through DocuSign app. My lord, kindly see how the parties were described. Subject to the terms and conditions of the distributor agreement hereinafter referred to as agreement. Flint, Netherlands grants to distributor a non-exclusive and non-assignable right to distribute the products listed in Schedule 1 as amended from time to time hereinafter so and so within the contractual territory pursuant to Article 1.2. The contractual 1.2, my lord, article, my lord, states the contractual territory.
Page.
My lord, 142, my lord, I am referring. My lord, 141, 140, my lord,
Whether
your
you are
lordship.
denying this agreement?
But I'm saying it was never signed. So there was no concluded contract and no reference can
That's
be made.
why. So where is the original?
The original is with them, my lord. It was signed digitally. So
You are having the original.
I don't. Well, that is my affidavit.
Denying.
You have to, because you have filed an application under Section 8.
Yes, my lord.
It
That is
your
why, my lord, my reply is, my lord, relevant. My lord. Because, my lord, in
reply is relevant. See, that is with regard to the evidence.
Yes,
correct.
yes.
Agreement. Now this is Section 8. Section 8, the court has to consider with regard to the agreement entered between the parties. Agreement contains the arbitration clause. Correct. These are the two things is to be considered.
Yes.
Now this is the agreement. Now you are telling that, and you have filed an application under Section 8. It is your duty to prove the agreement. Now they are denying with regard to agreement. What would be the situation now?
My lord, this is what, my lord, I will try to satisfy your lordship. There was an agreement, and the documents need not be signed by wet pen. It can be signed digitally also, and this type of execution of contracts are very normal outside the in the foreign country, and even in India also, my lord. Post COVID, my lord, this is natural thing, and my lord, as per the arbitration section 7 of the Arbitration Act, my lord, even, my lord, the section says that the arbitration agreement can be, my lord, through email or fax, anything could be.
Correct.
So, my lord, by communication, I will try to satisfy your lordship that they have accepted that the contract contains arbitration clause. They have also insisted me, and it is not the foreign company, it is the plaintiff, representative of the plaintiff, that who compelled me to know you have to agree to the terms only, and this will be the arbitration clause only. This is the part of the communication.
Okay.
My lord, kindly, my lord, may I refer the contract, my lord, once, my lord, because, my lord, here, my lord, I have also, I have to show that how they are selling affiliate of the Flint, Netherlands. My lord, at page 40, my lord, your lordship will see the descriptions of parties are there, and at the top left, DocuSign envelope ID is there at page 140, my lord. Now, my lord,
the agreement entered between Flint Group of Print Supply Platform BV.
Yes.
Correct.
Yes.
And who is the plaintiff here?
Is an Indian company.
Then?
But, my lord, I do not have any contract. They in the plaint, my lord, what they said, my lord, it was cleverly drafted, I can say only. In the plaint, my lord, your lordship will see the transaction. It's worth more than crores. And I will show, my lord, when they appointed me agent, when my scope was limited, they entered into a formal contract. The plaintiff himself entered into a contract.
That's, I am not on. You are relying upon 140.
Yes, my lord.
Page 140, page number 1. That is the first page of the agreement.
Yes.
Correct. That is entered between the Flint Group, Print Supply Platform BV, at Station Print 3-2, so and so, and SAS India.
SAS India. I am the SAS India.
SAS India, you are the SAS India.
Yes.
Where is that? That you are the defendant.
Yes.
Being the sole proprietor carrying the business under the name and style of SAS India. So with regard to the how you describe this party number 1, Print Group.
In my petition, I have said that they did not deny in their opposition. They have accepted it.
Where is that?
My lord, kindly come to, my lord, my lord, page 5. Sorry, paragraph 5, starting from page 3. My lord, may I refer few paragraphs? My lord, I will refer, my lord, only paragraph 6 and paragraph 5 once. My lord, the plaintiff has failed to disclose before this honorable court that the transaction and or invoices on which the reliefs are based are governed by a distributorship agreement that mandates dispute resolution through international arbitration. Despite the existence of this arbitration clause, the plaintiff has proceeded to file the present suit.
Hmm.
Now, my lord, kindly take their opposition side by side, my lord. I will refer my paragraphs, what I have contended and how it was dealt with.
Hmm.
My lord, kindly take their opposition to GFO.
GFO का opposition दो. Opposition. Yes.
My lord, paragraph 5.
Hmm.
Paragraph 5. My lord, paragraph 1 to 4 of my application, my lord, I stated, my lord, how I have served and what order was passed. So
Yes.
paragraph 5, my lord, was dealt,
Hmm.
my lord, at paragraph 5 of their affidavit in opposition.
Hmm.
My lord, in the affidavit in opposition, my lord, if your lordship considers the paragraph 5 of the opposition, my lord, they did not categorically dispute this. Now, my lord, kindly take paragraph 6 of my petition.
Hmm.
6A.
Yes.
Flint Group is a global establishment in the supply of products for the printing and packaging industries, hereinafter referred to as Flint Group. Here I am not talking about the plaintiff. The Flint Group has its headquarters located at 44 Esplanade. I mentioned the USA address. Operates more than 125 centers worldwide, including in India, where the plaintiff in the present suit operates as its selling affiliate. This factum was not denied by them. That they did not say that they are not selling affiliate of the Flint Group. My lord, this paragraph, my lord, dealt, my lord, at paragraph 6 of the opposition. Now, my lord, here your lordship will see 6A to 6G was dealt with.
Hmm.
Now, my lord, may I refer what is 6A and G, my lord, I have stated. Now, in 6B, here I have talked about the Flint Netherlands. Sorry, here I talked about the plaintiff. Flint Group India Private Limited, that is plaintiff herein, is a selling affiliate owned and controlled by the Flint Group, operating within its global framework. As a selling affiliate, the plaintiff is bound by the terms and conditions of the Flint Group, including the distributorship agreement at the center of the present dispute. The plaintiff operates under the direct control of the Flint Group, adhering to its global policies, standards, and decisions which governs its business, operation, and agreement.
So, kindly come to the B. Flint Group India Private Limited, the plaintiff herein is selling affiliate owned by and controlled by the Flint Group. No problem.
Yes.
Operating in the global frame.
Yes.
As the selling affiliate, the plaintiff is bound by the terms and how it can be?
Because, my lord, the contract provides that.
That's where is the contract?
Distributorship agreement, my lord. Distributorship agreement.
To whom?
With me. By the Netherlands company. Yes.
With you.
Yes.
Correct.
Yes.
Not the plaintiff here in the party on that.
No.
So,
my lord, kindly.
If the plaintiff is not a party to the agreement, how the agreement?
But it is not their contention in the AO that I'm not bound by the whatever understanding.
That's why kindly come to the 6A, page 7 of their affidavit. I deny any distributorship agreement was executed between the Flint Netherlands and the defendant.
Yes.
Correct. He has denied. As alleged at all, I deny the agreement was given any retrospective effect. So I deny that it was agreed between the parties that any dispute arising. So he is denying that. So you show me with regard to this agreement, the plaintiff is bound by that.
My lord, they have said that they denied. Obviously, they have to deny. But, my lord, they did not. My lord, my paragraphs, if your lordship, my lord, consider sub-paragraphs in paragraph 6 of my petition.
Correct.
My lord, I have elaborately stated. And, my lord, in one paragraph, they only denied.
Sir.
They only deny.
As per paragraph 6B, it is your admitted case, there is no direct agreement with the plaintiff.
Yes.
The agreement executed between you and the Finland company, this Netherlands company or foreign company, from that agreement he is bound by that.
Yes.
It is your case.
Yes.
Correct.
Yes.
If it is the case, how section 8 will applicable?
No, my case is also that the transaction, the purport transactions based on which this suit was filed by the plaintiff is covered under the distributorship agreement, and I do not have any individual contract with them. This is also a case here.
With them means with the
With the
plaintiff.
plaintiff, yes.
So
With the plaintiff.
then, if there is no individual contact with the plaintiff, how you can invoke the section 8?
But my lord, I am facing the recovery of money suit by them.
So you challenge that you contest the suit in the why you wanted the agreement, because see section 8, kindly go to the section 8.
Yes, my lord.
Give that arbitration.
My lord, if my lord, may I pause? May I seek one indulgence only, my lord? If I can show, if your lordship, my lord, if I can show your lordship that while preparation of the document and signing of the document, they were part of it.
Maybe. See.
They were part of it.
An agreement was entered between A and B.
Yes.
Agreement was entered into A and B. Correct. And for the execution of this agreement, C has come in picture and distributorship or whatever it has been done. Can you say that the C is also the part of the agreement? Is that the terms and condition of the arbitration agreement can be in the with the C?
My lord, this is exactly happened in
That's why I'm telling. Which one?
Exactly happened, my lord, in this.
That's what I'm telling. It is exactly. It is happening in every case, sir.
Yes.
Third party interest accrued.
Yes.
Third party involved in the agreement entered between two parties. Third parties entered, that been executed between with the one of the party with the third party, supply of the goods or whatever it may be. So only you have to set it how this agreement has not entered by the third party, how that agreement is bound by them.
My lord, this is what, my lord, I am trying to show your lordship, my lord. Your lordship, of course, my lord, will consider this issue, my lord. My lord, may I praise my application, my lord? Your lordship will consider this. Yes, this is the issue.
No, that's why I'm putting. This is the hurdle.
Yes, this hurdle I have to cross also, and your lordship has to consider this
Correct.
aspect, whether the plaintiff are bound by this contract
agreement. Because admittedly now it is admitted as per your submission as of now.
Yes.
There is no entered. There is no written contract between the plaintiff and the defendant. You and the plaintiff.
There are.
That's why that's why I'm asking since beginning. Where is the contract entered between you and the plaintiff?
I have to refer then my reply.
So
yes, my lord, may I yes reply to the yes. My lord, kindly start from page. I'm straight away, my lord, your lordship. I'm taking your lordship, my lord, with the documents. My lord, kindly come to page 12. Your lordship will see, my lord, at the middle, there is a email sent by Amar Sen.
Amar Sen, yes.
Yes, from Amar Sen. Kindly see the date. 9th August 2019.
Yes.
This Amar Sen is the representative of the plaintiff company.
Okay.
And my lord, kindly see it was sent to whom?
Who is Sachin Kumar?
Sachin Kumar, it is their representative.
Plaintiff group.
Yes.
Correct.
Now, my lord, Sujayda. I am Sujay Lodha, defendant. My email ID is there. Now, my lord, kindly, I will, yes, my lord. Now, kindly see what is written by Amar Sen to Sachin Kumar. Sachin, please advise. Amar Sen, divisional manager, sales, packaging, so and so. Amar Sen, mail is there. Now, my lord, kindly see. This is the response of my earlier mail that is appearing at page 13. My lord, kindly see. Sujay Lodha, my lord, writing to Amar Sen. My lord, that is dated 8 September 2019. Much prior to the transaction or suit. What I am writing, dear sir, with greeting. This is to inform you that we have not yet signed the signed copy of the agreement from your end. Request you to provide the same at the earliest. I have stated this. Now, my lord, kindly come to the page 14. They did not, after receiving this mail, they were kept silent, and I was also carrying my business. Now, what has happened? Kindly come to page 14. Your lordship at the middle will find this is email sent by Amar Sen. He is the representative of the plaintiff. 21st April 2020.
But now the problem is that now this document you have disclosed in the reply. This is not the case you have made out in the plan in your application. He
No,
has not dealt with.
my lord, kindly understand my
He has not
position.
dealt with.
My lord, I kindly understand. My lord, my lord, in my petition, I state I did not annex the whole trail mail. I annexed few emails there, where I said, look, in fact, I was the one who opposed the arbitration clause, stating that it should be in India, not outside. And you were the one. Here I'm directly pointing out to the plaintiff. You were insisted me. No, you have to accept because this is the global company and you have to abide by the terms set out by them. We cannot modify it. My lord, this is the part of the record. This was part of my application. I will show to your lordship. My lord. And my lord, my learned friend will not be in a position to deny that they were completely alien to the plaintiff company, or these officers were not acting as a representative capacity of the plaintiff. We cannot deny this. My lord,
Representative capacity acting, okay, whatever it may be. But how you can link that this agreement is bound?
kindly bear with me, my lord, 10 minutes, my lord. If I show, my lord, if I am able to show the whole communications,
No,
my lord,
if now you are going to this agreement, this document,
yes,
then he has to deal with that.
My lord,
I don't know. Subject to him is.
My lord, obviously, my lord.
I have gone through the reply, some of the documents. My stand remains the same as it is in my affidavit in opposition.
So you will not deal this.
But I can deal with this on affidavit. But my lord, for the time being, my lord, arguments can be advanced. My lord, I do not think, my lord, if my learned friend takes 10-15 minutes more time, my lord, I would require, my lord, half an hour to conclude.
Okay, continue.
My lord, if
yes. Huh? My lord, I am told, my lord, tomorrow office Friday, Saturday, Sunday, anyway, it was beyond time. My lord, kindly take the April sent 21st April 2020 sent by Amar Sen. My lord, what he is writing? He is writing to me.
Where? Page
my
number?
lord, at the page 14, my lord, at the middle.
21st April, yes.
Yes. My lord, he is writing to me. And kindly see the subject. Antwerp compliance issue, dealers without contract. Now I will show the trail mails. This mail was first sent to the plaintiff's company, the foreign entity, asking for submission of the agreement, distributorship agreement. Now, my lord, dear sir, he is writing to me, your agreement copy is not yet signed. Now, if you have internet connection and then using DocuSign, you can complete the same. Please confirm. It's most important.
Correct.
This is writing, plaintiff company is writing to me. Correct. Now, my lord, kindly turn the page. Come to page 15. Now, my lord, here you will find at the top one Sachin Kumar, Flint Group. He is sending email to Amar Sen.
Yes.
Both are officers of the plaintiff company. CC Sandeep Singh. Again, subject the same. Amar, did you get this agreement signed from SAS? Do you have the signed copy with you? If not, will SAS be able to sign this using DocuSign? He just needs internet connection to this. Now, my lord, kindly see at the bottom. Now, who is the person asking for this document? Kindly see, regard Sachin at the bottom, whose name is appearing from Veera Abramova something. My lord, he is also the, kindly see the email ID. All are Flint Group. He's the officer of the foreign company. Sachin Kumar. He is writing to Sachin Kumar, and who are the CC? Some George, Shreyarth, Michael Fien, Utpal Roy. Now, what is the subject? Dealers without contract. Hi Sachin, many thanks for your swift reply. I looked up in our files. The contract for SAS, that is the defendant, was sent on September 27, 2019 to Amar Sen. So there is an admission. If it's okay with you, we can send out the contract to be signed electronically through DocuSign. We would just need the names and emails of the signatories on the part of the SAS. But what had happened, I manually signed in 2019. They did not provide me a copy of it. I have shown the earlier mail of me, my lord, 2019, when I sought for a copy of this. They have misplaced the document. Plaintiff misplaced the document. When they did not, when they were not able to provide to their reporting company, they asked me to sign it digitally. Now, my lord, who is writing? The legal administrator of the Flint, Netherlands, to the Indian company, plaintiff. Now, my lord, kindly come to page 16. Here the 16, my lord, your lordship will see. Please find the response with the reference. Here again, at the top, your lordship will see there is an email dated 21st April 2020 at the top left by the foreign company. My lord, it was sent to the other foreign officers also, including the representative of the plaintiff, Utpal Roy. My lord, what he is saying, hello, Veera. Please find the response with reference to India distributors agents. First name was appearing as mine, SAS. INC process for SAS had got completed sometime in September 2019. But I don't find any email sharing the agreement with them for getting it signed. Last email I have received on this subject from so-and-so is appended below. Please help me with the agreement so that the same can be executed, so that the same can be closed. Now, my lord, this is the remarks made in respect of the defendant at the first SAS. Then there are other two distributors I am not concerned with. My lord, now this communication, my lord, was done by whom, my lord? Was done to whom? Sachin Kumar, Chief Financial Officer. This is a plaintiff representative. Now, my lord, again at the middle, from Utpal Roy, Flint Group. He is sending the mail to one Sandeep Singh, Flint Group. And CC was made Sachin Kumar. Compliance issue, subject, dealers without contract. Now, please respond tomorrow. This is the mail. Now, again, the representative of foreign company, my lord, is again on writing. These are trail mail, my lord. It's actually, it starts from 20th April, my lord. 20th April, my lord, the first email was sent by the foreign officer. Yes. Dear both, I hope you are well. Receiving our compliance active, we located 5 packaging dealers. My lord, this is important at the bottom. 5 packaging dealers, agents and distributors in APAC region that were approved before October 2019. Contracts were sent to the responsible relationship manager to procure e-signature of the dealer. See attached the dealers without contract packaging APAC. Now, my lord, there are 2 attachments at page 17. You will see. Yes. Kindly see the body of the mail. Unfortunately, we received no contracts for these dealers until today. At the top, my lord, page 17. These poses a serious danger to our compliance situation and is not audit proof. We ask you to kindly review the attached list. If we conduct business with listed dealers, provide us with the contract that was signed by the dealers by Wednesday, May 6th, 2020 at the latest. If we don't conduct business with the listed dealers any longer, let us know. We will have all corresponding dealer accounts blocked on SAP and or any other available ERP system to avoid non-compliant dealer business in future. Please let us have our feedback by Friday, April 24th, 2020 at the latest. In the list, you will find the names of the dealers as well as their type, agent and so and so. My lord, here the attachments, 2 attachments are there, my lord. Now, my lord, kindly, the attachment, my lord, I have annexed at page 18. This message has been forwarded. My lord, kindly see at the top, right side, 17/9/2019, right side at the top. Yes. My lord, forward Flint IOSU SAS. It is me. So, my lord, from this communication, in the body, hello Sachin. This is writing to the Netherlands officer to the Indian company. Hello, Sachin. The INC process for SAS has been finished and the whole documentation is in legal. The contract is being drafted, but due to limited number of legal counsels, you have to wait until next week. Now, my lord, again at the bottom, my lord, is this how, my lord, this attachment was made, my lord? I have annexed it. My lord, kindly see. Sachin Kumar, hello, so-and-so. Can you please share the update regarding SAS Industrial? SAS Industrial, that is email dated 13th September 2019. Now, my lord, again on 13th September 2019, they are writing it. Now, my lord, kindly come to page 19. Now, my lord, your lordship is seen the, as I stated, in 2019, I signed the contract, but it was somehow not forwarded to the foreign company by the plaintiff. Now, when they threatened to block all non-compliant distributor, because since they did not get the copy, your lordship has seen the email dated 20th April. They wrote to the plaintiff company and stated, if you do not forward, if you do not comply, or the distributorship or dealership agreement is not forwarded to us, if it doesn't reach to us by 6th of May, we will take penal actions and I will block their IDs. So this prompted them to start chasing me and asking me, your lordship has seen the subsequent correspondences starting straight away from the April 20. My lord, they have started sending me, no, you sign it through, you just need internet connection, you sign it digitally, it can be. My lord, kindly come to page 19. My lord, this is the email, my lord, at the middle, kindly find. I am writing it. Sujay Lodha, September 25th, April 2020. My lord, I am writing to some Mr. Arun Kumar Das, so and so. Now, my lord, what I am signature coordinator, so and so. My lord, this is April 20. Now, my lord, kindly come to page 20. My lord, kindly see the envelope activation at the bottom at page 19, my lord.
Yes.
Yes.
Page 19.
Yes, page 19 at the bottom. Your lordship will see.
Please sign the document. Print
Yes.
sign document.
Yes. And who is sending this message to me? Signature coordinator via DocuSign.
Yes.
DSE and so DocuSign. He is sending to me, asking on 23rd April 2020 to Sujay Lodha, sending the documents through the DocuSign envelope, and he provided an activation key. Now, my lord, kindly come to page 20.
Yes.
Signature coordinated sent you a document to review and signed. Now review the document. This was, because my lord, here what has happened, my lord, I cannot this application service, my lord, is activated for a limited time only. If I want to open it, I cannot open it. It is available only for the limited period. Now, my lord, so this was sent to me. Now, my lord, kindly come to page 21. My lord, kindly see at the middle. This is email dated 15th May 2020. My lord, I will request your lordship, my lord, to place the email exchange from, my lord, page 25, my lord. Rather 26, my lord, from page 26.
Yes.
Because these are trail mail, my lord. My lord, here your lordship will see again, my lord, there is another email dated 17th September 2019.
Yes.
Again, it has been recorded that.
That is your shown
Yes,
earlier.
yes, my lord. Kindly come to page 25. This was also shown to your lordship, my lord. Page 24 and 25.
Yes,
Yes.
document.
No, page 24, my lord. I did not. My lord, kindly see, there is another email, my lord, that is dated 20th April. Your lordship will see. No, this was also placed, my lord. My lord, kindly come to page 23. My lord, here your lordship will see the email dated 21st April 2024. My lord, I have also placed this email, my lord. Here at the bottom, my lord, there are 3 distributors, my lord. My lord, kindly come to straight away, my lord, come to page 21, my lord. Those mails where I have placed already. My lord, kindly come to email dated 15th May 2020. This is Amar Sen writing. What he is saying, dear Sujay ji, still not received signed copy from you. If you have any query, please get it cleared. You cannot hold it indefinitely. It's already delayed. Regards so and so. Now, my lord.
So, if he's telling that in 2020,
Yes.
then you are telling that 2019.
My lord, what does I mean? The agreement was signed twice. In 2019, it was signed manually. When the plaintiff representative brought the copy to me, and I manually signed it.
When?
In 2019. And in the email, they have acknowledged that the process was completed. But the plaintiff did not forward it to the Netherlands company.
Where is the case you made out? That case?
My lord, I was not aware of it.
So now
I have made out this case in the reply when I brought all the records because they denied.
With regard to the lost of document, lost of the original agreement signed manually is lost by him, and thereafter he has started making the correspondence. Where is that case you have made out?
Because, my lord, I have just shown your lordship, my lord, the email.
That I understand. That I understand.
Yes.
There was
They sought copy of the dealership agreement
That's why
with them.
I understand from the documents from the email which you have shown here.
Yes.
He has made several several emails from the foreign country as well as from him asking you to sign the document. If it's not possible, you sign the document in the e-document.
Yes, my lord.
Correct.
Yes.
That's correct.
Yes.
But now you have started your submission that there is an agreement in 2019.
Yes,
now you are relying upon page 21 wherein it is telling that you signed the agreement by 20.
No, my lord, I have not stated the date because the contract are same. It was signed twice. It's not that the dates were
Where is
different.
the case? See, whatever you are making out the case, making a submission before this court, where is the case made out in your either affidavit in opposition or in the affidavit in reply or in your application?
Yes, my lord.
Where is the case you made out?
Kindly.
It was signed and you lost, and thereafter he has.
My lord, I will show only 2-3 emails. Else the email chapters will be closed, my lord. My lord, kindly allow me to, my lord, to place, my lord, because the 15th May email and 30th May email, my lords, are important, my lord. My lord. My lord, I have placed email dated 15th May. My lord, kindly come to page 21 once.
21, I am there only.
Yes, yes.
15th May.
Yes.
Still not received the signed copy
Yes,
from you.
yes, yes.
So as per this email, there is no agreement until 15th
Yes, till
of
that
May.
period it was not
Till
there.
May
It was
2020,
not
there
there.
was no agreement.
Yes. Now, my lord, kindly come to page 22.
Yes.
Yes. Here again, my lord. My lord, kindly come to page 27. I placed those in that email, my lord. Kindly come to page 27.
Yes.
Your lordship will see, my lord. This is the DocuSign document. Now, my lord, kindly come to page 28. This is important, my lord. I wanted to place it. Page 28. My lord, on 15th May 2020, the defendant writing email to Amar Sen, another representative of the plaintiff, saying, "We disagree with a few points mentioned in the agreement and would like to modify them. Firstly, we would like to mention that the distributor agreement between Flint Group India Private Limited and SATS India. So first, what I wanted to have an agreement directly with the plaintiff and the defendant. Now,
firstly, we would like to mention that the distributor agreement be between the Plaintiff Group of India and SAS India.
Yes,
It is therefore means that the agreement shall be
I am
subject to
writing
the
this.
laws.
Yes.
Yes.
It
Then
therefore means that this agreement shall be subject to the laws of India only. So I am insisting it.
Correct.
Secondly, we are not. Secondly, we not being the exclusive distributor of Flint may purchase, sell, or resell competing.
competing
This is
products
different.
in any of the other
Now,
suppliers.
my lord, I have attached the distributor agreement in the email, my lord. There is a PDF attachment.
Yes.
Now, this is the attachment. It starts from page 29 to 42. I will come later. This is the attachment. Now, my lord, kindly come to page 43. Your lordship will see at the middle, 19th May, email dated. Amar Sen writing to me, plaintiff representative.
Yes.
To Sujay Lodha. And in CC, there were others officers. All the officers are the plaintiff representative. Now, my lord, what he is writing. Dear Sujayji, please refer below quote from our CFO, which is repetition that we discussed earlier and today also. What he is saying, all distributor agreements are being centrally signed by Flint through Flint Netherlands only, and all dealings will happen with India. This is the company policy with no option. And also please note, this is dealership agreement. We are run by Flint, which is a global footprint. So policy on appointing dealer to represent Flint, a global brand. Financial dealing will be with India, but as policy and standard is global. This has comes from our sale directives. So here there is a clear admission that they cannot override and they do not have any say on it because they are bound by the instruction of the Flint Netherlands. Now, my lord, I will show another mail from the arbitration clause was referred to, an exchange between the parties. My lord, I keep aside all the documents. I am through by this email only, my lord, in view of Section 7 of the Arbitration Act. My lord, kindly come to page 45.
Yes.
My lord, this is email dated 30th May 2020. I am writing this.
Yes.
To Amar Sen and other officers of plaintiff. Subject forward agreement. Dear sir, we refer to our email dated 15th May 2020 and your subsequent reply dated 19th May 2020. My lord, I have placed all these two emails, my lord.
Yes.
On the caption subject. Due to our past relationship with Flint, we are sending you the agreement with signature docu-sign. So here, my lord, I have informed that I have sent you. But we are still concerned on certain clauses in the agreement which are either irrelevant in the present state of business affairs between us or are legally inexecutable in its present form. Now, what are the conditions, my lord? I have referred, my lord, a few conditions, my lord. I'm straight away, your lord, I'm taking your lordship, my lord, the relevant thing, Article 12, page 46.
Yes.
We are confident that our business relation will not necessitate to resort to such mechanism. However, in an unforeseen situation, if any need arise to resolve any dispute between the parties, it would be prudent that the agreement be governed by the laws applicable to India and settle the disputes as per the Indian Arbitration and Conciliation Act, and place of arbitration may be preferred at Kolkata, since both the parties, the distributor as well as the Flint selling affiliate, so they are the Flint selling affiliate, are companies incorporated and registered in India and having registered office or place of business in Kolkata. This will not only save time but also substantial amount of cost for both the parties. We have considered our response dated. We have considered your response dated 19th May 2020 and understand that the company has certain standard policies which are being followed globally. For the said reason, we accept all other terms of the agreement except the ones stated above and request you to suitably modify the same in view of our long business association and ease of future business. Now, my lord, now kindly come to page 48. This email was not responded to them. Here, my lord, I have annexed the document. Your document has been completed, viewed completed document. I signed it and placed it to them, my lord. So, my lord, thereafter, my lord, and now, my lord.
Where? Page 48.
Yes, my lord, 48. Sorry, yes, 48.
Completed document signed.
Yes.
26.
Yes.
9/20/2019.
Yes.
Distributor agreement says India PDFs. Yes, then.
Now, my lord, I will show only one document, my lord. Though, my lord, in the opposition, my lord, they did not deny the nexus with the plaintiff and the Flint Netherlands and the Flint group of America. They did not dispute it. My lord, I will show, my lord, only one document. My lord, kindly come to page 71. Kindly see who are the promoters of the company. They are holding 80% of the shares of this company.
Yes.
Flint Inc. Mauritius Limited. And my lord, your lordship will see, my lord, I have also obtained copy, my lord. The company has, my lord, 30 lakh shares. Out of 30 lakh shares, my lord, 24 lakh 30,000 shares held by the foreign company. So 80% shares are with the foreign entity. Obviously, they are controlling and managing the company. My lord, these are, my lord, my humble submission, my lord. If your lordship, my lord, consider section 7 once, my lord. My lord, here, my lord, by way of an email, my lord, I believe, my lord, I am able to show that their arbitration clause was referred to. There, the arbitration clause was, at least, my lord, if I keep aside all issues, my lord, the existence of arbitration, my lord, in the contract, my lord, was admitted by the parties.
With whom?
With the plaintiff.
That is the problem. Yes. Let me see, hear you. Yes. 7.
My lord, may I refer to section 7, my lord? My lord, I will refer, my lord, 7(4)(a). I will rely upon, my lord.
7.
Yes, my lord, of course, my lord, there are conditions, my lord. The agreement has to be in writing. My lord, kindly see 7(4)(a). A document signed by the parties. B. An exchange of letters, telex, telegrams, or other means of telecommunications, including communications through electronic means, which provide a record of the agreement. My lord, this electronic means, my lord, was introduced after the amendment.
That's why that has been Supreme Court has justified that. That is not the agreement. This agreement can be treated as a continuation with the letters, communication, and email.
Yes,
here, that is not the case. Here, the question is that agreement signed by you and the foreign company. Correct. The plaintiff is the middleman.
Yes, my lord.
Is the middleman.
Yes.
What are the agreement entered between you? There was some conflict between you and the plaintiff, you and the foreign party. The agreement was not signed. Thereafter, there was a communication, but that agreement is not signed by the plaintiff with you. Now only the question is that agreement which you are referred to, the arbitration clause which you are telling that is admitted by the plaintiff, can be treated as admitted by the plaintiff or agreement
Or
of
whether
the
it is binding upon them or not.
That is the only question.
Yes, my lord.
Correct.
So that is the issue.
This B, an exchange of letter, telex, telegram, and other means to the telecommunication, including communication to the electronic, which provide the record of the agreement.
Yes.
So which provide the record of the agreement. So that's why if any agreement, in continuation to any agreement, there is any communication, there is any mail or whatever it is, that can be treated as in continuation. But here the question is that the main agreement, admittedly there is no signature, there is no signed agreement between you and the plaintiff. So only the by way of this communication can it be said that the plaintiff is bound by that agreement.
Subject to correction, my lord, it's already 3 o'clock, my lord. My lord, I will, for the time being, my lord, there are other fixed matter, and my learner friend, I also believe he also requires time to go through the reply, my lord. I will only say, my lord, so far, my lord, even for the sake of argument, if I keep it aside of the existence of the agreement, the email dated 30th May 2020, my lord, exchange between the official email ID of the representative of the plaintiff and me, my lord, establish that there is an parties agreed to resolve the dispute through arbitration, my lord. This is not denied by them, and they cannot deny this.
Okay.
That they cannot deny. And my lord, I have not placed the agreement, my lord. From the agreement, I will show that they have been defined in the contract. What will be their role? They have been addressed as a selling affiliate.
Okay, let us see on the next.
Yes, my lord. Yes.
Census and Supreme Court the plaintiff, census and Supreme Court the defendant. The defendant has filed affidavit in reply in connection with GA Com 4 of 2024. After serving the copy to the Learned Counsel.
My lord, I have also.
4
and 5 both.
4 and 5. Affidavit in reply in connection with GA4 and GA5. After serving the copy to the Learned Counsel for the plaintiff, let the same be kept with the record. Counsel for the defendant has argued at length in connection with GA4 of 20. You are argued at GA4?
Yes, yes.
4 of 2025. 2024, but due to paucity of time, hearing could not be completed. Let the matter appear on 28 February at 3 p.m. 28 February 2025 at 3 p.m.
But the interim order is expiring on 10th January. But that may be confirmed, Malad, in view of they have not used any opposition. That may be made absolute.
The interim order which and the counsel for the plaintiff submit the interim order passed earlier is going to be expired on 10th of January 2025. Accordingly, the interim order is extended till 28 February bola na? Till 4th of March 2025 or until further order, whichever is certain.
Well, Lordship will also give you a chance to use an affidavit to the reply. They have disclosed documents. If it is if required.
In the meantime, if the plaintiff intends to file rejoinder to the affidavit and reply filed by the in the meantime, the plaintiff intends to file rejoinder to the affidavit in reply filed by the defendants. The same may be filed after serving the copy to the Learned Counsel for the time.
Grateful. Grateful.
I'm so grateful, my lord.
Yes, next. PC Chandra.
It has changed. Now we are on the left side.
Book wala hai. In the pattern.
Yes, please, Your Lordship. So that copyright matter.
Yes.
Where I appear for the publisher, my lord.
Yes.
New Central. Defendant numbers 1, 2, and 1 and 2. 3 times. 3 times.
Yes.
May I just recapitulate for 2 minutes, my lord, what the matter is for my benefit, actually.
some time. Paresh Chandra Das, your lordship says, is admittedly the author of the books in question. Two books in question, Paresh Chandra Das was the author. He gave me publication rights. The rights which he gave me and the agreements by which he gave me right to publish expressly record that his wife is the copyright owner. During when the wife was alive, I was permitted to enter into a co-publication agreement during the COVID period, whereby I was permitted to have the books published by a third party. Co-publication agreement was for a limited duration. At the time of entering into the co-publication agreement, the consent which was given to me to enter into the co-publication agreement was by way of a separate written document, which permitted me to enter into a co-publication agreement, but said that you are entering into a co-publication, very good, but our agreement and your rights and obligations under that agreement will continue as they are. You will still be liable to pay me royalty. Neither the author, who's the petitioner number one, nor the copyright holder, who's his wife at that time, were parties to the co-publication agreement. The co-publication agreement was for a limited period of 3 years. On its expiry, the author and his sons, claiming to be owners of copyright, gave me notices that the co-publication agreement has expired, now you have no right to publish. To which my contention was that expiry of the co-publication agreement does not mean that my publication agreement, which is the parent agreement, has also expired. That still continues and has never been terminated till date. After that, they came in and then they gave the right to my competitor, who was the co-publisher whom I had introduced. They go and give the right to him directly. Now they come and file this suit. Author is the petitioner number one. He has two sons. Amitava Das, who's the second petitioner, the second son is not made party to the proceeding. Now the copyright holder is his wife, admittedly, from documents as well as pleadings. Yes. Wife has since passed away. There is no averment in the plaint as to how the right has been transferred, how the right to sue. So my first contention before your lordship, which I've already argued, was nothing in the plaint to show that they have a right to sue, because the right to sue for infringement of copyright rests only with the owner of the copyright. That is under the act. Nobody else can claim. How these plaintiffs became owner of the copyright, there is no averment. Number one. Now my second point, my lord, his argument is that the parent agreement has been novated by the subsequent co-publication agreement. That is his pleaded case. Now on that, he has shown your lordship an authority. Kindly just see your lordship will kindly take the co-publication agreement once as to why this cannot be a novation of the parent agreement. Kindly have the co-publication agreement once, please, my lord. Kindly see the co-publishing agreement, which is at page 30, please, my lord. To enter into the co-publishing.
Yes.
The co-publication agreement, your co-publishing agreement is at page 30, but kindly see once page 37 and 38, please, my lord, which are the consent letters which preceded the co-publication agreement.
Consent letter.
This is the consent letter.
Correct.
We do hereby give our consent to the new agreement between the publisher, New Central, that is me, and the co-publisher Katha Kahini in the following terms and conditions. So, my lord, this is only the co-publication agreement is only by consent of the owners, the copyright holder and the author. Arrangement must be between publisher and co-publisher to be settled by themselves, so that the author or the copyright holder or the author's heirs, in absence of the author or the copyright holder, can get 10% royalty. Now, my lord, kindly see, as per original agreement clause 10, 11 and 12. With NCBA, which is the defendant number one, my lord, New Central, for this book dated so-and-so and this book dated so-and-so, from the co-publication Katha Kahini with the effect from the date of the new agreement. That is all that is there. So the co-publisher will now pay directly to me, but in terms of the original agreement, 10%. New Central will pay the author's royalty for the above mentioned books to the copyright holder up to the date of the new agreement, within a week of this agreement. So as and when the new agreement, till that new agreement comes in, you will pay. And as the author is the basic copyright holder and he confers his copyright to his wife Shima Das, and as both are aged persons, the author or the copyright holder or author's heirs will have the right to take the decision in the matter of publication of the said books after the expiry of the period of this agreement, or it may be continued if the three parties are satisfied. So this agreement here is the new agreement between. Now this is the letter which entirely explains what is the condition. Yes, what is the condition. Now if your lordship sees the co-publishing agreement which is entered into with the permission of the author and the copyright holder, kindly take page 30 please, my lord. Here neither the author nor the copyright holder is party, and this agreement starts with, your lordship kindly see the first whereas. Whereas the publisher herein is holding the exclusive publishing and marketing rights of the following books throughout the world. So this agreement itself recognizes my pre-existing right, which cannot come into being without the earlier agreement being in existence.
Yes.
I would have understood his argument of novation if the owner or copyright holder would have been party to this agreement.
Yes.
And by this agreement, they would have given me the exclusive publishing and marketing right. But they do not. So the earlier agreement is very much alive and subsisting. This is right, if I may put it in simple terms, not a right of lease with a right to sublease. This is the right to sublease. The right of sublease cannot survive without the parent right of lease. And he says that by the right of sublease, your right to lease is gone. There is no novation here. And then kindly see the second whereas. Publisher has expressed its intention to give permission to the publisher to take over the entire publishing works. Then, so I am now permitting Katha and Kahini to take over the publication. And then your lordship sees the sixth whereas from the second last paragraph from the bottom of the page. Whereas the co-publisher at the request of the publisher has agreed to be engaged in the entire publishing program up to the stage of so-and-so upon the author and copyright holder's written consent. So this also makes it clear that this agreement is only in terms of that.
Yes.
So on the face of the document itself, this cannot be treated to be as a novation of the parent agreement. Now, kindly see the decision which the petitioner has relied upon.
As per your submission, this is not the novation.
This is not novation. And what is novation? Now I'll show you, lordship. Kindly permit me. But kindly see the petitioner's decision on novation, which the petitioner has relied on. Kindly see. Other case ta dekho. No, judgment. Their judgment on novation. And they have argued before your lordship novation, and that is also pleaded here in paragraphs 11 and 13 of the petition. Page 7, please.
This is of the judgment.
Yes.
What even novation?
Yes. Their case. Where is their case?
This is different.
Paragraph 11. The agreements dated so and so are determinable and I'm sorry, my lord.
Judgment dated?
I'm sorry, my lord. The petition.
You are referring?
The petition, my lord. Paragraph 11, please. Where is pleaded the case of novation?
Page?
Page 7 of the petition, please, my lord.
Yes.
Kindly see the second sentence in paragraph 11. The said agreements dated so and so have been novated by the agreement dated so and have lost their force. And then paragraph 13 also, he runs those three alternate cases, my lord, which he cannot. I'll show your lordship, my lord. Plaintiff cannot take alternate cases. Said license has expired by flux of time and or by operation of law. Said original agreements licenses have been novated and or superseded by the execution of the agreement dated so and so, in view whereof the license subsisting have been terminated. So this is his. Now kindly see, my lord, where does novation come in? Kindly see the Contract Act once, please, my lord. Now what is novation? Because his prima facie case is based on three. One, expired by flux of time. Second, novation. Third, terminated. First submission on this is he cannot raise inconsistent pleas. These are all inconsistent, mutually destructive. These cannot be raised, but I'll deal with each of them independently, my lord.
Yes.
Kindly see, my lord, now the novation, kindly have section 62 of the Contract Act once, please, my lord.
Contact.
Section 62 of the Contract Act, please, my lord. It is set out in paragraph 9 of this report itself. Your lordship kindly takes.
Paragraph 9.
Paragraph 9 of this judgment, my lord, 2000, volume 1, SCC 586.
Yes.
Section 62 of the Contract Act is set out. We may at this stage refer to the provisions of section 62 of the Contract Act. If the parties to a contract agree to substitute a new contract for it, or to rescind or alter it, the original contract need not be performed. This provision contains the principle of novation of a contract.
If the parties to the contract agree to
Substitute a new contract, or to rescind it, or alter it.
So parties to be
the same. So the consent letter is the agreement between
not
us.
by you.
It's not.
So that cannot be a novation.
That cannot be novation. And that principle is explained in paragraph 10, your lordship kindly sees. One of the essential requirements of novation, as contemplated by section 62, is that there should be complete substitution of a new contract in place of the old. This cannot be because the first recital of the co-publishing agreement records that I have the right.
So first you have to go by the first agreement.
Yes, you have to go by the first agreement. Without the first agreement, there cannot be a second agreement. It is in that situation that the original contract need not be performed. Substitution of a new contract in place of the old contract, which would have the effect of rescinding or completely altering the terms of the original contract, has to be by agreement between the parties. A substituted contract should rescind or alter or extinguish the previous contract. But if the terms of the two contracts are inconsistent and they cannot stand together, the subsequent contract cannot said to be substitution of the earlier contract. So, my lord, in the second co-publishing agreement, it neither rescinds, nor it alters, nor it extinguishes the previous contract. In fact, it relies on the previous contract.
Yes.
But since so much reliance is placed on novation, kindly permit me to trouble your lordship with one more decision. Chrysomatta there. 2018, volume 16, Supreme Court cases 117, please, my lord.
2018?
16, 16, SCC 117.
Volume 18?
Yes, please, my lord. No, 2000 here, 2018, volume 16. I'm sorry, my lord, it is 2018, year 18, volume 16.
Correct.
I'll give that to your decision, my lord. There's some problem with the copies. Kindly omit that for the time. Now, my lord, on my argument that there cannot be three different cases, the petitioner has cited one judgment. Kindly take that, my lord. Kindly have ওই জাজমেন্টটা দাও না ইনকনসিস্টেন্ট ক্লিয়ার উপরে হ্যাঁ এত সব জাজমেন্ট নিয়ে এসে সব মেস ওই জাজমেন্টটা দাও ইনকনসিস্টেন্ট প্লিজ Yes. Kindly have, my lord. This is 2003 one Maharashtra Law Journal, page 446. This was relied upon by the petitioner.
2003?
Yes.
Yes.
Kindly come to paragraph 4 of the decision. Kindly bear in mind who takes the inconsistent pleas in this case. Kindly come to paragraph 4.
Page 4, para 4.
Yes. I'm sorry, sir. Kindly take paragraph 3 once, please, my lord. Kindly see, take the second paragraph of paragraph 3. The respondents are plaintiffs.
Yes.
They filed the suit for declaration of title and possession of agricultural lands. They claim that the properties were owned by their grandfather, inherited by them through their uncle. Since father preceded uncle, uncle acted as karta. So this was the case of the plaintiff. Now kindly see defendant. Defendants approached with a plea that the uncle and eldest brother of plaintiff had agreed to sell the suit land in favor of defendant number 1. So first there's an agreement for sale. In the alternative, it is claimed that if the Isar Pauti, that is the agreement for sale, has not passed the title in favor of the defendants, they have become owners by adverse possession. So this was the alternate case which was set up. After conclusion of recording of evidence before the arguments could be opened, application so-and-so was filed by plaintiff requesting the court to direct defendants to elect one of the pleas, that is either their right to possession under section 53A of the Transfer of Property Act on the basis of agreement to sell, or claim their title on the basis of adverse possession. Now, my lord, all these case laws are cited. Then kindly come to paragraph 10. In the aforesaid 3 cases, respective high courts were not confronted with the issue if the court can direct a party either while leading its argument or while arguing its case to confine its evidence and argument to only one of the two inconsistent pleas. The observations that inconsistent pleas cannot survive are during the course of appreciation. When a party takes inconsistent pleas, ordinarily it may abandon or destroy one for success in another. In a given case, two conflicting and inconsistent pleas may even destroy both the pleas, cases, grounds of attack, or grounds of defense. In a given case, party may sacrifice one for the success in the alternate. This is a matter to be considered when the court enters the zone of appreciation of evidence and grant of relief in accordance with the case prescribed. There is nothing in the CPC or the Evidence Act that prevents a party from pleading alternate pleas, whether inconsistent, complementary, or inconsistent and conflicting. The court can prevent a party from adducing evidence in a case it arrives at a conclusion that evidence sought to be adduced is irrelevant, etc. But there is no provision so the plaintiff filed an application for the defendant to give up one plea. That the court said he could continue with the pleas till the time of trial. Now today when the plaintiff has come up with...
But paragraph 11...
Yes, please. Madam.
In order to supplement his argument that inconsistent plea is allowed to be taken and party can enjoy the relief that may be granted the court accepting either of the pleas.
Yes. So, then a plaintiff may rely upon different rights alternatively.
Correct.
And there is nothing in the court to prevent a party from making two or more inconsistent set of allegations and claiming relief thereunder in the alternative.
Correct.
It is in this matter which was defendant denied the contract, it was whole. So, my lord,
they have relied upon this.
Yes, they have relied upon this part, but this is at the stage of final hearing. Today, when a prima facie case is sought to be made out before you, that is the distinction. This judgment applies only at the case of final hearing. It is not at the interlocutory stage. That is why, my lord, I place before your lordship, my lord, paragraph 4. After recording of evidence before the arguments could be opened. Today, when he comes up with a prima facie case, what is his prima facie case? I ask myself, my lord. Today, by making these 3 inconsistent pleas, he himself casts a doubt on his prima facie case.
Yes.
Paragraph 11, which I'm sorry, my lord, I missed paragraph 11. Paragraph 11 is at the final hearing of the suit when the decree is made. Specific performance is declined. Money is, the defendant says it was given as a loan, so you repay the loan. In this matter, which was sued for specific performance of a contract, defendant denied the contract and pleaded that money is taken by him as a loan. It was held that the court could pass the decree for recovery of loan in favor of plaintiff in view of admission of defendant, although such case was inconsistent with the pleadings in the plaint. So the pleadings in the plaint were consistent. But this was an observation made by the Supreme Court. This is again at the final stage. Today at the prima facie stage, what is the case which the plaintiff wants your lordship to believe?
Which they are harping?
Which are they harping on? If they are harping on novation, it is not novation. So the fact that he relies on three alternatives goes to show that he has no prima facie case for grant of an injunction. He can rely on all three or select one or abandon the other two, but at the final stage.
So that is the paragraph 12.
Yes, that is a paragraph. So
Yes.
that is why, Malad, this judgment, in fact, goes to show that at the prima facie stage, this election of pleas itself is not there. Then your lordship kindly takes his next decision, which he relies on. Chiranji Lal versus Ramdas. Kindly take, this is 2011 SCC Online, Delhi 2352.
Yeah.
This was a case of license, my lord. License of an immovable property, which your lordship will find in paragraph 3. Yes. Your lordship has, my lord, 2011 SCC Online, Delhi 2352.
Yes.
Yes. Kindly see subparagraph 5 of paragraph 2 on the first page, my lord. Plaintiff has employed his employees or munim to use the suit premises as licensees till 1960. So there was a grant of license till 1960. Then kindly come to subparagraph 11, present suit was accordingly filed. Now, my lord, the issue here was, and this judgment is in response to my case that there is no termination notice. So my learned friend has argued that I am not required to give a termination notice because a termination note by filing of a suit itself is notice of termination.
Correct.
No dispute with this proposition. But here, my learned friend does not deal with my argument that when there's an express clause as to how an agreement has to be terminated, it has to be done in that manner or not at all. Kindly see, my lord, what he does. He has shown a judgment on license on which there is no dispute. But my agreement is coupled with an agreement that he shall not terminate without 1 year's notice, which this judgment does not address. Kindly have my opposition once, please, my lord. Page 43 of the opposition.
Of Amitabh Sen.
Yes, my lord. Amitabh Sen, my lord. Amitabh Sen, 23rd April 2024.
Yes. Paragraph.
Kindly have page 44, please, my lord.
Yes.
This is written by the author, signed by. It is clearly expressed here that the copyrights of your lordship kindly sees all the books. So this is an agreement encompassing all the books which this author has written, of which publication right has been given to me. All the books written by Paresh Chandra Das, who's the petitioner before your lordship, son of so-and-so, residing at so-and-so, and published by New Central Book Agency. So all books written by him, which he has entrusted me the publication rights, or Miss Seema Das, copyright holder, or his sons, as conferred to them in the letter of the author, and as the author and his wife are aged persons, the author or the copyright holder or the author's heirs, in respect of in the absence of the author or the copyright holder, will have the sole right in the matter of publication of the books authored by Paresh Chandra Das, if any confusion or discontentment arises at any time. However, the aforesaid person or persons must give at least 1 year's advance notice to the existing publisher. Now, the agreement, the judgment of the Delhi High Court, which my learned friend has shown your lordship, does not contain any such clause.
So, with the clause permit, the notice is required.
Then clause permits notice is required. Now, this document has been suppressed. They don't disclose this document in the petition. So, the purported notice of termination given by them and filing of this suit cannot be treated as 1 year's notice. On this, my lord, may I cite an authority, my lord, Supreme Court? Supreme Court on this. Notice, State of Bihar. State of Bihar. 2000 volume 8 SCC 560. Your Lordship has 2000. It was handed over earlier.
2000?
2000 volume 8 SCC 560.
No.
ওই কোডে দিয়েছি তাহলে এখানে তো থাকবে। তোমার সফট কপি আছে? Absurd this man is. Sorry, my lord. He's sitting there with a bunch of papers doing nothing. Kindly come to paragraph 2 of this decision, please, my lord. Kindly see clause 9 at the bottom of page 2, please, my lord.
Yes.
The consumer shall not be at liberty to determine this agreement before the expiration of 3 years from the date of commencement of supply of energy. The consumer may, now this is relevant, my lord, the consumer may determine this agreement at any time after the said period on giving to the board not less than 12 calendar months previous notice in writing in that behalf. So up to 3 years you cannot determine. After 3 years you have to give 1 year's notice. Now, my lord, kindly see, thus it can be seen where the Supreme Court notice after noticing the facts. Thus it is to be seen that even though no energy may not be consumed, minimum charges has to be paid. The agreement was to be for a period of 3 years and thereafter to continue from year to year until it was determined. Under clause 9, the consumer could not determine before the expiration of 3 years, but could determine after the expiry of 3 years on giving a 12 months previous notice in writing.
Yes.
Now, I'm going to kindly come to paragraph 10.
Yes.
We have set out above the letter dated 24th February 1975. As seen, there is no request for termination of the agreement as contemplated by clause 9 of the agreement. In fact, there is no request for termination at all. By this letter, all that the respondent is asking the appellants to do is to disconnect the supply. The appellants pursuant to this request has disconnected the supply, but this does not mean that the agreement should terminate it. The agreement would continue until it was determined by the parties. The only method of termination was clause 9 of the agreement. As admittedly, no notice in writing of 12 months was given, the agreement would terminate as per clause 9 after a period of 12 months after disconnection. Therefore, the agreement subsisted until so-and-so. As the agreement subsisted till this date, the appellants were entitled to claim the annual minimum charges for this date. High Court as seriously. So here, my lord, in my case is even better. There is no, this suit has been filed before expiry of 1 year. This suit is not maintainable. He has to first give me 1 year's notice that he intends to terminate. Then he has to terminate. Then he has to file a suit. Not having done that, the agreement till this date is valid and subsisting. Now, Malad, kindly take his next case, which is on expiry by efflux of time. His argument on expiry by efflux of time is expiry of the co-publication agreement, which in my respectful submission does not arise. Then he says the agreements have been terminated or withdrawn. Now kindly see the termination and withdrawal notices, please, my lord. Kindly come to the termination and withdrawal notices.
Page.
Page 40.
Yes.
Now the document at page 40 is only termination of the co-publication agreement. And this is from the author. This is for your information that the co-publishing agreement for the two books ends on 24th August 2023. Therefore, I do hereby terminate the publication, printing and sale of the above mentioned books with effect. This has also been sent to the co-publisher. The last paragraph, he says, it is hereby added that the author and the copyright holder will freshly decide about the publication of the aforementioned books from any publisher of their choice. And there is no dispute, my lord, that the co-publishing agreement has expired by flux of time, but that only restrains Katha and Kahini from publishing any further. Now, this letter also, your lordship sees, is only from the author, who is no longer the copyright holder. Copyright holder is the wife. Now, kindly see the next letter at page 41. This is sent by Abhijit Das, who is not party to the suit. Page 41, my lord. Abhijit Das has sent a notice when he's not party to the suit. So he's one of the other sons, I would presume, but he's not made party here. Now he's also asserting a right. Now kindly see, notice for termination as the agreement for co-publishing ends on such and such date. This is for your information that the co-publishing agreement between New Central and Katha or Kahini for publishing applied English grammar and composition so-and-so ends on 24th August 20. In the previous agreement dated 9th August 2012, it is stated in clause 17, in case the author wishes to terminate the agreement, he will inform the publisher in writing to that effect. The agreement will then stand cancelled. Now pausing here for a minute, my lord. Now, the agreement of 9th August 2012 with Abhijit Das refers to in this letter does not form the subject matter of this suit. Kindly see. It's not there. Kindly see. Paragraph 11 of his petition. There is no reference to an agreement of 9th August 2012. Kindly see paragraph 11. The agreements dated 15 June 2001 and 22nd April 2002. Abhijit Das refers to some other agreement.
Yes.
Similar, this letter refers to some other agreement. Now kindly see the last paragraph. Thus, the previous agreements dated 9th August 2012 and the co-publishing agreement dated 25th August become null and void. So this does not affect the agreements in question in the suit. The Lordship has seen the last paragraph. He refers to an agreement of 9th August 2012, which is not the subject matter of this suit. The subject matter of this suit are the agreements of 15 June 2001 and 22nd April 2002, which are mentioned in paragraph 4 also of the petition.
Yes.
Then, my lord, kindly see the third letter now at page 42. 3 different stands, so 3 different letters.
Yes.
Now, my lord, this letter is very interesting. Kindly come to page 43 once, please, my lord. This letter is issued by Paresh Chandra Das, who is undisputedly the author. At page 43, your lordship will see. And Amitava Das and Abhijit Das claiming to be copyright holders. Not a mention in the plaint how after the demise of the wife, the 2 sons became copyright holders. And anyway, my lord, the author does not claim to be copyright holder. Petitioner number 1 does not claim to be copyright holder. Now, my lord, kindly come to the letter once. Kindly see the subject. Termination of the co-publishing agreement and the previous agreements. The author and the copyright holder reserve the rights of publishing the books with any publishers. As you could not publish properly and pay the royalty for the books mentioned below in due time, you had approached the author of the books for co-publishing with Katha or Kahini. And the author agreed to the proposal on condition as stated in the letter dated 18 July, which your lordship has seen, that the author and the copyright holder will take the final decision in the matter of publication of the books after the expiry of the co-publication agreement, as per agreement for so-and-so for 3 years and for beginners for 2 years. It is nowhere stated in the co-publishing agreement that after the expiry of the co-publishing agreement, it will go back to the previous publisher. Now kindly see the line of argument. Rather, it may be mentioned once again that the author and or the copyright holders will take the final decision in the matter of publication of the aforesaid books at the expiry of the co-publishing agreement as per letter A annexed to the co-publishing agreement. It was clearly expressed in letter A signed by Paresh Chandra and Paresh Chandra, the author, Amitabh Sen, that is you, the director, and Devapraj Patra, author of Katha Kahini, and annexed to the co-publishing agreement dated so. Thus, the co-publishing agreement and the original agreement too are now not in force as per letter A annexed in the subsequent co-publishing agreement for dated so-and-so for 3 years only and expired on so-and-so. So now, my lord, the author contends that the original agreement also stands expired on the expiry of the co-publication agreement by that letter. That letter does not say so. This is his interpretation now.
Yes.
Now the author and the copyright holders, after the death of the author Seema Das's wife, the previous copyright holder. Now, kindly see this paragraph, very interesting. Now, the author, that is Paresh, and the copyright holders are Amitabh Das for applied English and composition for high schools, and Abhijit Das for beginners applied English grammar and composition. Now, I kindly take the trouble of coming to paragraph 2 of the petition once, please, my lord.
Paragraph 2.
2 of the petition.
Yes.
Now, going by the petitioner's own case and his own document, my lord, kindly see paragraph 2 with paragraph 42, that paragraph. Paragraph 2, the books in question are Applied English Grammar and Composition, Anglo-Bengali, and Beginners Applied English Grammar, Composition and Translation. Now, my lord, kindly see page 42. Now, the author, that is Paresh, he is author for both the books. And the copyright holders are Amitabh Das, who's petitioner number 2 before your lordship, for Applied English and Composition. So, which is the first book which is mentioned in paragraph 2. And Abhijit Das for Beginners Applied English Grammar and Composition. So, in their own documents shows that the first two, the petitioners to the suit have no right in the book in respect of Beginners Applied English Grammar and Composition. Because Abhijit Das is not party to the suit.
Yes. So, contrary to the paragraph 2.
Contrary to paragraph 2.
Yes.
Then my lord, kindly see. So, he cannot have any order in respect of Beginners Applied English Grammar and Composition on the face of his own document.
Correct.
Even if I assume what it says is to be correct. And the change of the name of the copyright holders was informed to you by the author's letter dated so-and-so, and it was received by you under seal and signature. This is not, my lord, how copyright is transmission on death. Then, my lord, kindly sees, the author so-and-so has served a notice to you by email and speed post on 18 July 2023, about a month ago, informing of the termination of this book. That is the letter at page 40, my lord, which is referring to publication with effect from so-and-so. Now, not only that, another notice was sent to you by Amitabh Das, the copyright holder, by speed post, terminating the publication of Applied Grammar and Composition. Abhijit Das, the copyright holder, again your lordship kindly sees, Abhijit Das, the copyright holder of English Grammar and Applied English Grammar and Composition, also served the notice to you by speed post stating so-and-so. That 9th August letter which I have shown you. But Abhijit Das is not party to the suit. So, in respect of the second book, this action doesn't survive on his own document. Now, my lord, kindly sees, and this termination is as per clause 17 of the original agreement dated 9th August 2012, whereby it is clearly stated, in case so-and-so. 9th August 2012 agreement is not the subject matter of this suit at all.
Yes.
And as for Beginners Applied English Grammar and Composition, letter A has been mentioned and annexed in the co-publishing agreement dated 25th August 2020. So, for one book, it is an agreement of 9th August 2012 and clause 17 therein, which has not seen the light of day. For the second book, it is that letter A, which I have shown your lordship, my lord, does not talk of termination. And after having such notices from the author and the copyright holder of the above mentioned books, You have not responded in writing till now. That is the expiry of so and so. Hence, the author and the copyright holders of the above mentioned books are now at liberty to take decision in the matter of publication and and make fresh agreement with any publisher of their choice. And at the same time, you are not authorized to publish, print, or sell the books henceforth. Now, this notice, my lord, riddled with all the defects that it has, is given on 25th August 2023. This suit is filed immediately thereafter. So this notice, my lord, even if I take this, assuming but not admitting this to be a valid notice, even then this suit could not have been filed before expiry of 1 year. Now, my lord, kindly take his next case which he runs.
How much time will it take?
He has cited 4 more decisions which I need to distinguish.
With other matters.
He has cited 4 more. These are 4 more.
Other,
No, 6 more in fact.
other matters.
I'm sorry, my lord. 6 more decisions I'll distinguish. Facts I'll not trouble your lordship with, my lord. I have placed the facts. Only his decisions I need.
Suffering for the plaintiff. Suffering for the defendant.
Next matter, I must indicate, my lord, possibly will the fixed matter 345. Mr. Ray is also there. But may not go on for long because of some fresh discoveries that has happened in the matter. So if my learned friends want to continue, they may, subject to hearing Mr. Ray and me.
I
Possibly
don't know,
will not
Manoj,
continue.
because it's a application for revocation of grant of letters of administration after assent.
Yes.
And now, my lord, this has been heard at length. I don't know what he's trying to bring
Because
under.
we
The
have
pleadings
now,
are complete.
because now you have found out a certified copy of a will, which is there, which was not available to us. We will take 2 or 3 days to take on an
3
application
times,
on that.
same submissions.
No, my lord, now
Before
we have
Justice
the
Patanaik,
copy the down now.
then, my lord, last time also,
Now we
that's
have
why
got the
after that,
certified copy
your
of the
lordship
will.
had said that, yes, that's why your lordship
But
fixed
I
at
am
345.
entitled to. Now that the certified copy, the will is which is completely suppressed, I believe we will get 2 or 3 days to take out this application, bringing this on record. So may not, but I'll pray for some time.
Yes.
But this matter can continue.
Then, my lord, kindly fixes a date for this one.
Yes,
Same will
that
be
your
accepted,
lordship,
my
that your lordship will do.
Item number?
Yes, for
Fixed at 345.
2, my lord.
Commercial item number 2. So appearing for the petitioner. You are appearing
for the petitioner, my lord, who has sought for revocation.
So you are applicant.
Yes, my lord.
Appearing for the applicant. So appearing for the executor. Police counsel for the applicant submit that he has got the certified copy of the will and requires some time to place the same on record by way of an application. In view of the submission made by the counsel for the applicant, the case is adjourned. Let the matter appear on 5th February at 3:45.
Very good. And let's hope that day, my lord, it finishes, my lord.
Yes.
This is.
Yes.
Well, may I also make this, my lord, if he can make the application and I'll bring my opposition at the same time, my lord, then that would be easier, my lord. Let that be understood, my lord.
Yes.
I am grateful to my learned friends for letting us continue. Now, my lord, to deal with this contention of mine, he comes up with 2004 3 SCC 178. Kindly have 2004 3 SCC 178.
(2004).
Yes, I cited.
Yes, my lord. He cited 2004.
Once I can give a compilation also.
What is the name?
My lord, it is India Umbrella Manufacturing Company versus Bhagavan Devi Agarwala.
Copy আছে একটা extra copy আছে থাকলে দিয়ে দাও।
দাও এটা করে দাও।
আছে copy?
সাইট করেছিলে তো এটা?
কেন করব না?
হ্যাঁ করেছিলে।
তো কপি পেয়েছে।
না জজ সাহেবের কাছে নেই।
No copy is not here.
I have only one copy which is
ঠিক আছে কপি আছে নিশ্চয়ই সাইট হয়েছে।
তোমার নামও লেখা আছে দেবনাথ ঘোষ।
দেবনাথ ঘোষ নামও লেখা আছে।
Yeah,
because I had argued last on August.
July. और
জজ
judgment
সাহেবের
fee
ফাইল
रखा
থেকে কি করে মিসপ্লেস হবে?
অন্যটা করো না এটা বাদ দিয়ে অন্যটা করো। এটা আমি দেখছি।
আরে পয়েন্টটা তো ডিল করতে হবে।
কপি বার করে দাও না জজ সাহেবকে, ঝামেলা চুকে যাক, ও সফট কপিতে পড়ুক।
আর কি আছে
সফট কপিটা বার করে দাও।
দেখিয়েছে
এটা
ফেলে দাও ফেলে দাও ফেলে দাও ওভার রুল
It's not here.
May I just give my soft copy without কিছু
আমাদের আরেকটা কপি আছে, দাও তাহলে এটা দিয়ে দিই জজ সাহেবকে।
আমার কাছে যা আছে সেগুলো পুরি সরি কর। তো কপি আছে।
She gives me a moment.
কি হবে আর নেই, এটা নিচে রাখবে আর নেই এটা। May I hand over mine? Kindly have. Well, this was in respect of a suit for eviction of a tenant. Kindly come to paragraph 2, please, my lord. I'm sorry, paragraph 1. Can you see paragraph 1?
Yes.
Paragraph 1, fourth or fifth line, my lord. Third line. The entire property, including the land and the building, standing thereon was owned by late Ladi Agarwalini. It was in possession of two tenants. On so and so, late Ladi Agarwalini made a gift of the suit property in favor of her two daughters, namely Bhagavan Devi and Buchi Devi. The tenants were informed. I'm not troubling much. So, my lord, if I would apply the facts to this case, copyright holder is the lady, the wife. The wife during her lifetime gifted it to two people. In our case, there's nothing. Here, the admitted position was that the devolution of title is recognized. There's no dispute about who the owners are. In our case, the first question is who's the owner of the copyright after the demise of the lady, the wife of Paresh. So now, my lord, Ladi Agarwalini was the owner, recorded owner. She gifted it to Bhagavan Devi and Buchi Devi. Now, my lord, paragraph 2. Both the co-owners, Bhagavan Devi and Buchi Devi, initiated partition proceedings. The facts are not disputed. Then Buchi Devi transferred the property in favor of three people who are the partners of Umbrella. Now, my lord, kindly come to paragraph 5. I'm sorry, paragraph 6. Kindly come to paragraph 6. Having heard the learned counsel of the parties, we are satisfied that the appeals are liable to be dismissed. It is well settled that one of the co-owners can file a suit for eviction of a tenant in the property generally owned by the co-owners. This principle is based on the doctrine of agency. One co-owner filing a suit for eviction against the tenant does so on his own behalf, in his own right, and as an agent of the co-owners. The consent of other co-owners is assumed as taken unless it is shown that the other co-owners were not agreeable to eject the tenant and the suit was filed in spite of their disagreement. In the present case, Lordship kindly sees, in the present case, the suit was filed by both the co-owners. So the suit was valid, it was filed by both. One of the co-owners cannot withdraw his consent midway the suit so as to prejudice the other co-owner. The suit once filed, the right of the parties stand crystallized on the date of the suit, and the entitlement of the co-owners to seek ejectment must be adjudged by reference to the date of institution of the suit. The only exception being when by virtue of a subsequent event the entitlement of the body of co-owners to eject the tenant comes to an end by act of parties or by operation of law. Buchi Devi had willingly joined with Bhagavan Devi in filing the suit. During the continuity of litigation, she parted with her share in the property. One out of the two tenants purchased her share. It seems that the tenancy is in the name of a partnership. Then it's not relevant, Malad. The facts are totally different. In our case, there's nothing to show how these two gentlemen who filed this, yes, come in the first place. By author who has divested his copyright in favor of his wife, he has no subsisting right.
Yeah.
How the son becomes owner of copyright, there is nothing. In this suit, the owners had filed the suit. I would have understood if the wife had filed the suit during her lifetime.
Yes.
Wife has not filed the suit. And Abhijit Das, who is supposed to be the copyright holder in respect of one book, is not even party to the suit. So there's no question of co-ownership here as far as Abhijit Das's second book is concerned. Abhijit Das is the sole owner of the second book. There's no question of co-ownership. So, my lord, judgment wholly, my lord, inapplicable in the facts of our case. Now, my lord, kindly take Penguin Books Limited.
Yes.
Penguin Books Limited, Delhi High Court, my lord. Kindly see paragraph 1. The appellants, Penguin Books, your lordship has that one?
Yes.
The appellants, Penguin Books Limited of England, original plaintiffs brought a suit for perpetual injunction against the respondents, Messrs. India Book Distributors of so-and-so, restraining them. Now, my lord, kindly see, restraining them from infringing Penguin's territorial copyright or license in 23 books, the subject matter of the suit. So, my lord, this was a dispute between two rival publishers. Two rival publishers, my lord, Penguin Books of London said we have the right to publish, and the other Indian agency said they have the right to publish. This was not an action between the copyright holder and the publisher. Now, my lord, kindly turn to paragraph 28. I'm sorry, paragraph 30 onwards.
Yes.
I'm sorry, 30 sets out what is section 53, then see 31. If copyright is to possess any value to its owner, it must be capable of enforcement, law in general are enforced. So, Malad, these are all on the law and then subject, Malad. Then kindly come to easement. All these arguments are distinguished, Malad, but the fact of the matter is totally different. Kindly come to paragraph 43 now, Malad, after he's come with all the law and the subject has been discussed. Applying these principles to the fact of this case, I find that the balance of convenience is in favor of Penguin. There is prima facie an infringement of an exclusive right. A continuation of repetition of infringement is threatened in future as well. In such circumstances, the injured owner of an exclusive right may demand that the state of affairs which is contrary to law be rectified. He can ask for injunction restraining the party threatening the infringement. India Books have recently set up their business after separating from so-and-so. Counsel for so-and-so, it is a publication so-and-so. This is controverted. This may, whether they are one on the same may be restrained if I hold that Penguins are entitled to. So, my lord, again, this is a right of Penguin which had an exclusive right to publish a book which is granting him. Then kindly see 44. As most infringements of copyright consist of a continuous process of successive infringing rights, such as importation of infringing copies, as in this case, the most important remedy, and in many cases the only effective one, is injunction. This is always in the discretion of the court, and the court has to weigh the possible damage to the plaintiff if the injunction is not granted against the possible damage to the defendant if it is granted. Thus, once the infringement and its continuance is proved, the plaintiff will usually be entitled to an injunction, but the injunction would not be granted. Kindly see this, would not be granted if the damages caused to the defendant by granting the injunction would be out of all proportion to the seriousness of the infringement or to the possible damage to the plaintiff. Now, my lord, kindly see. My 1 year period has not expired. He has already entered into an agreement with the defendant number 3. Defendant number 3 is publishing these books. Now kindly weigh the balance of convenience and irreparable injury. I, my lord, give an undertaking that I will maintain accounts of the books which I sell. He is entitled to royalty at 10%. If two books are, it is not that his book is going out of the market or that I am not publishing his book. That is not his case. That you are not publishing, I would have understood, he would have earned, he would have suffered irreparable injury if I had gone out of business, if I was incapable of publishing the books. I was still enjoying the agreement. I was not publishing, his books were not going into the market, he was not getting any royalty. I would have, that would have been case of
This is not correct, Millard. I have not got a royalty, Millard, from 2019 onwards. Not a
He
single
is
for
telling that it is not.
I have not
his
got.
case.
I have
That is
not
not on
got.
his petition.
Yeah,
Let him
there
bring
is
submissions from the bar.
I
That is
have
not
not
the
got
case of-
a single royalty from him. I have
So he
said
is telling that
so.
he has not made out a case.
That is what I'm saying. And Millard, your lordship has seen. Your lordship has seen the termination notices. When my learned friend makes these submissions from the bar, he should tell your lordship that this is a case of breach of contract, which entitles me to. Had I not paid him royalty, that would have been a breach of contract. He would have been entitled to terminate on that ground.
Yes.
Your lordship has seen the 3 letters on which he claims termination.
Yes.
Not one mention of this case which my learned friend wants to argue from the bar. The case which he has cited, in fact, supports my case. Kindly test it on principles of prima facie case. He has no prima facie case. He does not have right to sue. He runs 3 different cases to obtain an order of injunction.
Yes.
The agreement is valid and subsisting even today. Now, on balance of convenience and irreparable injury, what the Delhi High Court holds, what my learned friend relies on, injunction would not be granted if the damage caused to the defendant by granting the injunction would be out of all proportion to the seriousness of the infringement or to the possible damage to the plaintiff.
That is the law of the.
That test is not diluted even in a copyright action.
No.
So, my lord, here he has already entered into an agreement with somebody else. I will keep accounts of whatever I publish, and I will give him royalty as per my whatever accounts are there. He can check the accounts. Your lordship will direct me to furnish accounts. His books are being published also by Katha and Kahini. If I am today injuncted from publishing the books which I have been publishing for more than 20 years now, irreparable damage and injury will be caused to me because I have invested time and money in making these books. Now kindly see paragraph 45. In this case, the defendant who was alleged to be infringing was not publishing the books. He was importing the books from outside. Kindly see 45. Here is a case of indirect infringement, which the Indian distributors are committing by importation and sale of titles, of which the exclusive licensees are Penguin, so far as India is concerned. The ratio of this judgment, my lord, would have had any application if Katha and Kahini would have come up, the rival publisher.
He is not there.
He is not there. He is not sued me.
Okay.
On the contrary, when it comes to injunction against the author, my lord, it is entirely my case that balance of convenience, irreparable injury, and prima facie case all are in my favor at this stage. Kindly see 47 once, please, my lord, of this report. No such case is made out here. In actions for infringement of copyright, damages are often not an adequate remedy, since there is difficulty in both ascertaining and quantifying such damage as injury to the plaintiff's property, business, and goodwill. This applies to Penguin, who can justly complain of injury to their worldwide business and goodwill. Some of their titles in question are highly topical titles. Penguin is a household word in English-speaking countries. This is a measure of goodwill, taking into account the relative strength of each party's case as revealed by affidavit evidence adduced on the hearing of the application. I think this is an injunction as offers. So, my here he has not made out any such case which would tilt the balance of convenience in his favor and say damage is not an alternate remedy. Then, my lord, your lordship kindly sees the next decision which he relies on. What are the 2023 SCC Online Calcutta 2335. Lordship has that, my lord? RDB versus Z.
Yes.
In this case also, my lord, the injunction at the ad interim stage was declined. The injunction was not granted at the appeal, and this is on final hearing. This judgment is on final hearing of the application. Mr. Ghosh will correct me if I'm wrong. Yes. Now, my lord, kindly come to paragraph 7. What was the ground of termination? Kindly come to paragraph 7. In this background, the license agreement dated so-and-so was terminated on the ground of inter alia violation of clause 7. The respondent number 2 having sub-licensed the same without any prior intimation to the plaintiff, and that the respondent number 1 and unauthorizedly broadcast the films over the digital platform outside the territory of India, which is beyond the scope of the license agreement. So direct breach of the license agreement. Here no such breach is alleged. What is alleged is expiry by efflux of time, novation, termination.
Yes.
So this case, my lord, perhaps cannot come to the assistance of my learned friend at all. The facts are entirely different. And then kindly see the ratio of this decision, please, my lord. Paragraph 12, where the salient clauses of the agreement are noticed.
Yes.
Worldwide rights, internet rights are not included. Then paragraph 13, no foreign transmission. And then kindly see paragraph 16, what is the ratio? On what findings was the injunction granted, my lord? This was entirely on the facts of the case. Kindly see paragraph 16. Prima facie, the respondent number 2 has been unable to demonstrate that they were authorized to assign the entirety of the rights in any of the films along with the underlying works embodied therein under the agreement dated so-and-so. The contention of the respondent number 1 being a bona fide assignee is also unsubstantiated. A transfer by a person without title cannot give title to the transferee. The respondent number 2 could not have conveyed better title or rights which they possessed under the agreement dated so-and-so. For the aforesaid reasons, there's a breach of the agreement dated so-and-so, and the same stands lawfully terminated in terms of clause 9 thereof. This is entirely on facts. Doesn't lay down any law. It's an application of injunction is granted because there's a breach. And there is a lawful termination in terms of clause 9, which gives him a right of termination if there is a breach. There is no case of breach made out in this petition at all. There is no case of breach made out. Nor is there any case of, there's no right of termination.
Yes, next.
Now, my lord, kindly see 1997 SCC Online Bombay 338. This was a case of passing off of a trademark. Kindly see paragraph 3.
Yes.
This notice, kindly see paragraph 3. This notice of motion has been taken out for an order of injunction restraining the defendants from infringing the plaintiff's trademark described in paragraph 1 of the plaint and passing off the defendant's products and goods as the products and goods of the plaintiff. It is also prayed that pending the hearing and the final disposal of the suit, the defendants cannot be directed to be delivered up and tensions. Similar the facts here, matter is relating to publication right, whether that right has expired by efflux of time or not. Then kindly see the paragraph which he relies upon. These considers the provisions of the Trademark Act. Now, my lord, kindly come to paragraph, I'm sorry, my lord, this does not have paragraphs. Paragraph 22, I'm sorry. Paragraph 22 at page 19, continuation. Plaintiff is the, admittedly, plaintiff is the owner of a registered trademark. Kindly see, my lord, about 10 lines from the bottom, towards the right-hand side. After your lordship sees paragraph 12, sentence beginning admittedly.
Paragraph 12.
I'm sorry, my lord, page 19, page number is on the right-hand, left-hand side top. Then there's a break there which says page 373.
Correct.
Then kindly come about 10 lines after that. Towards the center of the page, your lordship will find paragraph 12 written there.
Yes.
Then kindly see the sentence beginning admittedly.
Correct.
This is the first issue before your lordship, my lord. Admittedly, plaintiff is the owner of the registered trademark. There is no such admission in this case. He has failed to make out his right to sue as owner of copyright. The user agreement has been terminated with effect from 9 September 93. Even otherwise, the agreement was to come to an end by efflux of time on such and such date. So it was terminated prior to expiry. In our case, there's no termination which is valid in the eyes of law. In our case, there's no expiry on 13th. The defendants are continuing to infringe the trademark of the plaintiff against the provisions of the Act. This is the Trademark Act which is being referred to. In such circumstances, the equity, if any, would have to yield to the statutory provisions.
Yeah.
No unusual circumstances, etc., my lord. So here, the admitted fact was that the person who was suing was the owner of the trademark. The admitted fact was that there was a valid termination in eyes of law. The admitted fact was that the agreement expired. In all three, in our cases, does not arise. And moreover, this is a case under the Trademark Act. Section 10, my lord, I don't need to trouble your lordship with, my lord. He can file the subsequent suit. Yes. Now, my lord, one more decision which is relied upon is Section 10. He can maintain the suit, my lord, provided he has the right to sue. Now, my lord, the last decision which he has relied on. Copy nahi. Handover ko judge sahab ke diye cho.
Which one?
Justice judgment.
Justice?
Justice Gupta's judgment, my lord, I relied upon, my lord, on the same agreement, my lord, he concluded.
20, I have my copy, my lord. 2014 SCC Online, Calcutta 18353.
Yes.
Your lordship has
the
that.
copy.
Petitioner देखिए just Jones.
Petitioner
देखिए. Now your lordship kindly comes to.
Delhi division
आर की देखिए. No, Davis नहीं खींचो. It are the Strolls. आर नहीं. देखिए छिड़े. This has been overruled subsequently. Anyway. Now my lord kindly come to 2014 SCC Online Calcutta 18353. Kindly come to paragraph facts which are noticed in paragraph 2. The plaintiffs, your lordship has that, my lord. Plaintiffs instituted the suit alleging that late so-and-so was the author of books on gynecology and obstetrics. The author assigned the publishing rights by an agreement dated 7th November 81. The books have acquired international fame. The author died in the year 1995. It is alleged that by virtue of the said agreement, though the copyright belongs to the author, but the right of publication belongs absolutely to the plaintiffs. After the death of the author, the amount of royalty was paid to his heirs. After the death of the widow, the amount of royalty has been continuously paid to the daughter. The daughter is alleged to have raised unreasonable demands which the plaintiffs were not liable to meet. The agreement dated so-and-so, in derogation of the rights of the plaintiff to publish the books perpetually, was purportedly terminated by a letter dated so-and-so. Plaintiffs replied, it is pointing out that the alleged termination was illegal, unsustainable. It was further alleged that in violation of the agreement dated so-and-so, the books were permitted to be published by the sole heir of the author and her husband, who was for some time admitted by the defendant number 3, JP Brothers. Now, my lord, these are the admitted facts. Now, my lord, nowhere in this case was this 1 year notice period involved of valid termination, number one. Second, there was no dispute about the right to sue.
Yeah.
That was not in question.
Yeah.
Then, my lord, kindly see. Then the suit was filed, injunction was declined. Then in this, kindly come to the ratio of the decision straight away. Kindly come to page 4, please, of the report. We have considered, your lordship has it? We have considered the submissions advanced by the learned advocates appearing for the parties. The principal question of determination, according to us, is whether on consideration of the agreement dated so-and-so, it can be held that the right to publish the books was granted to the plaintiff perpetually. This is the principal question. Thus, the suit is based on the aforesaid assertion. It is on the aforesaid basis that all the claims for declaration and perpetual injunction have been put forward in the plain. Now pausing here for a minute, my lord. In this suit, the case or the publisher came to court seeking an injunction. In our case, in the case before your lordship, my lord, it is the purported copyright holder who claims to seek an injunction. The prima facie case in both these suits are different. The prima facie case here is for him to establish his case of breach of copyright. Here the case was different. Here if I may put the boot was on my foot, that is the publisher's foot, to prove a case of perpetual injunction because he was seeking the copyright. Now, kindly come to paragraph 4. The mere absence of a termination clause cannot lead to the inference that the contract is perpetual. On the contrary, the absence of termination clause, together with absence of any stipulation as regards duration thereof, would lead to the conclusion that the contract is terminable at will by either party. Now, I'm going to contrast this with the facts of our case. It says can be terminated after 1 year's notice. So, a decision flows from the fact situation. Correct. The submission that there has been a perpetual assignment or partial assignment of the right to publish the books, according to us, is fallacious. It is true that when a right to publish is granted, there is an assignment. But that assignment is coterminous with the agreement. The right to publish cannot exist independently of the agreement. So now, Malad, the test is from a learned friend to establish before your lordship what is the terminus of the agreement. The division bench points out 2 terminus dates. There is a termination of the agreement. There is a termination of the right to publish. Yes. My learned friend is not able to show your lordship even one date, which is the date of termination of the agreement. The right to publish cannot exist independently of that agreement. Then the decision cited by the plaintiff, I am not troubling your lordship with, kindly come to the next page. Assignment or partial assignment has to be implied, according to us, in order to give business efficacy to the agreement between the author and the publisher. But the assignment or partial assignment, if any, is coterminous with the agreement unless the subject matter of assignment is the copyright itself, and such assignment is absolute in nature. Any other interpretation shall render the ownership of the copyright meaningless. Publication is an incident of the copyright and cannot exist in isolation. When the copyright is admittedly vested in the author, the right to publish is also vested in him, except for such period which may have been granted by him. The grant in this case is evidenced by the agreement, which is terminable by will and has been terminated. So this was on the facts of that case. Termination is valid. There's no challenge to termination. The court finds that the grant is terminable at will and has been terminated. Then lordship kindly sees the next paragraph. There are some more facts which need to be noticed. From the letter dated so-and-so, it appears that more than a sum of 2 crores were outstanding on account of royalty, which the plaintiff has failed and neglected to pay to the defendant number 1. Nothing on our case, my lord. The fact that a sum of rupees 2 crores was outstanding has been admitted by the plaintiffs in their letter, wherein it is alleged that as per the verbal commitment, 50% of 2 crores shall be paid so-and-so. It appears that after receipt of the letter, the plaintiffs nominal kindly issued a check of rupees 2.5 lakhs on 20th October. And all these checks, all the aforesaid checks were dishonored upon presentation for payment. From the memo issued by the bank, it appears that the grounds for dishonor of the check was payment stopped by the drawer. Plaintiffs by their letter appear to have issued a check of 7.5 lakhs in lieu of the dishonored checks, requested the defendants to resolve the matter amicably. The defendants by the letter informed the plaintiff that the former chose to stick to their decision to terminate. It is on such an the books were published by defendant number 3, presumably pursuant to a fresh publication entered. From the aforesaid discussion, it is clear that the plaintiffs have not been able to demonstrate that they have any prima facie case in respect whereof an order of injunction could not have been granted. So in the facts of that particular case, where there was no dispute about title to sue, no dispute about termination, no dispute about plaintiff's breach, most important. Because one whole, your lordship sees, this paragraph about non-payment is something which has weighed with the division bench. A party in breach cannot seek an injunction. That is settled law, my lord. Yes. And that is what has weighed with the division bench, that they have not been able to make out any prima facie case. So this is again on the facts of the particular case. Division bench, Delhi.
Delhi Division Bench 2000 DRJ.
Your Lordship has
Rajasthan Breweries.
Rajasthan Breweries is two breweries, my lord. This has been, there's a recent division bench judgment of the Delhi High Court. I'm not carrying it, my lord. I'll file it on the next day, and he can, yes.
Any date, Lordship?
Any tomorrow, day after, any date, my lord. I'll just cite that one decision and close. আরে 5 মিনিট লাগবে, ছেড়ে দাও না, শেষ করে দাও।
There are another two.
My lord, my report
1998 volume 5.
I'll make a note, please, man.
Indian Bank versus Maharashtra Cooperative
Section 10, my lord, he has not
I am
filed
not
it.
pressing that.
You're
that.
not pressing.
Pressing that, he has said so.
I'm not pressing.
And another is, that is print copy of the judgment.
Max Charles.
Max Charles.
That, my lord, he says he has not argued, my lord, because of city civil court suit, there should not be an injunction.
That is a Supreme Court, Max Charles. No,
Max
that also.
Charles.
That also he has not said.
That also I'm not troubling much.
Only one copy.
One
দিয়েছো তো?
কোনটা?
Which one?
এটা তুমি সাইট করলে
No,
আমার
that
iPad থেকে কপি দিয়েছো তো?
Which one?
That I've handed over. The one which he has cited, but your Lordship didn't have a copy, I've handed over.
And I've given my iPad to him.
Which I have returned. I can keep it. Your Lordship can keep my copy, I'll keep his iPad. I'm happy.
Without any controversy, I will exhibit that.
Yes, your Lordship will accept. Well, I've more or less concluded. I'll take not more than 5 minutes on the next day.
Census and appearing for the plaintiff, census and
I'll be like immediately take
Police counsel for the defendant has argued at length in connection with GA1 of 2023. 3. Full stop. Due to paucity of time, argument could not be completed. क्या होगा date?
ठीक है ना, तू ही बोल ना date.
Any date, Lordship gives me.
Any date.
Friday.
Friday, I mean, any date other than 9th. Any day other than 9th, please.
9th of?
9th of this month. 9th of any day other than 9th of this month.
So without time, I am fixing let time from
Any time fixes, your Lordship. I will not take more than 5 minutes. Mr. Ghosh is always ready.
No, I am not ready at all like him.
এখন তো বললো করবে। তো বললে শেষ করে দেবে।
What time?
Any date, Lordship's commercial matters, Miller. Lordship has very not much matters. Lordship can keep it on Monday or Tuesday, Miller, next week.
Let the matter appear on 14th.
Please, man.
14th?
Yes, man.
14th is part heard.
14th. Yes, man.
Under the heading adjourn motion.
Lordship doesn't have, if there is problem, Miller, I'll... No.
No, there is not much commercial matters.
Not much.
I am there, man. Grateful, man.
Tuesday, ঠিক আছে করে দেবো ম্যাটার ছাড়ো না grateful
Yes, any interim order? No.
No. There's no interim order. He said Millard ad interim twice sort of final judgment. Millard he stopped Millard the ad interim order. That